And leave.
Yes.
My lord, on 9th of February 2023, your lordship directed the respondent number 7 and 8 to take steps in the matter since, my lord, they were they have filed a report before the another bench, my lord. They were supposed to hand over me the copy. Your lordship also directed them to hand over the copy, but ultimately they said that they did not file any copy. So your lordship directed
That
them
was
to
a
take.
division bench order.
Yes. Now, my lord, till date, in 9th February till today, they did not take any step. Now, let it appear, my lord, before your lordship, my lord. Either to be
Not in the list.
No, not in the list, my lord. My lord, to be mentioned, my lord, so that I can sub before sub.
To be mentioned, Rahman.
My lord.
Obliged to your lord.
My lord, may I permit to mention item number 81 of today's list? I am paying for upgradation, my lord, because the operation of the sand quarry of the petitioner has been stopped.
Today's list will not be upgraded, sir. I'm sorry. I'll wait for your turn. I'll take
No, it is going down, my lord. It is going down, my lord. Yesterday.
May I have your lordship's kind leave to mention item number 237 of your lordship's monthly list, my lord. What has happened, my lord, district magistrate's order is under challenge. The district magistrate's order was passed under a direction of your lordship, my lord, under the State Highway Act, my lord, for demolition of a particular structure. Now, since that is under challenge, that is not being demolished, taking advantage of the situation, the petitioners herein are constructing more buildings on that particular land itself, my lord, if it can be taken up.
My lord, may I permitted to mention for upgradation matter, the petitioner has filed a writ petition for praying the direction upon the landlord collector issuing the land loser certificate in favor of petitioner, which the member has been lost.
May I permitted to mention the matter common list, item number 452 and 453. On the earlier, the same identical order was passed. You will say on the submission of me that there was a prayer for exemption of royalty as there is no privity contract between the petitioner and the estate. And your lordship was pleased to direct me to withdraw the petition.
Give the numbers.
Yes, sir.
May I permitted to mention, your lordship, the matter item number 1013 and item number 1014 of monthly list of July, your lordship. Both of this matter has been came off under heading in hearing, your lordship. Wrongly came up. It will be under heading application with subject to lordship correction, your lordship.
Application
Application.
or motion?
Lordship,
Motion or application?
application, your lordship.
So applications are pending in these matters.
No, lordship. The hearing has been done, your lordship. Part heard has been done, by your lordship, and after that, a short hearing will be done, your lordship, and it will be come to application. We prayed for early hearing application, lordship.
The hearing application need not be heard. It will be heard as
Lordship, it has been came up under heading wrongly in hearing. Hearing.
It's a hearing matter. You say it has been
No,
heard.
your lordship. I filed application for early hearing, your lordship.
The numbers are checked. Didi, ekটু দেখে নেবেন?
May I permitted to mention?
Yes, your lordship. This is an application, your lordship.
Consider করার দরকার নেই। নাম্বারটা নিয়ে একটু দেখে
Grateful, lordship. This is an application. I filed an application.
for early hearing that will not be considered early.
No, lordship, it's an application, lordship. For the prayer is that we have the state government has accept the compensation. We prayed for a compensation that my land has been acquired by the state government, lordship. They accept my compensation, but the problem is it's not decided
For in the application, what is your prayer in the application?
for early hearing, lordship.
Not necessary to be considered.
Lordship, kindly, lordship, my client is suffering since 2022 March, your lordship. The last date was, lordship, the last date was 3 March 2022, your lordship.
Supplementary to include. Hearing matter supplementary.
May I permitted to mention to my lord's grant leave to file a review application on last occasion your because on last occasion, my lord, a review application has been filed and your lordship has given liberty, my lord. And on
So why are you seeking leave? File it.
because my lord, the computer section is not accepting because without the certified copy. Because on last occasion I filed it.
Accepted without certified copy.
Because
Collect the certified copy and file.
My lord, on last occasion I filed the review application, but your lordship has given liberty because the format was not correct. On that occasion, my lord, but this is the order passed by your
You have
lordship.
to take back the certified copy and file afresh. That is the rule.
Because my lord, the department is not returning back because that has already been annexed with the earlier review.
Asked to return, taking back the certified copy?
Yes, my lord, we have asked for, but
It's court.
my
The
lord,
court has to give you permission. Then you withdraw.
but that is with the earlier review application, my lord.
So you should have asked for return for taking back the certified copy, for filing it with the present review application.
Because this review application is in connection with an contempt application, my lord.
Maybe.
The contempt application filed before your lordship,
You are not
thereafter
able to
you
file this because you don't have the certified copy. Isn't it?
Yes,
Certified
ma'am.
copy is already lying in this court in
Yes, my
connection
lord.
with the earlier review application.
Yes, that
It
is
has been
already
withdrawn.
with the file of my.
When you have withdrawn the review application, you should have asked for taking back the certified.
That
copy
has not
also.
been withdrawn, that has been disposed of. That has been dismissed as withdrawn. Yes, my lord.
Yes,
Yes, my lord.
otherwise you wouldn't have had the liberty.
Yes, my lord.
File an application for taking back the certified copy.
Because my lord, the next date is on 26 July, my lord.
Maybe
Yes.
you can seek adjournment.
Not may I be permitted to mention, my lord.
Take back the certified copy and file. I cannot grant you leave without certified copy.
With your lordship's kind leave lordship mentioning one matter. My lord, this is a senior.
Continue.
No, my lord, he is a senior, my lord.
Lord, may I be permitted to mention one land motion, my lord, new motion. It was appearing on 28th June before your lordship in the supplementary list as item number 14. Then your lordship's court did not sit for a few days. Now, my lord, it has gone to the combined list as item number 792. My lord, I am
Give the number.
With your lordships kindly mentioning this matter lordship, this is a matter lordship. The matter was once released by Justice Rajashekar Manta, warrant of determination lordship. And the matter is falling under the determination of your lordships.
Land
Yes, lordship.
land matter.
Yes, lordship. Lordship, the matter was in the motion stage, lordship.
It's not appearing at all.
No, lordship. I previously also mentioned and your lordship allowed, but the matter is not appearing. If lordship may kindly give some precedence because this is 2022 matter, lordship.
May I be?
Appearing, no?
File আমি আনানোর ব্যবস্থা করছি। If
File
আপনার
has not
requisition টা
come.
পাঠান।
Yes.
If a requisition has been sent, then lordship, I will take initiation.
May I have
Okay,
your
lordship,
lordship's
I will
leave to
take-
mention,
I will take the initiation. Grateful lordship.
may I have your lordship's
It is
leave to
available.
mention a matter, my lord. This is a matter, my WPA 13659. This is filed sometimes in the month of June, my lord, against the order challenging the order of DM, my lord. This is a disputed land in Salt Lake, my lord. We have filed an application, read petition before your lordship, and pursuant to his direction, the learned DM Barashat had disposed of the matter, my lord. Now the issue is, we have filed a read petition. The state authorities are issuing a tender for giving that land to some other persons, my lord. So until this application is heard out by your lordship, the read petition will stand infructuous.
Give the number. Give the number.
Well, it is running 101 in the month supplementary, 105 in the monthly supplementary list. Well, my lord, kindly upgrade this matter and keep some importance, my lord.
Upgradation of supplementary list is difficult. Let us see.
My
May I
lord will
be-
kindly, in that even if my lord pleases, my kindly fix a date and time, my lord will come, and
It is running in the list.
it is running in the list because it's getting down day by day.
Let me see. Let's wait for some.
May I-
My lord will kindly consider, my lord.
May I be permitted to mention one matter? This is appearing in the monthly list of July as item number 786. The petitioners
Obliged.
wherein they have purchased a property and the respondent authorities on the basis of a purported notification which was published in the year 1983, they are trying to take physical possession of the property, your lordship. Kindly, it's appearing in the monthly list. Kindly fixes the date, your lordship.
Give the number.
Lord, seeking,
Gratefully, lordship.
Lord, seeking your lordship's please, Lord, mention a matter. Lord, this is appearing at serial number 999 in the combined monthly list. Lord, in this matter, the petitioner is the owner of 7 plots of land. Lord, subsequently, land acquisition proceedings were initiated and compensation was awarded, but my lord, not to me, to some other persons. So, my lord, I was humbly praying, my lord, that this matter could be taken up and heard anytime next week. Lord, it's appearing at 999 in the monthly list.
It's at the motion stage
My lord, for hearing, under for hearing.
for hearing.
Yes, my lord. My lord, pleadings are complete. The last order.
Complete
Yes, my lord. My lord, the last, I have the last order, my lord.
hearing matter.
Madam, may I permit
It will include.
Oblige, my lord.
But may permit to mention, my lord, the allotment of land was unilaterally terminated, my lord. My lord, the affidavit of exchange completed, my lord. But in the meantime, my lord, but that is in the month list, my lord, the matter is running in the month list as under the heading hearing, my lord. But in the recent period, my lord, the state, my lord, issued a notification for regularization of all these, my lord. I have brought it to record by an application, my lord. But that application, my lord, kindly keep it under the heading application.
What is the number?
Item number 978 of the combined month list of July.
You're asking for a hearing of an application, isn't it?
Application, my lord.
You have the number of the application?
Number one, my lord, can
Can
one.
one,
I have served the copy, my lord, and in
application enough. Can one the application enough.
My lord, may I permit a mentioning for upgradation, my lord, may I upgrade this matter, my lord, but till that this matter is not appearing.
Which matter?
My lord, monthly list of item number 801, my
What
lord.
is your urgency, madam?
My lord, my senior is mentioned this matter for upgradation.
So urgency is that your senior mentioned it. That is your urgency. You should be prepared with the brief before you come before a court, isn't it?
Yes, ma'am.
Do your homework and come tomorrow. Call the days list, please.
For judgment. 24898, Mohammed
Item 1.
Lord, I am for the writ petition.
Your
I am for the petitioner.
state, no one. I'm sorry you have to go before the appellate forum. Since the respondents allege that tax was imposed upon the petitioner for violation of West Bengal Motor Vehicles Tax Act 1979 and West Bengal Additional Tax and One-Time Tax on Motor Vehicles Act 1989, the remedy of the petitioner lies under Section 9 of the Act of 1979 and Section 22 of the Act of 1989. Also, the issues involve complicated questions of fact, which cannot be dealt with by this court in exercising jurisdiction under Article 226 of the Constitution of India. In view of the above, without going into the merits of the case, the writ petition is disposed of with liberty to the petitioner to approach the appellate forum for redressal of his grievance. In the event the petitioner files statutory appeal within 15 days from date, the appellate forum shall deal with the appeal on merits without dismissing the same on the ground of limitation. Item 2. Who is appearing?
No what?
Item 2.
Lost,
You're appearing.
lost in the meantime.
Yes, why
Milord,
would we
by
do
an
that?
order of Milord, 13th of June 2023, which is
Yes.
at page 11, Milord, Lordship directed the Eastern Coalfields to consider the representation on 7th March 20, file dated 7th March 2023 within the period of 6 weeks, 3 weeks from the date of the said order. Milord, it's an old record. I have to give him compensation, Milord, the writ petitioner. So I traced the record. It could not be completed within that
You put
particular.
the writ petitioner on
Yes,
notice.
yes, I have put them on notice there. Notice there. We have also called him. Meeting has been held. He is also agreeable, Milord. Page 19, Milord. I have held a meeting.
You have mentioned this matter today upon notice.
Yes.
Where is the notice?
Notice টা কোথায়?
নোটিশ বলতে সার্ভিস করেছে
Yes.
ওটা তো আমি সকালেই জানতে পেরেছি একটা আছে
I have it, Milord. If Lordship wants some other day, I can do that.
When have you served?
Milord, I have served it today by email, Milord.
and I have also called
He might not
I
have
have
seen
also-
it at all.
Very well.
ওকে তাহলে কালকে
Very well. Any day, tomorrow or day after, when?
Not this week. Serve in the meantime.
Yes, Monday, Milord, or Milord,
Monday.
Kablik say Tuesday, Milord, if so commences. He will have more time, Milord.
Tuesday.
Tuesday. হ্যাঁ, আমি আছি। Tuesday.
None appears for the petitioner. Let the
I
matter,
am the petitioner applicant, my lord. I am the applicant, respondent in the writ petition.
is the application as such.
This is
You are
my
the
application.
respondent.
Yes, this is my application by the respondent. This is the
File an
application.
application.
Yes, application by the respondent. Because lordship's view was, my lord, for extension of time, I have to file, my lord, a formal application, my lord.
Where is the application?
And they have agreed, page 19. 3 weeks, they have no difficulty.
Application.
My lord, it's scan number 1 in WPA number 5639 of 2022. They have no, they said they have no objection if
The
further 3 weeks.
applicant / respondents. Educating. None appears for the petitioners. Petitioner. Paragraph, let the matter appear under the same heading. Can I order? Auditor can I? On 25th July. Paragraph, the applicant respondent is directed to serve notice upon the petitioner intimating the urgent date.
I'll definitely do that. Lord.
It's not in, you filed it yesterday.
Yesterday, my lord. Yesterday, but we have
Because
matter is
of the-
there. Returnable date দিয়েছিলাম 20 তারিখে। Matter has come up, Lord. I don't know how, my lord.
একটা line করুন, can 1 of 2023 is not in the file. Paragraph, the department is directed to put up the application along with the file on the agenda date. তারপরে none appears for the.
Mongolwar. He has more or less agreed 3 weeks, I'll give him the
Come
money.
back, I'll pass it in.
I'll give him.
Same heading. ওটা উপরে যাও, তারপরে none appears. Yes, next.
Item
My lord,
3,
I appear for the alleged contemner. 13th of July, this matter was taken up by your lordship. I submitted before your lordship that I have complied with the order. Your lordship directed me to file an affidavit of compliance. My lord, it has been made ready. Today it is going to be affirmed. Lordship, can you only make it not today, my
Not
lord?
today.
Not, only not.
Please serve a copy in course of.
Right, Sabine. Yeah, ask me copy.
Item 4,
I am appearing. Lordship, as per lordship direction, I filed the serve the service there. Consequently, the page.
I'm for the alleged contemner, my lord, led by Mr. Day, my lord.
yes,
I'm for the alleged contemner, my lord, led by Mr. Day, my lord.
yes,
My lord, may I be permitted to file my alleged compliance of report, your lord?
it's complied.
Yes, my lord.
Have you received a copy?
Lordship, I'm showing the
Have you
complaint
received
report.
the copy of the
No,
complaint?
nothing.
No, I'm sorry, sir.
I do not know what is the compliance. Lordship, can you see page 16 for a moment. 16 appear asked me to appear, and 17 old lordship is the compliance report. Can you have a look to that? That is sent. To my client.
Will you go through the report and come back?
No, I got it now
So will
today.
you go through this and come back? Do you want to see the report? and come
Yes,
back?
yes, without looking into how shall I? What is that compliance? Well, let us see.
Affidavit of compliance submitted on behalf of the alleged contemner is taken on record. Paragraph, copy of the affidavit is made over to learned counsel for the applicant petitioner / petitioner in court this day. Paragraph, on prayer of the applicant petitioner, the matter is adjourned. Let the matter appear under the same heading on 3rd August.
My lord,
3rd August.
third.
If you want to use an exception, please do so in the meantime.
My lord, if necessary, I shall file affidavit, if necessary.
item 5,
Compliance.
Appear on behalf of the petitioner, madam. Non-comply or my lord order, your lordship direction upon 13 April 2023, serve the contempt application to the contemner.
Have you served the contemner?
My serve the copy, but not every service not ready, my lord. Received by hand delivery.
Affidavit is not ready.
I am undertaking that in course of the 2 day, my lord.
So let there be a date.
Adjourn, adjourn the,
It's a contempt application, so it's serious matter. So they'll.
serve the copy by hand delivery to the contemner, my lord.
You have to file an affidavit of service.
Well, I'm undertaking to, in course of the today, to file that.
Not today,
Well, not today.
not today.
Yes. ma'am.
Item 6.
This matter, I am for the petition. As per your lordship's directions, since it was not complied within the time, my lord, yesterday they held the hearing. They have taken the hearing, very nice atmosphere, my lord, and he assured that he will do the needful. So, my lord, my humble submission, let it be pending for at least 2 to 3 weeks, because they have.
Because we have to pass a final order.
Final order, that is. They will pass the final. Okay?
By consent of the parties, the matter is adjourned. Let the matter appear under the same heading on 16th August.
16th August, deeply obliged.
Yes.
Item 7.
Item 7, my lord, I appear for the petitioner, my lord, pursuant to
For the alleged contempt.
my lord's order is at page 45 of the
My lord.
contempt application, my lord.
My lord, as per, no, my lord, as per my instruction, my lord, the physical verification will be held on 27th July, my lord, and to 12 noon, my lord. My lord, I'm praying only 4 weeks time to submit
Thank
a
you, sir.
compliance report, your lordship.
My lord will kindly consider the order, my lord. Now, my lord, again,
lord, may I
physical
hand over-
verification,
My lord, may I hand
all
over the
this
instruction, your lordship?
paraphernalias are over, my lord. Page 45 is the order, my lord. They have already ascertained the amount, my lord. Fund amounting to rupees 76 lakh 72,147 is lying with the district level purchase committee for payment to the petitioners as per direct purchase policy. Page 45, my lord. Learned counsel for the state respondent seeks accommodation for a couple of months to complete the entire procedure and execute the deed in favor of the petitioners. In view of the above, the writ petition is disposed of, directing the second respondent to complete the proceedings for direct purchase and execute the title deed in favor of the petitioners within 2 months from the date of communication of this order, upon affording a reasonable opportunity of hearing to the petitioners if required in accordance with law. Well, this order was passed in the month of December 2022. But thereafter in the month,
Why physical verification after the earlier order?
putting the card back.
Anyway, he is asking for a month's time for compliance. Let him come back.
But my little less time may be given, Mala, because pujas are approaching, Mala.
Just are in end of October.
Mala,
We are in July.
by this manner, Mala.
Learned counsel for the, you can take this back.
That's you.
Learned counsel for the alleged contender seeks accommodation for a month to comply with the order under contempt. Paragraph in view of the above.
Unless
Let the matter appear under the same heading on
date.
But there is some indication regarding issuance of rule, Mala, if he is.
not necessary, they are complying.
Returnable copy.
18th August.
18th August.
Paragraph affidavit of compliance be submitted on the adjourned date.
Yes, your lordship.
My lord, I am for the petitioner, my lord, contempt application for the first time, my lord, my lord's order. My lord's order dated
Please
25th.
serve and come back.
Yes, ma'am.
The applicant petitioners are the applicants petitioners are directed to serve notice, serve copy of the contempt application along with annexure thereto upon the alleged contender and file affidavit of service on the adjourned date. Paragraph, let the matter appear under the same heading on 18th August.
Respondents who have challenged the order, my lord's order, that has been dismissed by the honorable Lucent bench.
Item 9.
My lord, I am appealing for the state.
My lord, I beg to appear on behalf of the petitioner. Supplementary to them. My lord, may I kindly leave your lordships, my lord, to file a supplementary affidavit annexing only one document.
My lord, before I place this,
Served. A copy.
yes, yes. Shall it start? Now, my lord, kindly, I before place this matter, my lord, I may be allowed to, my lord, place page 18, my lord's order. May I place, my lord? The petitioners claim to be the recorded owner of the plot in question and complains that the private respondents have encroached upon a portion of PWD land adjoining his property, thereby obstructing his ingress and egress. The petitioner has submitted a representation dated such and such, which is yet to be considered. It is submitted on behalf of the private respondent that since the petitioner filed a suit in respect of the plot involved in the writ petition praying for permanent and mandatory injunction against the sixth respondent, impleading executive engineer PWD Nodia and the assistant engineer as pro forma respondent therein, the writ petition is not maintainable since the suit was pending. Then, my lord, the observation, the last part, page 19. My lord, got it. Page 19, it starts from, since the representation submitted by the petitioner is pending before the concerned authority, the writ petition is disposed of, directing the concerned authority being the 10th respondent herein to consider and dispose of the representation submitted by the petitioner dated such and such within 3 months from the date of communication of this order upon affording reasonable opportunity of hearing to all the affected parties, including the respondent. My lord, I am most of affected party. I was not given any, my lord, any opportunity of hearing, an order was passed. Now, my lord, kindly, even I was not made party in the proceedings. Now, my lord, kindly have a look, my lord, this notice, page 16. This was section 10, subsection 1 notice.
Yes.
Now, my lord, the porcha, my lord, I have annexed, my lord.
This was
The-
served on you?
Yes. No, yes, I have been served. This was served, my lord. After the, my lord, hearing, no notice was, hearing was given to me. Now, my lord, then kindly see the plot of land. It is usually not the road. 1752. Then, my lord, the writ petition was moved and this order was passed without impleading me as a party and no opportunity was given. Now, my lord, kindly have a look, my lord, the supplementary affidavit wherein, my lord, I have annexed, my lord, the document of the notice dated 10/2. At page 5, my lord, it is a typed copy of page 6. 10/2. And my lord, I have stated in paragraph 9.
Yes, so you have an opportunity under 10(3).
Prior to that, my lord, kindly have a look, supplementary affidavit, page 3, paragraph 9.
Page 8.
Yes.
8 bole ji. The police authorities, my lord, sorry, my lord, kindly excuse me, para 6, my lord.
Para 9 says they have not come for demolition.
My lord, para 6, my lord, kindly have a 6. Page 2. That all on a sudden, on such and such, the police of Najirpur Investigation Center, my lord, under the Tehatta police station, came to the house of the petitioner and told that they will demolish the residential house of the petitioner by so and so. Then, my lord, even yesterday night, my advocate on record also talked with the police authority. Yesterday night, they also came to the spot. My lord, I shall participate, my lord. Your lordship is absolutely correct. 10(3), my lord, is there. I can approach there. But teach us the police should not, my lord. The police, my lord, in making this type of harassment to. At midnight, they are coming. My advocate on record talked to the police authorities. Well, this is the, my lord, this protection, my lord, can be given. I shall proceed with that.
Yes, my lord, we have received the instruction, my lord. The authority has taken step, my lord, as per my instructions.
Taken steps for what?
My lord, may kindly.
10(2) notice has been issued, isn't it?
Yes, your lordship.
Section 10 proceeding comprises 10-1, 10-2, 10-3, and then an appeal under 10-4.
Yes, Your Lordship.
10-2 is over. You are at the stage of 10-3 now. So both parties need to be called, evidence need to be recorded.
Yes,
In
Your
the
Lordship.
meantime, the police is disturbing the possession of the petitioners. That should not happen, isn't it?
Yes, Your
Unless
Lordship.
the proceeding is completed, the petitioners are given an opportunity of hearing, they cannot be thrown out of their property, even if they're encroachers. Yes? So let the proceeding be completed within 1 month from date.
Yes, Your Lordship.
Until then, the police will, no coercive action shall be taken against the petitioners. Right?
Yes, Your Lordship.
My lord, my
Affidavit of service and supplementary affidavit filed by the petitioners are taken on record. Paragraph instructions submitted on behalf of the state respondents is also taken on record.
নোটিশ স্যার তুই হিয়ারিং এ পার্টিসিপেট
Correct.
করলেই তো তোকে নোটিশ দেয় তুই কোনো পিকচারই ছিল না
Pursuant to an order passed by this court
আমি নোটের পাঠিয়ে না
on
সে ঠিক আছে কিন্তু
20th March 2023,
ইন্টারভিউ করে
WPA 11778 of 2021.
N3 তারপর তো 10-4 আছে অ্যাপিলেট ফোর তার অত সস্তা 1 মাসের মধ্যে 10-3 করবে তা আপনি সঙ্গে সঙ্গে অ্যাপিল করুন
Directing initiation of proceedings under section 10 of the West Bengal Highways Act 1964. In the event unauthorized construction / encroachment upon PWD road or land was found, proceeding under section 10 of the Act of 1964 has been initiated. And notices under section 10(2) and 10(3) of the Act have been issued. Paragraph, it is submitted on behalf of the petitioners that no opportunity of hearing was granted to the petitioners prior to issuance of the notice under section 10(1) of the Act. And though the proceeding under section 10 is pending, the police authorities are
ওটাই তো বলছি তুমি প্রসিডিংস আরম্ভ হয়ে গেছে এখন কি করে
threatening
করবে? তো যার জন্য সেকশন
disposes the petitioners from their residential accommodation
তো ইন্টারভেন করে
in
গেছে
the plot in question.
10-1 চ্যালেঞ্জ করে 10-1 চ্যালেঞ্জ করার পরেই তো সঙ্গে সঙ্গে 10-2 করে দিয়েছে এখন তো 10-2 আমার অন ফিল্ড
Paragraph, learned counsel for the state respondents submits that proceeding has been initiated in compliance with the order of this court. Paragraph, upon consideration of the submission made on behalf of the parties, this court is inclined to hold that since proceeding under section 10 of the Act of 1964 has been initiated, the proceeding be taken to its logical conclusion. The fifth respondent is be directed to take the proceeding. Has been initiated, the fifth respondent be directed to take the proceeding to its logical conclusion within 1 month from the date of communication of this order.
প্রসিডিং করবে এটা
My lord, may kindly grant 3 months, my lord.
2 months. Section 2 is over, 10(2) is
10 is,
over.
yes, your lordship.
Evidence.
Yes, your lordship.
So 2 months should be sufficient. Within 2 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioners, in accordance with law. Paragraph, pending disposal of the proceeding under section 10 of the Act, no coercive steps shall be taken against the petitioners in respect of the plot in question.
My lord, kindly made it clear, my lord, that no coercive step to be taken by the respondent number 8. My lord, I do not know why they are, my lord.
By the respondents, no coercive steps taken
My lord.
by the respondents. Disposed of.
Deeply obliged.
I am for the petitioner, my lord.
I am for the statement.
My affidavit, sir. My lord, kindly come to the page 34, my lord. Unauthorized,
obstruction and my lord, the illegal unauthorized construction encroaching the PWD road, my lord, back in land, my lord.
Who
Page
is appealing to
34.
the state? You're appealing?
I am protesting.
Page 34, my lord.
Pagination copy has been served to me.
No, pagination, okay.
Annexure P2.
Yes, my lord, P2.
This is your representation.
Yes, my lord.
Yes.
This repetition is not maintainable on three grounds. First, my lord, the land is question, my land in question is neither fall under PWD, not fall under my lord highway. Therefore, the action which has to be taken by the, as per their prayer, by the executive magistrate is not come, my lord.
The authority will decide.
Yes, my lord. Authority will
If the
decide.
land is, if the land is fall under PWD or highway, then the executive engineer will take action.
The
There is
authority
no
will
question.
decide whether it's
They will
PWD
decide.
land or not.
Yes, no, but plot number has to be mentioned. They have not mentioned any plot. Where I am deciding.
They have stated it's adjoining their plot.
Second,
PWD
my
start
lord,
adjoining
second,
their
my
plot.
lord, road is questioned, whether the road is highway or not, that has not annexed to any document.
That
Therefore,
authority
no
will decide.
question, just come, my lord, to take action by the executive magistrate, my executive engineer. my lord.
Your next objection, the authority will decide, sir.
Yes.
Don't worry. Next, your next objection.
Third, my lord, the third point is the question of ingress and egress of the petitioner. My lord, there is it, my lord, road. If you lordship kindly come to page number 90 of their deed, I don't know the exact page number. Page number
Internal,
9.
internal page 9. My lord, page 26,
Internal
my lord.
page
Page 26, page 26.
Kindly come.
Yes.
The allegation is, I have blocked the ingress and egress of the petitioner land. If you lordship kindly see the Chowhuddi Uttor 10 foot Prososto Kacha road. There is a road. If I am belonging in this road, even therefore, my lord, the question the executive magistrate will take action under Highway Act will not come. But I have to occupy the land of the PWD road. Therefore, the question
Petitioner
comes
claims
that
that
the
this
executive
is-
magistrate will take action.
The petitioner claims that this is a PWD road. So this court will not go into merits. There is a representation pending before the authority. Your points will be taken up for consideration by the authority who will decide.
You might not kindly record one thing, if the land is not fall under highway or PWD, PWD will not take any action.
That is not necessary to be recorded. The PWD themselves will not take up in that case. Yes, for the state.
Yes,
anything?
madam. Consider the representation then.
Affidavit of service. The petitioner,
And then the plot number should be considered.
everything will be considered.
Everything.
Why are you apprehensive, sir? Your submissions indicate that you are encroaching.
And I am encroaching maybe in a private land, if that is a private land, there is a civil suit. They may come before the civil court.
Let the
There is no
authority
question
decide.
of taking action by the highway authority.
Let the authority decide. You are vehemently opposing because of that fact, sir. The petitioner claims to be the recorded owner of the plot in question and complains that the private respondents have placed unauthorized construction by encroaching upon PWD road adjoining his property, thereby obstructing his egress and ingress. The petitioner submitted a representation in this regard before the concerned authority on no date.
Yes, my
Your
lord.
representation?
Yes.
Well, the assistant engineer is not made a party or executive engineer in the representation. They only sent it to the subdivisional officer, superintendent of police, district magistrate, officer.
Should be Where is the assistant engineer? It's not addressed to the.
Assistant engineer is the authority.
The subdivisional officer.
No.
It's PWD road.
Leave they will grant it to.
Not implemented also.
Not a party in the writ petition.
You're aware. It should be the assistant engineer.
And leave may be granted to add.
What is the date of your representation?
Representation date my lord same on my lord 8/12/2022.
Where is the date?
My lord, page 36 my lord. All receipt my lord I sent my lord.
On 8th December 2022, which is yet to be considered. Stop the petitioner prays for the direction upon the concerned authority to consider the representation at the earliest. Paragraph, it is submitted on behalf of the private respondents that it cannot be ascertained from the writ petition as to whether the land occupied by the private respondents belong to the state highway, belong to the PWD, belong to the PWD. And also the construction raised by the private respondents has not obstructed the egress and ingress of the petitioner in any manner. Paragraph, be that as it may, comma, since the petitioner alleges illegal encroachment upon PWD road and representation submitted by the petitioner is pending consideration by the authority, comma. This court is inclined to hold that the representation be considered and disposed of by the authority in accordance with law. Paragraph, in view of the above, the petition is disposed of, directing the ninth respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 3 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondents, comma, in accordance with law. Paragraph, the concerned authority is at liberty to ascertain whether the land in dispute is part of the state highway or belongs to the PWD and shall take necessary steps in accordance with law in the event of unauthorized encroachment in the event of encroachment / unauthorized construction thereon. Yes, that is your submission. On prayer of the petitioner, liberty is granted to implead the assistant engineer Midnapur Highway Division.
Yes, Midnapur Highway Division. Yes, my lord.
Public
My lord,
works
they have not annexed any document to prove that the Midnapur Highway, Midnapur Division is the concerned authority or not. No documents have been.
Not necessary, sir.
This is necessary. Maybe
The assistant engineer,
Midnapur, my lord,
Midnapur
Division
Highway
take
Division.
action.
And this is not the concern of the private respondent. The state will object if necessary.
Yes.
Comma, Public Works Department within bracket roads, comma, Government of West Bengal as respondent number 9 in the petition. Paragraph, the cost title of the petition be amended accordingly. Last is until then. It is closed up.
Madam, naam ta nahi. Naam.
Well, item number 11, I appear for the petitioner. My lord.
I appear for the state.
The other
My lord, I
side,
am
sir,
for the
here.
DFCCI.
Other side, sir, here. My lord, this matter, my lord, pertains to my lord, land acquisition by railway project. My lord, the answering respondent is the my lord, competent authority, the ADM. My lord, kindly come to page number, my lord, 26 P1, my lord. In the year 2015, my lord, I have been
What is
served
your
with this
advance?
notice.
You've not received compensation.
I have not received compensation till date. Me being the interested person, my lord, I have enclosed the document, my lord, showing my rights over the property.
That page? You're
At
referring to
page, my lord, my lord, may kindly come to page number my lord, 39, my lord.
Yes.
At the bottom, my lord, kindly see, my lord, 18368. It is in the my lord, vernacular, my lord. Then, my lord, 18503. My lord, kindly turn over leaf on the left hand column, my lord, in the middle. 18363, 18364, 18365. 5 plots, my lord. The name has been indicated, my lord. Mohammed Amin.
Yes.
At page number, my lord, 27, I have sent the my lord, representation to the ADM, my lord, on my lord, 18th November 2022.
27 is a notice.
Yes, my lord, I have sent this the advocate's notice, my lord. The advocate on record, my lord, sent this advocate's notice. Since then, man, I have been paying the electricity bills, the my lord, property
And
tax,
you're in possession.
my lord.
All steps have been taken in accordance with law, in accordance with the Railways Act to be precise. My lord, notifications were issued. Interested persons were called for hearing. After calling the interested persons, the petitioner, my lord, failed to submit any documents which would reflect his ownership over the land. Thereafter, the amount, my lord, which has been given by the Railways Authority has been deposited in the court in terms of the Railways Act.
My lord,
This is my report.
My lord, I appeared, my lord. I have
You appeared.
indicated in my.
You appeared.
I appeared with all my documents, which I have been. I have annexed here, my lord. And till then, my lord, the ADM has not communicated anything to me, my lord.
The ADM has not?
Has not communicated anything to me after that.
So he needs a copy of the report.
I'm giving him a copy of the report. Lordship, kindly sees the next page. The second page, my lord. Last paragraph. Last paragraph. The notice was issued to interested persons against plot number so and so, including the writ petitioner, but no revenue record in respect of suit plots has been obtained from the office of the this. The interested persons, including the writ petitioner, could not submit any revenue record in support of their claim. Hence, the petitioner has been considered as an interested person, but not as a raya. The award amount in respect of suit plots is this much, and due to non-availability of revenue record either from the office of the SDNLRO or from the interested persons, including petitioner, the entire award amount has been deposited in the court in terms of section 20H4.
So your recourse lies before the civil court now.
My lord, then my lord, I'll beseech to your lordship, my lord, kindly give me that liberty to approach the civil court by filing an application, my lord, and kindly.
I will grant you liberty to approach the civil court in accordance with law.
And my lord, also my lord, time frame, my lord.
Kindly direct the land civil court to dispose of his application as expeditiously as possible.
Within
Not
8
more
weeks,
than that.
8 weeks.
Civil courts are,
My lord,
I do not know the.
my lord, I am my lord, 70 years, 78 years old, my lord.
So this prayer has to be made before the court itself.
If a time frame is, my lord, an observation is.
Without being aware of the business of the court, the court may be having 10,000 records pending, isn't it? So it's best if you appear before the court and make such a prayer.
As expeditious.
I'll grant you liberty. Third, instruction submitted on behalf of the state respondent is taken on record. Paragraph, heard learned counsels for the parties. Paragraph.
Limitation of it.
The Grievance of the petitioner is that though his land was acquired
May I take your lordship?
by the railway authority for Eastern Dedicated Freight Corridor Project, comma, Vide LA case number 75/2013-14 within bracket DFC bracket closed, comma. No compensation was paid to the petitioner for the same. The petitioner sent a demand notice upon the concerned authority through his learned counsel on 18th November 2022, which has also not been considered. Paragraph. It is submitted on behalf of the state respondents that notice under section 20 capital F within bracket 4 of the Railways Act 1989 was issued to all the interested persons, including the petitioner, and since the petitioner was unable to substantiate his claim in respect of the plots in question, comma, no compensation could be granted to him by the authority. Stop. The entire amount of rupees 35,777,53 has been deposited in the court of the learned district judge, comma, Paschim Bardhaman, as per provision of section 20 capital H within bracket 4 of the Railways within bracket Amendment bracket closed Act, comma, 2008. Paragraph. In view of the above, the petitioner seeks to approach the learned civil court to substantiate his claim for receipt of compensation. Paragraph. Accordingly, the petition is disposed of with liberty to the petitioner to approach the appropriate civil court for redressal of his grievance. Paragraph. The civil court is requested to consider the prayer of the petitioner and dispose of the same as expeditiously as the business of the court would warrant.
I'll add one more in this one. The period of limitation, if any, may be excused to approach the civil court.
Paragraph. In the event, requested in the event, file for a direction, liberty, in the event the petitioner approaches the civil court within 15 days, from date, comma, the learned court shall deal with the application of the petitioner on merits without dismissing the same on the ground of limitation. Therefore, the learned court is requested.
Thank you.
There shall, however, be no order as to costs, etc. No order as, no.
Okay.
Next.
12. Opposition member.
I am for the petition. This is the second round. Lordship's earlier passed an order. Lordship's page, operating portion page, my lord, 62. This has been passed on the basis of the paragraph 6 of this writ petition.
Yes.
But Lordship, this order has been passed on the basis of the statement paragraph 6 of the writ petition, as because the some plots of lands have not been acquired, though other lands have been acquired. Now they have passed the impugn order. Impugn order something else. The operating portion of the end of the order, kindly appreciate the observation. Page 70. May I submit it is settled principle law that having the land been taken over possession in a duly constituted land acquisition proceedings, that is not the prayer formality.
Not the case at all.
That is not the case at all. So my respectful submission to this, my lord, in this case, my lord, require for affidavits. Otherwise, it cannot be disposed of. It requires for affidavits and with the records. Something is else behind the back.
My lord, if your lordship come page 69.
I mean,
69?
I have seen it.
Yes.
Sorry.
Yes.
69, my lord, third paragraph.
I mean, last portion.
Moreover, Molina Loskar, wife of Nirmal Loskar, appellant number 2, submitted an affidavit before ATO that she is not involved in WPA number. That is, my lord, that is involved in
That doesn't alter the acquisition.
I'm coming, my lord. That is if your lordship, what your lordship order passed, my lord, that is in that, my lord, he is not a party of the proceeding but his name was taken, my lord. As a part of the development of Newtown project, plots were on going through all the case record, it is crystal clear that there is no latches in the aforementioned to land acquisition proceeding. Notice were duly issued to the petitioner interest of the petitioner by invoking section 9 of the Land Acquisition Act 1892. Award had been declared, initiating proceeding under section 11 and possession handed over to RB and ATO by case number ATO and ATO case number. But the petitioner interest of the petitioner did not appear for taking their due compensation as under section ATO of the union. After due award money of these two proceedings had already been deposited in court, being verified in form number ATO and ATO. So the two lands acquisition proceeding had attained finality. It is up to mention to this context that as soon as the possession handed over to the ATO, the land absolutely vests to the government as consecutive the actual owner of the divested and ownership of possession. There is no law in the land acquisition of a land act for relinquishing of the land after it vesting in the government. It is said to principle of law that having the land been taken over possession, it is duly constituted land acquisition proceeding. There is no scope to release the revert the land to the erstwhile owner. In this case, this is well. Well, what is the wrong in it?
Everything is wrong in it.
What is?
The land acquisition proceeding was not challenged at all. There was no prayer for divesting of the land.
Then?
The petitioner in the earlier petition said the acquisition proceeding was held, no dispute. Land beyond the acquired land was trying to be utilized by the requiring body. Where the petitioner resides, that land is not part of the acquisition process.
My lord,
the petitioner filed a representation seeking that you can either acquire the land or give it back to me. The acquisition process was not challenged at all. There is no question of divesting. It has been held on a very wrong premise. The authority has failed to understand the purport of the representation.
Then, my lord, what is the where is the representation?
Earlier petition আছে 1 minute.
Where is your representation?
1 minute. That is annexer P5, page 57.
আমাদের গৃহীত নিবেদনে যে তফসিলের সম্মতি আমার পৈতৃক খরিদসূত্রে প্রাপ্ত এক খাসি মালিকানা বাস্তু জমির অসুবিধা তো আমরা বাসযোগ্য জমিতে পরিণত করা গাছপালা লাগায় মাটি ফেলে উঁচু পরিণত করা গৃহণ করতেছি পশ্চিমবঙ্গ সরকার বাহাদুর নিম্ন সম্পত্তি উপনগরী করিবার জন্য অধিগ্রহণ করলে আমরা বিরাট ভাবে ক্ষতি করবো আমাদের রাষ্ট্র হিসেবে নিম্নিত চার করে জমি স্বেচ্ছা বাহাদুরকে ছাড়িয়ে দিতেছি আমাদের তৈরি এই উঁচু বাগান গাছের ফলে নিম্ন সম্পত্তি বাহাদুর গ্রহণ করিয়া আমাদের অনুকূলে ছাড়া দেওয়ার জন্য দরখাস্ত করি কারণ মহাশয়
That is my lord, the paragraph 6 in the writ petition that I have stated that portion has not been under the acquisition proceedings, that is left. How the acquisition proceeding come?
My lord, there is nothing in this.
That's true.
What is the contention of this, my lord? I can't understand this contention.
In this
What is the
statement without
contention of this,
affidavit,
my lord?
without records, this cannot decide.
দাঁড়াও না তোমার কাছে শিখতে হবে নাকি একটু দাঁড়াও আমারটা আমি বলি তোমারটা তুমি বলেছো তো
ঠিক আছে।
দেখুন আমি তোমাকে ডিস্টার্ব করিনি তুমি কেন আমার বেলায় বলতে আসছো
Disturb করি, sorry.
my lord what is this contention
Is this the writ petition that you?
if this is the representation my lord whether this representation has any my lord I can't understand what is the representation is this nothing is there আমার জমি আমি তোমাকে ছাড়িয়ে দেবো তুমি এটা নিয়ে নাও what is this representation that is he has not any case my lord practically in represent according to this representation my lord my lord our officer passed this order that is a very good order that we have
The representation has no.
General
connection with
Lordships
the
kindly see the
petition.
annexer P8 notice.
There is the representation that you referred to in the earlier writ petition. This representation doesn't say anything.
My lord, that is my kindly see paragraph 6, which I have prayed for. That on that basis, my lord, the order was passed. Paragraph 6 in the writ petition. এটা কোনটা?
But is this the subject of your representation? No.
My lord, that is earlier represent. This is the separate another deed application after the order. My lord, the General Lordships kindly see one document I can say before Lordships, page 58.
In the earlier representation, in the earlier writ petition, a representation was directed to be disposed of.
Yes. Considering my prayer and the paragraph 6.
Paragraph 6 is in this. writ
Paragraph
petition.
6 did not this. Paragraph 6 is some plot of lands
So
which
where
were
is
not
this
acquired.
clear in your representation?
That
How will
represent,
the authority know?
Lord, my lord, the kindly see the page 58 of this, the notice. দাগ নাম্বার দিয়েছি তো কিন্তু প্রেয়ারটা সেখানে না করে অনুকূলে
This
গিয়ে
is a different issue altogether, allocation of alternative land.
Yes.
Acquisition. This
My
is not
my the paragraph
representation.
representation what my prayed for. What prayed for, the other lands have been acquired and no objection to that. Only some plots has not been acquired. They have taken the possession. Right position, not position. My client is still position.
Is that your language in the representation? Have
This,
you
my
seen
lord,
the
the client has been made and indicated the plot number also in the bottom portion in the prayer representation. So my respectful submission to the case, my in this instance, let the file the evidence opposition with the records. My lord, otherwise my lord, client will be prejudiced. Otherwise, my client will be prejudiced.
Your client.
I am
is
challenging the ordered impugned, which has been ordered impugned, is otherwise decided.
perfectly in tune with your representation, which has no connection with the earlier writ petition. You have stated something in the earlier writ petition, something else in the representation. And the authority has passed an order according to your representation.
My lord, order passed? Can you appreciate to that?
Your writ
May
petition.
I seek for my lord, kindly what
Your
order?
representation says গৃহ নির্মাণ করিবার পরিকল্পনা করিতেছি. That means there is no construction. You are planning to make a residential house.
No, we are residents, we have the
Some
residents.
representation, sir.
No.
গৃহ নির্মাণ করিবার পরিকল্পনা করিতেছি. That means there is no গৃহ at present. You are planning to construct.
That thereafter, when the application was made, my lord, that is my lord.
Where have you stated that you are residing in the property?
এবং আমাদের তৈরি উঁচু বাগান গাছপালা তৈরি করা আছে বাস্তু সংলগ্ন জমি হইতেছে লাস্ট বটম পোর্শন ইন
গাছপালা তৈরি করা আছে।
তৈরি করা and গাছ and the বাস্তু সম জমি হইতেছে ফলে নিম্ন তপসীমন সম্পত্তি সহ অধিগ্রহণ না করিয়া আমাদের অনুকূল ছাড়িয়ে দেবার জন্য দরখাস্ত মূল করিতেছি। My respectful submission, this plot in question which has been my clients residing in possession, there other plots have been taken. There is no dispute about this. We are not challenging this. That plot of land in question which has not been under the acquisition proceedings. They tried to acquire, they tried to take the position. That's why
Saying is not part of your representation.
the part of
You
the
said this in the earlier writ petition.
Yes.
You have said this in paragraph 6 of this writ petition, but not in your representation.
But apart from that, not apart from that. Apart from that, my clients, my lord, the paragraph is stated in the affidavit that some plot in question is not the under the acquisition proceedings. The law, when the acquisition notification has been done,
Have stated in the affidavit, have you placed it before the authority? The authority has only considered your representation, and rightly so.
my
There
lord,
was
the-
no scope for the authority to consider your prayers in the writ petition.
my lord, the only one thing for my Indians. Well, I prayed for my lord the affidavit in this case, particularly in this case, as because my client will be prejudiced. When the acquisition has been taken, as to whether that plot in question was taken in possession,
Your client has
my
chosen to be
my
prejudiced.
client still in possession. They have stated,
But nothing in the writ petition, have to dismiss.
my
You
lord,
can
the
withdraw if you want.
my lord, the only one in this can be my lord. My client will be prejudiced, my lord. If lordship,
Your client has chosen to be prejudiced.
my lord, the lordship, that's we have come before lordship, challenging the order impute. My responsible submission,
There is nothing.
though I
wrong
have
with
prayed
it.
for set aside the impugned order, though I prayed for, at this stage, my lord, we prayed for opposition. As because some records is required for consideration. As because, my lord, when the acquisition proceeding is done,
The state
gazette notification has been done. No, whether the gazette notification, my
doesn't want to file opposition, the court cannot insist. It is this for the state.
then I have to
decide.
oust the court.
It is the state for the state to decide whether opposition needs to be filed. State says not required. I do not find anything wrong with it in terms of your representation. The authority cannot go beyond your representation.
My lord, only, my
You
lord,
have
the-
stated alternative land doesn't mean anything. Is this a representation?
I've seen.
Yes.
Apart from that,
So
my
there
lord,
is no fault on the part of the authority.
no, my lord,
There is nothing apart from that. Your representation considered by the authority, no fault. Writ petition says
no, my
something
responsible
else.
submission only one other things, my lord. In the earlier occasion, I submitted it to lordship.
And you were heard by the authority before it was considered? Before
Only
it
the
was-
last occasion, at the time of last hearing, my client could not be participate in the proceedings. The last order. Though all along, my lord, my client appeared.
Predecessor of writ petitioners could not. That is a different thing.
And the entire order, my lord, the only on the records on the place by the HITCO. That is not my petition. Petitioner prayed for adjournment on the, that has been considered. Not the page 68. My client prayed for adjournment. That has been rejected.
The seventh adjournment was rejected.
My client prayed for adjournment.
Seventh adjournment. 6 adjournments were
No, no,
held
no.
earlier. Please
Seven
continue.
adjournment made, there are certain proceedings, my lord, when officer was not present, they have stated, made the application for adjournment. All the occasion when the adjournment has been done. And my responsible submission only things, my lord, as to whether the plot in question involved in the acquisition proceedings.
Mr. De, it appears that the 7th adjournment of the petitioner was turned down by the authority and it was heard ex parte. Let the matter be sent back to the authority for reconsideration. One date be granted to the petitioner. If the petitioner doesn't appear, this order will be affirmed automatically. Let the petitioner be heard before.
Without setting aside this order, my lord. As because, my lord, that order is, my lord, he can improve his case, my lord, then.
Let one date, I'll grant you the
Yes.
opportunity.
Yes, sir.
for
But he has not any case, my lord, according to.
That's true.
And that is one, my lord, malified intention that a person who is not, my lord, they agree to be a party of the proceeding, that He added that he as a petitioner.
Unfortunately, the court is also holding that petitioner has no case. So I want to send him back to the authority, let the authority.
Yes, ma'am.
Instead of dismissing it outright.
Yes, ma'am.
WPA 21382 of 2021. Directing the concerned authority to dispose of the representation submitted by the petitioners before him within a stipulated time frame. Paragraph. The order impugned demonstrates that on the date of hearing, the petitioners sought adjournment which was turned down by the authority on the ground that 6 adjournments were sought by the petitioners previously, which were allowed. Stop. The order was passed in absence of the petitioners. Stop. Paragraph in view of the above, without going into the merits of the case, this court is inclined to hold that since the petitioners were deprived of an opportunity of hearing before the authority when the order impugned was passed, such opportunity be granted to the petitioner by the authority in disposing of the representation pending before him. Paragraph. In view of the above, the writ petition is disposed of, directing the
Additional district magistrate.
third respondent.
Additional district magistrate.
Yes,
Additional district magistrate.
the third respondent to extend an opportunity of hearing to the petitioners and consider the submission made by them before passing a final order. Stop. If the petitioners fail to be represented on the date fixed by the authority, the order impugned shall attain finality. disposed of বলেছি আগে there shall be no order as to cause since no affidavit or
My lord, the lordship fix the date, my lord. Any date? Fix the date.
1 month
Yes, my lord. One.
মানে the extra ওটার আগে করুন
ওকে নোটিশ দেবে তো নোটিশ
Final
দেবে
করুন, ওখানে করুন the entire exercise is expected to be completed within 1 month from the date of communication of this order.
Another instance, my lord, the earlier order also the status quo interim order position is.
No, my lord.
No.
My lord,
No,
the
my
only
lord.
things for a moment.
That can't be.
I do not find any case, so I will not grant any further
No, last occasion, your lordship passed and since my lord, my client is still in position. My lord, only till that, my lord, till date. I am not, my lord, the searching for the other things, my lord. Otherwise, my lord, the
It is entirely your fault. I do not find
that
anything
is,
in your.
my lord, the somebody false, well, that is, I am not submitting.
It is not a committee, it's the petitioners themselves.
Well, I'm submitting it for lordship. So last occasion, lordship passed an order, status quo.
No interim order will be granted, appear before the.
Only for
authority, let
status
them
quo
consider.
regards till the disposal, your lordship fixing the date 1 month, only 1 month, what will be happen?
Has anything happened during the past few months? Nothing. So next 1 month, nothing will
No, no,
happen.
that,
I'm sorry.
since your lordship direction was there, since lordship direction was there.
No,
13.
next.
Issue. Issue. So,
No, yes, I
No, my lord, I am not, my lord, since your lordship passed an order.
My last occasion in this matter, my lord, file this.
Facts of the case of this case, my lord, the unauthorized encroachment, for removal, the unauthorized encroachment, the petitioner prayed for necessary direction upon the authority, my lord, to consider the representation of the petitioner. Earlier occasion, my learned friend who is appearing on behalf of the, my lord, the Jila Parishad, my lord, he submitted before your lordship that it is, my lord, leased out. My lord, the roadside land, my lord, which, my lord, in front of the petitioner's premises, my lord, he.
My lord, I am for the Jila Parishad.
my lord, I am for the respondent number 11, my lord.
My lord, the land belongs to Jila Parishad, there is no dispute. My lord, now, my lord, what he is praying, my lord, in front of his house, my lord, there are certain stalls and all on that same land, my lord. My lord, he wants to evict those persons from my land of the Jila Parishad of the government, my lord, and he trying to have a free access of the entire front face of his property. Well, this cannot be done. My lord, he's a 10-foot road is already there.
Say that you leased out the land.
Yes.
in favor of
Now,
the-
yes.
Well, one thing, I am appealing for the private
They
response.
are the leaseholders.
So this is the land belongs to the government.
Then
The
I'm sorry
proceedings
to,
under the
sorry to
government.
interrupt, my lord, we are paying the tax to the concerned panchayat also. I'm sorry, private respondent number 11.
For the petitioner.
Yes. So, my lord, this is the proceedings, according to my learned friend, it can be initiated under the Government Land Unauthorized Occupiers Act. My lord, the opening sentence starts with in absence of any permission. Your lordship find in both the cases, my lord, I have the permission. Now, if they want, that now, my lord, asking for easement. Easement right about the land in question. That is the civil court is only the jurisdiction.
It is the government land.
Yes, government land.
So
belongs to
what?
Jila Parishad.
What is his Lucas?
My lord.
And this is the,
Premises,
No.
anybody.
that is why.
Constructed by way of constructing part of structure and ingress and egress, my lord, is blocked. Then, my lord, he,
If the government has granted lease, they are the private respondents are the lessees.
my lord, kindly direct them to file the, my lord, report.
Why?
Kindly direct them
There is
to
the
give a
lease.
report. My lord,
My lord, I am giving.
kindly.
Yeah, this is a payment of the money
Kindly give a.
regarding.
The payment doesn't prove anything. I want to see the deed,
Yes,
the lease.
My lord, these are the, my lord, fees, my lord, which they have deposited. The matter has been, the matter has been sent to the, my lord, DM. My lord, DM is the authority, my lord, who will grant the lease. My lord, the deeds are to be, my lord, required to be transferred to the, my lord, leaseholders. My lord.
It has been
No,
verbally.
it has not been done. My lord, it will be done very soon since the panchayat election was there. My lord, it could not be done.
So how do you say that you have granted lease?
My lord, because we have accepted the, my lord, amount of lease, my lord, kindly see. And my lord, he is trying to, my lord, get hold of a property, my lord, of the government, my lord, to have a free access of the, of ingress and egress of this.
Government land, maybe government land. That does not mean they will, my lord, lease in front of my premises, which I use as.
No, my lord. No, my lord, there is already a 10-foot road
And
for
my
his
lord,
ingress and egress.
Kindly
These are
direct them.
disputes of fact. It will not be dealt with by the.
Yes.
petitioner.
Kindly direct them to hand over a report, a copy of the report. My lord,
Stating what?
I will take instructions from my client.
What they will take.
You had an opportunity to take instructions because on the earlier date they have submitted that
No.
we released out the time.
Earlier occasions, your lordship directed to file a report in the form of an affidavit.
You
Whether
actually
they have,
directed to file a
whether
report.
they have filed it or not, I do not know.
My lord, I have, my lord, made it
And,
ready, my lord, it has to be
my lord,
affirmed.
kindly direct them to give a copy.
My lord, same thing, my lord, which I am saying before your lordship, my lord, I have stated there.
Direct them to give a copy.
He has a 10-foot feet road, my lord, through which he can egress and egress. The entire frontage, my lord, he cannot claim.
Whatever it may be.
He has to go to the civil court and claim for his inventory rights.
Road belongs admittedly to the Jilla Parishad. The Jilla Parishad has the authority to lease it out to any
Yes.
person.
My lord, can.
If you
My lord,
have any grievance
Civil court.
against that, you have to appropriate you have to approach the appropriate forum. Right?
my lord, yes, my lord.
What
Kindly,
else?
kindly adjourn this matter.
Oh,
My lord,
what
kindly
else?
give, kindly direct them to give a copy of this report. And my lord, I will take instructions from my client.
But these are government documents, my lord, filed on behalf of the government, my lord.
There was a direction.
My lord,
for
I have,
a report in the form of an.
I can, the same thing, my lord, which I am, my lord, pressing before your
Come
lordship,
back
my lord.
next week with a report.
Yes, my lord.
And please serve an advance copy.
Yes,
so
yes,
that
I am
we
serving
can-
hearing now.
And my lord, one thing, my lord, kindly see the prayer B, my lord. It is
My lord, if
stated
your
that
lordship
it
may
will
kindly
be
consider.
used.
একটাই আরেকটা কোনো কিছু নেই
Where is annexed?
My lord, even if my lord kindly consider section 8
No annexure is there.
postulates unauthorized occupation in relation to any public land means the use or occupation by any person of the public land without authority in writing by or on behalf. So anything, my lord, I have to produce that they have the consent to giving the land. Nothing more than that.
No, no.
And my lord, kindly,
And if
kindly
they
see the
want
prayer B, my lord.
point-to-point access, then they have to establish their right under the Easement Act.
It has to be unauthorized.
Yes.
Yes.
Right? Then you cannot do anything about it.
No. My lord, they can say it is authorized. But my lord,
They are the
evidence,
owners.
your earlier evidence, your lordship directed to file, my lord, report in the form
My lord, what more, my lord, I will file?
Give a copy.
You are harping on the same point. Report. What will?
What
how
more
will
I
the report
can
make a
give?
difference to your client?
My lord, even it is unauthorized.
There is a
Am I
direction.
not be able
Please
to
come back
take
with
a
a report. You can take this back.
এই দে রে ভাই ওকে একটা
একটা
copy
কপি
দে।
দিয়ে দাও না।
ও না annexure order এই জজ সাহেবের order
No, he is giving without any annexure.
আরে the
Without
annexure
any
is
annexure.
the annexure is the order of the court.
Only.
Learned
You want to
counsel for
linger the matter, you linger the matter.
Why linger?
I record my submissions so that portion is.
I'll kindly also record my submissions also, man.
Only report because my lord, it will just, my lord, record it.
This
I am
submitted on
inviting.
behalf of the Jilla Parishad as well as the private
My lord, may I be
respondents.
permitted to take
That
my lord?
that the Jilla Parishad has. Jilla Parishad intends to lease out the plot in question in favor of the private respondents for which rents are being accepted by the authority from them. Learned counsel for the Jilla Parishad seeks extension of time to submit the report in the form of affidavit as sought. Paragraph, let the matter appear under the same heading on 25th July.
Okay, can I take back the
পুরোটা ফেরত দিয়ে দিল না কেন?
এইটা না
ফেরত দিয়ে
ওই
দিল, রিপোর্টটা ফেরত দিয়ে দিল।
হ্যাঁ ওটা দাও এটা দাও
He's serving the annexures because
এটা যেগুলো annexure করেছি যেটা এটা কোথায়
next. Yes.
Should make you aware of the state responding question.
All the response services affected.
Private respondents are there?
How this is affected about the private respondent?
Anyone appearing for the private respondents?
I'm for the private respondent.
Private respondents?
Unauthorized
construction over the government land as per 1962 Act, my lord. The petition
Yes.
says constitution, that is annexure P3 page 56, my lord.
Page?
বোঝাই যাচ্ছে না। 51.
Yes. What is the submission?
But this is my land, madam. It's completely suppression offense. I can show my land also from this annexures also.
Place your documents before the authority, let them
Page-
consider.
Before the authority.
Let the representation be
Let the authority
considered.
decide.
You will be given an opportunity of
My lord.
hearing.
My lord, may I humbly submit, lordship. My lord, after receiving this representation, my lord, which my learned friend has adverted to at page 56, my lord, that is on 9th January 2023, my lord, the authority received on 19th January 2023, my lord. After receiving the same, my lord, the SDO has written, my lord, to the BL and LRO. As the report goes, my lord, I have been given one report dated 20th February 2023.
For demarcation?
So, my lord, as per the report dated 20th February, I find that, yes, the SDO has written to the BLLRO that you go and demarcate the land in question. Accordingly, my lord, BLLRO had fixed, my lord, 24th February 2023, a date for demarcating. So thereafter, my lord, I don't have any update with me. Lordship, kindly direct them. So if not already undertaken, let them go along with the process by keeping this report on record,
But
lordship.
both of us will be called.
Absolutely.
Yes, lordship. Report dated 20th February, lordship. The first annexure, letter by SDO to BLLRO. And second annexure, my lord, letter by BLLRO to SDO. Fixing date on 24th February. Lordship.
Affidavit of service. The petitioner complains that the private respondents have raised unauthorized construction by encroaching upon government land adjoining his property, thereby obstructing his egress and ingress completely. Stop. The petitioner submitted a representation in this regard before the concerned authority on
9th January 2020.
9th January 2020.
2023, which is yet to be considered. Stop. The petitioner prays for a direction upon the authority to consider the representation at the earliest. Paragraph, it is submitted on behalf of the private respondents that the private respondents have raised construction on their Rayati land and have not encroached upon any portion of government land. That is your submission.
Well.
Paragraph. একদম শুরুতে বলেছি, instructions submitted on behalf of the state respondents is taken on record. Paragraph, placing reliance on the instructions submitted today, learned counsel for the state respondents submits that pursuant to the representation submitted by the petitioner, the subdivisional officer, Tomluk Irrigation Subdivision, Purbo Medinipur, by a letter issued on 19th January 2023, 2023 to the block 2023, requested the block land and land reforms officer Mohishadol, Purbo Medinipur, for demarcation of the government land in dispute. Stop. The block land and land reforms officer, in turn, informed the subdivisional officer by a letter dated 17th February 2023 that the date for demarcation has been fixed. Demarcation was fixed on 24th February 2023. Stop. Learned counsel is unable to apprise the court as to whether such demarcation has been concluded Stop. Paragraph, in view of the above, this court is, this court is inclined to hold that since steps have been taken by the authority for demarcation of the plot in dispute, the
Respondent number 3 back.
BLLRO,
Subdivisional officer HON'BLE.
No.
first the demarcation, then the
Lord,
subdivision.
if not already done,
The Block Land and Land Reforms Officer, being the fourth respondent herein, be directed to conclude the demarcation and submit a report to that effect before the subdivisional officer Holdia, being the third respondent herein, within 1 month from date.
if not already done, Lordship.
1 month from date, if not already submitted. In the event encroachment upon government land or any portion thereof is detected upon demarcation, the third respondent is directed to initiate proceeding under the Act of 1962 and take the proceeding to its logical conclusion within 2 months from the date of receipt of the report, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondents, in accordance with law. Disposed of which apply.
The report may be kept on record, Lordship.
Take. Affidavit of service and report taken on record.
Lordship.
Well, the collector will be empowered, I think, for.
SD.
SD.
Goes to the collector.
It should be appeal to the collector.
9 to 11 already. 9 and 10 days.
Next.
But I beg to appear on behalf of the petitioner. This is my
Take
affidavit of
this photo.
service. I am appealing for the initial authorities. My Lord, without conducting any acquisition proceedings, without providing us any compensation, even without being able to show any documents in support of their title, our land has been taken over by Eastern Coalfields Limited. Now, Lordship, firstly, if I may just take your Lordship to the documents, but in support of our title, Lordship may kindly come to page 19. The plot in question.
Give me a minute, please. Who are the other respondents? Only ECL?
Only ECL. A stadium has been constructed over our plot of land.
State. Have you served?
Yes,
The
yes.
state is also.
No.
District magistrate is there, my lord. LR and
The district magistrate is there.
district magistrate is also there. 5 and 6.
Where is
We
the
have served,
service?
we have served. Everybody has received, only the respondent number 3, that parcel has come back with the endorsement refused. Barring that, everybody has received.
Mr. Dey, may I request you to appear? Respondent number 3, you must be representing him.
Yes.
Please serve a copy to Mr. Dey.
Very good.
I'll regularize his appointment.
Very good. Lordship is
Yes.
keeping it on some other day.
No, why?
Oh, very good.
It's your case. Let's see if we can deal with
Yes,
it.
yes, certainly. Lordship may kindly come to page 19. This is the record of rights. The plot number which we are concerned with is 645. Next page also continues till 21. Plot number is 645.
Yes.
Then at page 22, there's a family tree. The plot, how we have inherited the plot of land. I have stated it in my petition, and Lordship may get that particular at page 22. Page 23, we have been depositing the tax yet till today, 23 and 24. In 2018, Lordship, we came to know about this fact. We appointed a surveyor, a survey report was prepared. Lordship may kindly take up that survey report.
You
It's
are
at,
in possession.
yes. Annexure P3. The part which is encircled, Lordship may find plot number 645, the survey report. Kindly sees the date at the very bottom. And at the top, recorded owners. Amrita Gopal Chatterjee is petition number 5. We then made an application under the RTI Act. How did Eastern Coalfields Limited came to acquire this plot of land, and what are the documents in support of your title? Lordship may kindly come to page 26.
Yes.
Our specific queries, column 1 and column 2. How did Eastern Coalfields get the authority to commence construction of a stadium on our aforementioned plot of land? We have indicated the plot of land. Lordship may kindly find that the second paragraph of our RTI application, plot number 645. And the second query was, please supply the documents to show that Eastern Coalfields has the title in respect of the aforesaid plot of land. Now they give the reply at page 27. The senior manager.
Inherited land.
Yes. Answer. The answer to the first query. As per computerized land record maintained at Kunustoria area office, the plot number 645, Moja Kunustoria, jail number 54, measuring an area of 0.54 acres, is an inherited land of ECL. That means the owner of the land is ECL. Now comes to the answer to the second query. The title documents of the aforementioned plot is not readily available at Kunustoria area, but it might be available at the office of the Chief Mining Officer, Government of West Bengal. So they were not able to provide us the documents. Then in the month of December 2022, we made a representation that you were not being able to, that you have not been able to show us the documents. No acquisition proceedings have also been held. You have to grant us compensation at the current market value. This representation is still pending.
Yes.
My lord, this land was purchased, my lord, in 14th of May 1962 from my lord one Suhasini Devi, my lord, who is the wife of Noni Gopal Chattopadhyay, from whom they are claiming, my lord. Now, my lord, I have a title deed with me, my lord. I also have a arrest record of right. What he is showing, my lord, is the LR record of right. Your lordship knows, my lord, from record of right, you cannot establish your ownership. Only the deed can show the ownership, my lord. We have deed with us, my lord, which says, my lord, that on 14th.
So will you come back with a report in the form of an affidavit?
I can, my lord.
Annexing the copy of the deed?
Yes, my lord.
We need
I am
to
also
see
carrying
that.
today, my lord, and I can also.
With a copy.
An advance copy to the petitioner.
Yes.
Certainly. Certainly.
And Lordship may kindly grant us liberty to use an exception if any.
Good.
Advance copy.
Affidavit of service. Paragraph none appears for the state respondents. Mr. Dev, who is appearing, who is present in court, regularized court and copy service direction. Paragraph. It is contended on behalf of the petitioners that though they are recorded owners of the plot in question, comma, the Eastern Coalfields Limited has Limited claims to have acquired the said plot, though no plot, but no compensation has been paid to the petitioners for the same. Paragraph. Learned counsel for the ECL submits that the ECL purchased the plot in question from the predecessor in interest of the petitioners by virtue of a registered deed. Stop. Learned counsel seeks to submit a report in the form of affidavit in this regard, annexing relevant documents. Paragraph. Let the matter appear under the same heading on 14th August.
Can it be after 15th of August? I won't
Very
be
well.
in town.
18th? 18th August. Paragraph. Report in the form of affidavit be submitted on the adjourned date upon service of advance copy to the petitioners.
I'm deeply obliged.
Affidavit of service.
Advance copy.
16.
May please, your lordship. My lord, this is a peculiar matter. Land has been taken, but without any compensation. Long ago, my lord, a petition was moved. Kindly look at page, my lord, 17.
there is a direction for consideration of the grievances of the petitioner.
Page 17.
17. Usual order representation consideration. Then, my lord, consideration was done and it was held in our favor. Page, my lord, 20, bottom. The case is taken up for hearing on behalf of the RB, Ulberia subdivision and such and such. They state that at this moment they are not in a position to say anything regarding the construction of road. Consulted the relevant office records, gone through the connected spot enquiry report dated September 16, 2011, conducted and furnished by Sri S.J. Day and Sessions, surveyor attached with Howrah, LAG office, LA Collector General. He transferred from the said field enquiry report that the subject plots are involved by way of considering the constructing the road from Baxi Bridge to Kalighat constructed by PW Road. Such spot enquiry report is made part of the proceedings. Having heard petitioners as well as the representatives of the RB and the additional executive engineer Jila Parishad, and having Howrah being respondent in this case, consulting relevant office records and considering the fact as related in the relevant spot enquiry, I am convinced that the subject plots of land have been used by the RB PW Roads without their acquiring the same for construction of the road concerned and without paying any compensation for them. Accordingly, the matter is disposed of by directing the RB concerned to submit a proposal for acquisition of the case plots of land to the extent they have been used for construction of the road according to the existing government norms, a plain copy such and such. Then, my lord, kindly see the next page report. These are the, my lord, persons who inquired and came to the conclusion. Since then, nothing has been done, no compensation. Land has been taken, road has been constructed, but no compensation.
Well, the order has been passed in the year 2012. It is, my lord, admitted by the, as it appears from the, my lord, the annexure, page 2021, the district magistrate and collector Howrah heard the matter, and he has found that, my lord, the land has been used and directed the requiring body to, my lord. But till such a long time, after 10 years, he is approaching before this.
It is your responsibility also.
Yes.
That is not the grounds. The land belongs to the father of the petitioner. During his lifetime, he has never approached before the honorable court. After demise, my lord, after 10 years, he is approaching.
That is the trouble, my lord, without understanding the brief, reading the brief. Sachin Mandal, my father, filed the writ petition. Then kindly look page 22 into October 27-21. They said that we have made inspection. Every day we are going, my lord, we have got other functions. Every day I shall in the morning go to the district magistrate for 10 years. Then, my lord, kindly see, we requested in page 23 in 20, which resulted in 21 report. For the fault of the government, they are in fault, imposing the fault to the petitioners. Land has been taken, valuable land, man, it Howrah, Baxi area. Your lordship can direct the relay collector. No. To, my lord, take effective decision.
No, he has taken the decision. Requiring body is this. He will provide the fund.
PW Roads. You are representing the referring body also. So this has to be complied with.
Let it be considered by the PW.
Consideration is over. Now it is only compliance.
That is true, my lord. But his present moment without instruction, I cannot say nothing more than that.
If you want to come back with instructions, you can come back with instructions.
Because we want an
But he has not made any representation before the authority. আমি দেখে নিয়েছি ওটা গোলাম মুস্তাফা চিঠি
কে দিবে?
That is not the representation. That is the advocate's letter.
No. Is there any bar?
Yes.
You have to make a representation.
No, we have.
Advocate's letter will not be considered.
We have written. Lawyer cannot make any demand.
No.
It's a demand, it's a demand of justice.
দিতে পারেন না।
There should
No,
be
we have
redress
demanded,
first.
because representation part was over, it is in our favor. We demanded that you do it. They have not done it.
Yes,
I shall come back to the.
you'll come back.
Page
with the-
24, what was your?
Let him come back with instructions. Mr. Bandyopadhyay wants to come back.
Because we want an end.
Absolutely.
এন্ড তো নিশ্চয়ই হওয়া উচিত, টাকা পাওয়া উচিত আপনার, আমি তো বলছি না পাবেন না।
It is submitted on behalf of the
ঠিক আছে।
করছেন তো
petitioner
Sure.
that
তোকে এক সপ্তাহ লাগবে।
though
এক সপ্তাহে ভয় নেই,
the
আপনি 10 বছরের টাইম পাননি সময় দেওয়ার।
district magistrate and collector, Howrah, by an order passed on 12
20% interest সহ দিতে হবে। Bank, housing,
আচ্ছা আপনার কত পার্সেন্ট থাকবে? ভালো হবে।
তুই 19% দিলে আমার 10% থাকবে হচ্ছে।
The order is on 12th September 2012.
Yes, yes. That
12th September 2012 held that the
yes, yes, September 12.
land of the petitioner has been utilized by the requiring body, that is, the PW within bracket roads, without acquiring the same or paying compensation to the petitioner.
Signature is to be, sir.
প্ল্যানিং কি করবেন? প্ল্যানিং তো করবেন, প্ল্যানিং করবেন, চিঠিতে কিন্তু প্ল্যানিং
No proposal for acquisition of the plots was made by the requiring body to the petitioner despite direction of the authority in the said order. Paragraph, learned counsel for the respondents seeks to submit a report in the form of affidavit in this regard. Paragraph, let the matter appear under the same heading on 14th August.
14th August, my lord, 15, Tuesday. 14 August মানে হচ্ছে সেদিন না আসার চান্স বেশি।
কেন আসবে না?
After
কেন আপনি আসবেন না?
গায়ের লোক তো দেশে
16th,
yes, yes.
16th August.
যাবেন না কোনো ঘুরতে যাবেন, বলুন কোথায়?
Next.
No, because my lord, Saturday, Sunday, Monday.
So you'll take
ঠিক
an
আছে, যান না,
extended
ঘুরে আসুন
weekend.
না, তারপরে হবে।
Because I'm from Murshidabad rural area. I
You'll
will-
take an extended weekend.
Yes, yes. So I'm grateful, man.
Next.
I have confidence upon him. my lord. তাড়াতাড়ি করুন।
বললাম তো।
My lord, this is my application, my lord. My lord, will recall this is that matter relating to, my lord, a contested allocation of land. A long-term settlement was supposed to be entered into, my lord. The private respondent, my lord, was contesting my prior allotment. My lord, in the meantime, my lord, the parties have entered into a settlement, my lord. I am told an agreement has also been formally entered into, my lord. I was praying for 4 weeks' time, my lord, to finalize the, my lord.
Agreement is between us.
Yes.
I suppose I have not seen. I do not know whether government will accept this or not.
Yes.
Whatever it is, the order is in my favor. It stands, well, the allotment is in my favor. They have purported to challenge that allotment. Now, my lord, I really don't know
My lord,
how the settlement, it is only up to the government now.
Settlement is between
between
you,
the
your
private
client,
parties, my lord.
the
My lord,
private parties.
I do not know, my lord, how that will result in a modification of an order already passed by the government.
my lord, here, my lord.
That is it, made. Well, I am not going into, my learned friend is
So
asking
why
for
don't
time.
you come back when there's a chance of
Yes,
settlement?
yes,
like
I
this?
shall. আমাকে একটা কপি দিয়ে দাও খালি।
এগ্রিমেন্টটা পাঠালে তবে তো আমাদের কাছে।
তাই তো
It is submitted on behalf of the petitioners
আমার order আমার
that talk of settlement is going on between the private respondent and the petitioners. Stop. Learned counsel seeks accommodation. Paragraph, let the matter appear under the same heading on 18th August.
My lord, 18th August. Deeply appraised, my lord.
Council, only petition.
18.
Yes, my lord, may I please your lordship? This is the affidavit of service. Only state is the contesting respondent.
And for this state.
My lord, the short point involved in this petition,
Yes, ma'am.
my lord, the one Deepak Datta, since deceased, got an allotment in respect of a plot of land, leasehold plot of land lying and situated at Kollani.
At
Kollani. Lease agreement was executed after completion of payment of premium, salamis, rent, everything. Possession was handed over to the said Deepak Datta since deceased. Now, before his death, he executed his last will and testament in favor of the petitioner.
Hello.
No, municipality is not the party.
Is a party. Three.
Yes, municipality party. Municipality party.
Where is the service upon the municipality?
Yes, I have served.
I just check. It's served, yes.
Lordship. So therefore, my lord, what happened? So before his death, he executed his last will and testament in favor of the present writ petitioner before your lords. She obtained probate from this honorable court, and after obtaining the probate, she submitted the same along with all other documents before the respondent authority concerned, the estate manager Kollani, being the respondent number 2 herein in this writ petition, my lord. Now, my lord, what happened, my lord? Lordship, if your lordship kindly turn, please take trouble to straightway come page 36 in your lordship's brief.
Yes.
My lord, the probate was granted thereafter through lawyer, through learned advocate. It was communicated to the concerned respondent on 18th of July 2019. Has your lordship got it? My lord, thereafter, the petitioner sent application on 4th September. Lordship will find at page 37, 2019.
You're asking for mutation.
Lordship, only thing. And I am well covered by the judgment of this honorable court. Mr. Dey is also well conversant about that. A judgment passed by the Honorable Justice Horish Tandon. Thereafter, the state preferred appeal, but the judgment was confirmed by the Honorable Division Bench presided over by Honorable Justice Vishwanath Samaddar. And I have got the copy of the judgments. So, if I am entitled to get the mandamus to be exercised by this honorable court at this stage, and the petitioner is a senior citizen suffering from cardiac problem. And this is the judgment of Honorable Justice Horish Tandon. The very same points have been discussed and issued. Lordship, if you Lord kindly consider the last paragraph of the judgment, that this court does not find any failure on the part of the authority to execute the document as required in favor of heirs or successor under the law, as mere death of an allotee before the execution and the registration of the lease deed does not automatically or ipso facto creates any bar. Furthermore, the name of the allotee was duly recorded in the records of the maintained by the estate manager. Therefore, a person who derived the right and title through such person can be substituted in her place. This court therefore cannot agree with the stance of the estate manager that since the lease deed was not executed in favor of the testatrix during her life, the petitioner's right cannot be recognized, even if probate is granted by a competent court. This court therefore directs the estate manager to consider the said application afresh, as the order imputed in that particular they have rejected.
Now, here also, the deed was not registered
No,
in favor of the erstwhile owner.
no, my lord. In that regard, my lord, kindly see if you also kindly take trouble. Page 19. The agreement was executed.
But the deed was not registered.
No, because before the execution of the deed,
He expired.
he expired. I'm grateful to you. But if you also kindly turn page 19. My lord, if you also kindly take subclause H. H. Has you also got it? H.
Yes.
My lord, suit the lessee stroke lessee die after having made a bequest of the leasehold premises and the building to be erected thereon in favor of more than one person or die intestate, having more than one heir or heirs. In such case, the petition persons to whom the leasehold premises with the buildings thereon be so bequeathed, or any right to have a partition of the same may be meets and bounds, or they shall nominate one person amongst their number in whom the same will vest. So therefore, the petition, the erstwhile lessee was well entitled to execute a will before registration of the lease deed, because that cannot be a bar. This is the whole case. Several representations, applications were made, my lord. Even if, my lord, one thing, they have, the government now has started application on through online process. If your lordship kindly turn page 40. After submitting the applications on physical mode, thereafter, page 40, the online application was made and the grips challan were downloaded, the payment were made in favor of the estate manager.
Yes, Mr. Dey.
Well, that is the agreement. Agreement is not the ownership or anything else.
But I'm covered by the judgment of this honorable court.
My lord, that agreement, the only agreement is there. There is no any lease deed was executed by the authority, my lord. So he has not any right to say anything else.
Please, have you seen this order?
My lord, yes, my lord, because they appeared in that matter before Justice Tandon. তোমরা একটা অ্যাপিলও করেছিলে অমিতেশকে দিয়ে সেই অ্যাপিলও হেরে গেছে।
My lord, I must see this after that, my lord.
Let him come.
My lord,
my lord, there is a, my lord, according to on the strength of an agreement, my lord, there is no any execution of the deed. It is not
necessary, my lord, not necessary, because agreement is so clear.
Please take instructions
Yes,
because
my lord.
law permits, I think.
Yes, my lord, only for that reason, my lord, that is your lordship wanted to order.
দাদা রেখে দিও জাজমেন্টটা।
Affidavit of service.
দেবো কি আমি দেখবো না?
তোমাকে দিলাম,
By the
তোমাকে আমি এত হেল্প করি, তুমি তো আমাকে
Paragraph
হেল্প করো।
none appears for the third respondent.
ওটার এগেইনস্টে স্টেট অ্যাপিল
Paragraph
করেছো,
it is
হেরে গেছো।
contained on behalf of the petitioner that
ছেলে ভালো।
the plot in
কাজে
question
করবে কি এটা?
was allotted
কত নম্বর
to
আছে আজকে?
207
কত থেকে শুরু?
one Deepak Kumar Dotto
দেখবো চেষ্টা করছি।
নাম দিয়ে দিয়েছো?
by virtue of an agreement for lease executed on 15th June 1967 by the estate manager, Development and Planning Department, Government of West Bengal. Stop. The West Bengal, and possession of the plot was made over to the lessee on 17th May 1968. Stop. Prior to execution of the deed of lease, the lessee expired upon executing a will in respect of the plot
My
in
lord,
question.
we can, my lord, that
In favor of
that respondent number 2 will consider your case in terms of the this deed.
In terms of the judgment passed by this honorable court.
Yes. My lord,
matter of
your lordship can dispose of
It
this
can
matter
dispose-
directly.
I'm very much grateful to my learned senior friend.
Yes, my lord, I have seen all
yes,
after
yes.
seeing that. I can
কি
find
বললেন?
the matter. Immediately I gonna.
This is the geniusness of Mr. De.
In favor of
What
the
is it, ma'am?
petitioner,
তাহলে তুমি কি আর
and the petitioner obtained probate of the said will.
এটা কিন্তু প্রডিউস করবে। আমি এই দুটো মাই লর্ডকে বলে দিচ্ছি এর মধ্যে দিয়ে দেন।
The petitioner applied before the concerned authority for execution and registration of deed of lease in respect of the plot in question in her favor, and also for mutating her name in respect of the said plot. Stop. Several representations submitted by the petitioner before the authority in this regard fell on deaf ears. Stop. The petitioner prays for a direction upon the authority to execute and register a deed of lease in her favor and mutate her name in respect of the plot at the earliest. Paragraph. Learned counsel for the petitioner refers to an order passed by a coordinate bench of this court in a similar matter on 29th August 2018 in WP 12222 within bracket W of 2018, wherein in a similar fact situation as in the present case, comma, the court directed the estate manager, comma, Kollani, to consider the application of the petitioner afresh and granted liberty to the petitioner to pray for execution and registration of the lease deed in respect of the plot which was the subject matter of the said writ petition. The orders refusing the prayer of the petitioner were turned down by the learned court. The orders refusing the prayers of the petitioner were turned down by the learned court. The petitioner, where is your representation?
Lordship will first representation. First representation, your Lordship will find at
37
on 4th September 2019, thereafter 18th November 2019. Lordship, kindly turn page 43. The last representation 27 January 2023.
Let this be considered in
This
that
is,
case, in terms of the judge.
Yes, Lordship, I'm great. I'm great.
Mr. Desh, shall I record your submission that it should be considered in terms of this judgment?
Your Lordship can pass the order without
recording.
Yes, ma'am. Lordship can pass the order.
The paragraph 1, the petitioner submitted a representation before the concerned authority learned counsel for the petitioner seeks a direction upon the concerned authority to consider the representation submitted by the petitioner on 27 January 2023 in the light of the observation made by the coordinate bench in the order passed on 29th August 2018. Paragraph, upon consideration of the submission made on behalf of the parties and material on record, comma, this court is inclined to hold that since the petitioner has stepped into the shoes of the erstwhile lessee by virtue of the probated will in her favor, comma, the mere fact that no deed of lease was executed in favor of the erstwhile lessee during his lifetime cannot and does not stand in the way of the authority in executing and registering such deed in favor of the petitioner at present. Paragraph in view of the above, comma, the writ petition is disposed of, directing the
Respondent number 2, Mali.
concerned authority being the
Respondent number 2.
being the second respondent herein, comma, to consider and dispose of the representation submitted by the petitioner dated such and such within 1 month,
Within 2 months, Mali.
within 2 months from the date of communication of this order, upon affording reasonable opportunity of hearing to the petitioner, comma, in accordance with law. Paragraph in the event the representation is decided in favor of the petitioner, comma, the concerned authority shall take all consequential steps thereto within a month thereafter. Oh, petitioner, in the light of
Yes.
disposed of within 2 months from the date of order, upon consequable তার আগে করুন, within 2 months from the date of in the light of the observation made by this court in the order passed on 29th August 2018 in WP 12222 within bracket W of 2018 and upon affording reasonable opportunity. Chatling. 19 disposed of একবার বললাম আর বলা দরকার no order is sir ওই copy Yes.
There is a fixed matter. I am appearing on behalf of the Bardwan Development.
Fixed matter at 12:30.
Yes. 56, item number 56.
Yes. 56 টা দিন 56
Both of my learned friends are ready today.
Fighter 8537.
দাদা দেখো এটা করবে তো আমি যে ঘুরেছি
Mr. Talukdar will make his submissions first.
We have filed our respective affidavits. There, we have shown in the 2 acquisition proceedings, the acquisition was complete and the compensation amount has been made. So in respect of 1 acquisition, just I'm here to over. In 1 acquisition proceedings, 0.82 acre was taken, excluding the structural part. Then subsequently, another acquisition proceedings, in that particular acquisition proceedings, 0.06 was taken. So it is in respect of Bata that number, as my lord knows, the plot which comes Bata, which originates from the parent, that should appear in the Bata dag on top. If from dag number 1 Bata dag is coming out or carving out, then it would be 1 by something. And that Bata, which is underneath 1 by something, that should be treated actual the dag number. So in our case, my lord, the Bata dag is RS 2454, Bata 2759, which can be called as 2759. যেটা সবসময় সত্যজিৎ তালুকদার বলানোর চেষ্টা করে, যেটা আমি বলাইনি।
Yes.
So now, my lord, in the kindly come to, my lord, my
The
affidavit.
petitioner completed on the.
No,
earlier
no,
date.
no,
Well,
not at all.
I'm just giving a
Not at all.
overview so that, my lord,
You are placing your defense before I start.
He wants to leave. Another matter is being called, that is why.
my lord, let him.
On the last occasion, my lord,
Let him complete his submissions today. Come, you start on the next day.
on the last occasion, my lord, I was placing, my lord, the report submitted by the state respondents and the KMDI in the form of affidavit.
Yes.
Report that for the purpose of, my lord, recollection, my lord, of your lordship, my lord, I am showing one document, my lord, that is, my lord, my purchase deed. My lord, that is at page, my lord, 24 of my writ petition.
Yes.
Lordship will find, first of all, Lordship kindly, page 24, Lordship kindly noted that the Kovala Grohita, that is the purchaser is Pramod Ranjan Datta, Pita Mrito Kamakha Ranjan Datta. Well, this part is very important because I will show your Lordships one document how the, my lord, state respondents, my lord, exercise their discretion. Now, my lord, at page, my lord, 29, your lordship will find that this deed was executed and registered in the year 1968.
Yes.
And my lord, at that relevant point of time, this Bata dag was, my lord, was in existence. Because the predecessor of the petitioners purchased the property showing Bata dag. That is, my lord, 2354 by 2759. And in that Bata dag, there were several plots. Out of several plots, the predecessor of the petitioner purchased one plot, that is plot number 11. That is measuring 3 kata, 2 chitaks, 5 square feet.
Where is the Bata dag recorded in the deed?
My lord?
The Bata dag is not recorded in the deed.
Yes, page 29.
Yes, where is the Bata dag?
My lord, that is 2354 by 2759 at the schedule. In the schedule portion, your lordship will find 2354 or my lord, kindly have a look, my lord, page 27, page 26. Page 26, lordship kindly
page 26
of writ petition. Page 26 at the first line, your lordship will find.
Page 23.
Page 26 at the first line. জরিপের 191 নম্বর খতিয়ানে 2454 by 2759.
23 is the affidavit.
26, my lord. 26. First line.
Oh, they have recorded it like that.
My lord. So in the year 1968, it was the Bata dag was existed and my predecessors purchased the, my lord, from the Bata dag. Now, my lord, it is a case of the state respondents that 2 acquisition proceedings were initiated. First of all, my lord, in the year 77-78, much later, my lord, than the, my lord, purchased by our predecessor. Well, in the year 77-78, the acquisition proceeding was started, and 83 it was notified. First phase, my lord, 82 decimal of land from dag number 2759, not Bata dag, 2759. 0.82 acre was, my lord, acquired.
I'm sorry to interject, my lord. As I said, my lord, 2454 Bata 2759 and 2759 both are same.
No, that I can understand, but in the award sheet it is not there. I will show that document. Now, my lord, after, my lord, the acquisition, well, it was general, my lord,
order from the government that, my lord, I have annexed to the my writ petition, my lord, annexure P231. So, my lord, what happened in this case? Out of 88, my lord, 82 decimal or land was, my lord, acquired. Bulk land was acquired. Now, my lord, what was, my lord, not acquired? That is the, my lord, portion covered by structure. Because our predecessor purchased the property in the year 1968. Since then, she constructed Kacha structure there and started living there with family members. That's why, my lord, it was not within the acquisition proceeding in the year 77, 78, which was notified in 1983. Now, my lord, this is the general order. Lordship kindly have a look, annexure P231. It is, my lord, applicable to all, my lord, which portions were covered by structure, 2.5 katas were exempted from acquisition. Not for our land, it is for all the lands in that Mauja. Lordship kindly have a look, my lord, with reference to the above, this is to state that the ceiling limit of 2.5 kata of land regarding exemption of land appertaining to existing structure, including structure built before July 1978. Our structure was built before 1978. That I will show your lordship the documents. Was intimated to the LA collector by this office memo number such and such dated September 2, 1980. I am endorsing a copy of this letter, enclosing a copy of the above letter, the LA collector again. So, my lord, this was done in respect of all the plots that 2.5 katas would be exempted, which were covered by structure. My lord, our land was, my lord, covered by structure. My predecessor were there, my lord, since 68. Now we are in possession. Now, my lord, we applied for, my lord, no objection so that we can develop our property. Now, my lord, the authorities refused to, my lord, to give any, my lord, no objection. Then, my lord, the petitioners have been compelled to approach your lordships. Now, my lord, the respondent, state respondents and, my lord, KMDA now have stated case that another LA proceeding was started in the year 1991 for only 0.6 decimals of land. My lord, I fail to understand, my lord, how, and I put this question, my lord, how this small quantity of land has been utilized for public utility. For what purposes, my lord, this was, my lord, acquired. Now, my lord, I will show you lordship, my lord, the report submitted by my lord, the state authorities. That is, my lord, affirmed on, my lord, 20th June 2023.
Yes, 20th January.
20th January. 20th January in the name of Mr. Supratim Dhar. Because two affidavits are there, my lord.
Oh, this is Abhishek Dishas.
No. No, Abhishek Dishas is affirmed. Learned advocate is Mr. Dhar. Backseat.
Affidavit by?
Affidavit by, my lord, Abhishek Dishas, were a backseat in the name of Mr. Dhar.
Other matters be released.
It will take time. Time level.
What are other matters be released?
You'll take some time.
Some judgments are there, my lord. I have, my lord, one by exception. No documents are there.
Other matters released for the day.
Now, my lord, kindly.
I'm not finished today.
Now, my lord, kindly, my lord. Para 3 of their, my lord, affidavit, kindly have a look, my lord. That your respondent state the following facts of the case in brief. The suit plot number RS2454 by 2759. Now, my lord, they are using the Batadak number. Lordship, kindly note it. They are not saying 2759. They are using the Batadak number RS2459 54 by 2759, measuring an entire area of 0.88 acre of Mauja Kosba, jail number 13, appertaining to RS Kotian number such and such, was requisition under section 3(1) of the West Bengal Land Requisition and Acquisition Act 1948, Act 2 of 1948, hereinafter referred to as the Act 2 of 1948, by virtue of LA case number such and such, for ECAD project of the Calcutta Metropolitan Development Authority, now KMDA, and the possession of vacant portion measuring an area of 0.82 acre of the said plot, excepting the area covered by structure, was taken over and handed over to the requiring body, CMDA, now KMDA, on 15/5/1978. Accordingly, notice under section 4(1)A of the Act 2 of 1948 was published on 29/11/1983 in the Calcutta Gazette, extraordinary by number such and such, dated 21st November 1983. That means, my lord, on 21st November 1983, the property was vested to the government. But possession was taken, my lord, as my lord purportedly has claimed in the year 1978. Now, my lord, another next para, another offshoot case being LA 2 of 1993-94 was initiated for the purpose of taking over possession of the remaining structural portion measuring an area of 0.06 acre of the suit plot, which was found affected by the road alignment, internal feeder road, and possession of the said area was taken over and handed over in the requiring body, that is KMDA. Also subsequently, notice under section 4(1)A of Act 2 of 1948 with respect of 0.06 acre of suit plot was published in Calcutta Gazette on 13/10/1995 by number such and such, dated 21st September 1995. Thus, the entire area of the said plot number 2454/2759, again data number they have referred, that is 2759, measuring 0.88 acre of Mauja Qasba, jail number 13, was fully acquired by virtue of LA case number LA2 such and such, with handing over of possession of the same to the CMDA, now KMDA, on 15/5/78 and 13 March 1994 respectively. Accordingly, the award was duly declared in respect of 0.82 acre of the said plot, along with other plots in LA case number LA 205 of 1976-77 on 21st August 1989 in favor of Nagendranath Das, son of Kirot Chandra, and others by award serial number 30, and the said award amounting to rupees such and such was deposited in the Learned Court of Special LA Judge at Alipur by check number such and such, dated such and such, as revealed from the noting against award in the award copy itself. My lord, in terms of Act 2, subject to your lordship's correction, my lord, in terms of Act 2, if, my lord, for argument's sake, the award was declared, whether it is a valid award, because my predecessor purchased in the year 1968, and my lord, they cannot say that his name was not available, because I have annexed all the documents showing recording by the Panchayat Samiti, by the corporation, by the municipality. Not only that, my lord, they have annexed one document, they have forgotten. Well, in that document, the name of my predecessor is appearing. So that name was easily available to them. But, my lord, they cannot show that section 3, which is mandatory provision, my lord, in terms of the judgment of the division bench, my lord, of this court, that section 3, service of section 3 order is mandatory in nature, but they cannot show that any no order was served. That I will come later on, my lord.
This is in case of the subsequent
Subsequent and previous one also, because of the fact, my lord, as per their claim, the entire DAG number was covering by 0.88 acre. Out of, in the first phase, 82, in the second phase, 0.6. Because my predecessor purchased, my lord, 3 katas and 2 chitaks, suddenly it covered by the remaining portion, because it was covered by structure. That's why in the first phase it was excluded. And they have, my lord, practically overruled their own decision, and, my lord, 2.5 kata was exempted in case of other. But so far my case is concerned, that was not applied. That was not applied, man. Now, my lord, kindly have a...
For a moment, my lord, may I interrupt? What argument my learned friend is advancing, that is challenge to the second phase of acquisition. My lord, this gives a fresh cause of action, having regard to the prayers made in the writ petition. He cannot argue that without pleading and without any prayer.
No, that is a factual aspect. This is on record.
It is not
this
only
is apparent on the...
You are arguing on law.
To the first part.
Without pleading, without prayer.
No, my lord, this is, my lord, lordship kindly appreciate, my lord, the documents. Then, my lord, I put this question to myself. No, Mr. Tiger, let me submit. No, let me submit.
First phase of.
No.
first phase of
Then why you have
acquisition,
annexed this document? Why you have annexed this document?
I have
Why?
annexed
That's why.
liberty-
Because my
liberty-
lord kindly
liberty
appreciate,
gives you-
my lord kindly appreciate, my lord, before filing of their report, my lord, these documents are not with me, so I did not get any opportunity. But as my lord, my learned friends have annexed those documents, I have to deal with that. My lord, I have to deal with that.
By
Let
way
them-
of filing affidavit,
No.
one cannot, my lord, improve
The
his case.
entire plot is
88.
So you earlier said that out of 0.88, the structural part which belongs to you was left out.
My lord,
The state comes up with a report saying that they have subsequently acquired the structural part
my lord,
also.
my lord.
So that means resultantly the entire 0.88 has been acquired.
Yep.
You have prayed for demarcation of your portion. What is your portion?
Well, that is within my lord 0.8, 0.06.
The state says they have acquired the entire plot subsequently.
My lord, that is I have challenged the my lord the acquisition proceeding because of the fact.
Where
My lord,
have you challenged the acquisition?
my lord, I'll show your lordship the my lord that is not done.
It can't be.
My lord,
When
that
the
is
petition was filed, this information was not available to him. Now,
No,
after I
this petition
disclosed, even on the last occasion, when
That's
I
right.
said,
Let the petitioner answer. And
This
that's why I'm
petition
putting
about
this
that.
question. That's why I'm putting this.
Without wasting that.
court's time, my lord, he
Because
should.
you cannot ask for demarcation any longer. You have to challenge the proceeding in itself.
No, my lord, what is
Not
my
just
prayer, my lord?
Demarcation.
Not a single pleading even, not a ground.
No,
pleading, no prayer. How can the court go into that aspect?
প্রেয়ার দেখো, তুমি তোমার প্রেয়ারটা দেখো, তাহলেই বুঝতে পারবে।
The court is empowered to, in absence of pleading, grounds and prayers.
Primarily, your prayer is demarcation.
Primarily why it was not demarcated.
It's demarcation. So now your prayer goes, isn't it? You have to make a fresh prayer on a fresh cause of action.
Came to know after this report was filed.
All your prayers are on demarcation.
My lord, that is the fact because the relevant point of time,
You are not aware of this.
aware of the fact, my lord.
It's a fresh cause of action. Demarcation will not help you now. And there is no question of demarcation because the state says they have taken the entire property. So what do you demarcate?
My lord, if I pray for my lord amendment of the writ petition because of the fact, my lord, if my lord subsequent event comes into the picture. Yes, amendment. Because of the fact, my lord, because already they have, my lord.
This amendment will change the nature and.
Not at
character
all,
of the
not at
petition
all,
itself.
not at all.
In the writ petition, he sought that 0.88, out of that 0.82, boleni, 0.82 was acquired. So kindly demarcate the unacquired portion, that is 3 katha and something. Now he is coming by way of an amendment by saying that, hang on, I want to challenge the second land acquisition proceedings. Altogether, nature and character will change.
No, not the change of nature and character.
Not-
Because of the fact, my lord, as the fact was not within my knowledge, I could not, my lord, challenge that acquisition proceeding because it was within my knowledge that
Why don't you file a fresh comprehensive writ petition?
in that event, my lord, they have to again file opposition. That's why, my lord, because already they have,
This is not an opposition. It's a report.
my lord,
And the report will be different in that case.
my lord, report means that the same documents will be there, rely, but it will take, but if the, my lord, amendment is done, because I'll show you lots of the judgment, my lord. In this case, my lord, if certain things,
The amendment has to be in consonance with the present writ petition.
but that is, my lord, there, because acquisition, my lord, kindly have a look to the prayer portion, my lord. Though I have, my lord, prayed for,
It's only demarcation, nothing else.
এটা কোনটা আমাদেরটা তো?
There cannot be any challenge to that proceeding. You are not aware of.
prayer ground.
So that the actual status of acquisition can be ascertained upon such joint demarcation to be held and to prepare joint demarcation map of sketch plan showing the area.
Demarcation. It's all demarcation. All your prayers are demarcation. File a fresh writ petition stating the entire facts. Your cause of action changes. It is not,
Certainly, well, certainly because of the fact,
it's a different cause of action altogether.
certainly because it was not within my knowledge,
Now you challenge the acquisition proceedings.
particularly the number with regard to the particulars of the land acquisition, all these things, because now all the documents,
It is not in the reports.
Everything we have disclosed.
everything they have disclosed. Now it is,
That has to be challenged now, isn't it?
If
It
law
is no
permits,
question of,
if law permits, I must say if law permits, because we will be taking the point other.
of delay.
sir, you can, suddenly you can,
No, he is drawing information from your report.
Not only the delay, other points are also.
certainly.
So let him come back. We'll deal with the issues.
But then my liberty, my lord, kindly give my lord to, because the fresh cause of action arose, my lord.
Fresh cause of action liberty is not necessary.
My lord, why, my lord, fresh cause of action in view of the documents they have disclosed in this writ petition?
Yes.
Otherwise, my lord, they will, my lord, raise a issue that it is, my lord, barred by res judicata.
You, res judicata, where is res judicata coming?
My lord,
This
Because
issue
res
is
judicata
not
comes.
getting adjudicated by my lord. Their prayer was demarcate. Well, after the
And
disclose.
liberty is also not required because it's a fresh cause of action.
absolutely. My lord, kindly record that fresh cause of, it is my submission, fresh cause of action has arose.
Yes.
That can be recorded.
Liberty
It is submitted on behalf of the petitioners that on perusal of the reports in the form of affidavits submitted on behalf of the respondents, comma, the petitioners have learned that the entire Not in question.
objection of it.
কি বলছিস?
Amendment
তুমি judgment দেখাও।
Amendment allow হলে division bench যাবে।
CS tag number
তাদের তো তোমার মুখে সুবিধা।
252454
Division bench এ
slash
judgment দেয়।
2759 comprising
What he passed on?
the entire is 0.88.
Amendment is allowed, but against the division bench.
The entire plot is 0.88.
0.88. First acquisition 0.8.
No, the entire is 0.88.
0.88.
Comprising 0.88 decimals.
Decimals.
Have been acquired by the state respondents. Learned counsel, learned counsel for the petitioner. Learned counsel further submits that since such knowledge has given rise to a fresh cause of action, comma, the petitioners seek to challenge such acquisition in a fresh writ petition. That should be sufficient.
My lord.
Second phase of acquisition, because in this state petition, first phase of acquisition is admitted.
Yes, such, yes, challenge the second phase of acquisition.
Kindly, my lord, kindly mention that. The LA case number.
Challenge the acquisition, VD LA case number.
VD LA case number, my lord. LA 2 Roman 2 by 2 of 1993-94 at page 3.
VD LA case number, VD LA Roman 2/2 of 1993-94 in respect of 0.06 acres of the plot. এর আগে decimals acres করো।
না না আমি আগেরটা
0.88 acres করো, হ্যাঁ। 0.06 acres of the plot. এর আগে 0.88 বলেছি, ওটা acres করো।
সেও অনেকে যাচ্ছে আমার ফিরে যেতেই পারে আসতে
The acquisition VD LA case number in respect now. VD LA case number so also in respect of, in the plot. The petitioners seek to withdraw the present writ petition on such ground. Paragraph in view of the above, the writ petition being WPA such and such is dismissed for non-prosecution. There shall however be no order as to cause urgent certified website copy. Bad luck.
Sorry, my lord, 8 minutes time, my lord, we have wasted.
Earlier
Your
occasion,
lordship.
because I tried to.
Even I tried to point.
Hey, I also tried to convince, but you.
Anyway, come back with a fresh.
What is not permitted under the law? Unnecessary exercise.
Release to অন্যগুলো। রেখে দিন, কোথায় গেল?
Judgment গুলো তো না না এখন দেবো কেন
বাকি আছে স্যার একটা কোশ্চেন ফাইল টাইপ করতে হবে আর একটা বাকি আছে যেটা আমি এটা আরেকটা স্যারের একটা দাঁড়াও
Yes.
এটা রাখলি তো দর্শনে কোটে এসো ভেতরে হ্যাঁ 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 তাতে তাতে বিটগুলো নিয়ে এসো না না আচ্ছা আচ্ছা হ্যাঁ হ্যাঁ ভালো হুম হুম আচ্ছা কথা হয়েছে পরশু কথা হয়েছে আমি বিকেল 5টার পর কথা বলি 5টা না না 5টার সময় সেকেন্ডারে বসে মাপো কথা আজকে আমার কথা গেল মাথা খারাপ হয়ে যেত হিন্দির ওপর এটা চেষ্টা আছে মানে মিক্সটা তো একই তো হবে না বলছো দেখো না চান্স আছে কোনটা আগে বন্ধু বলে করেছিল না এটা দেবো কেউ করছে ওই সেম দিতে পারবি দিতে পারবি কার হয়ে ফেলতে আমি হেনের আমার আমি যেরকম তোমাকে দিয়েছি দেখো এটা সেম বলছি যেটা ছোট বন্ধা করেছিল ওই বন্ধটা হ্যাঁ বুঝছো কেন কেন বন্ধা বলছিল একজনকে কিন্তু এটা হচ্ছে যে যাকে প্লেস করছিল তারই তাই তো চান দিতে হবে একবার রিজেক্ট আছে কবে অল অর্ডার আছে রিজার্ভ করতে একদম থাকে বেলগুলো দিতে পারে এরপর নেই রাখ এরপর হ্যালো হ্যালো হ্যাঁ বলো না বলো তো অনেকক্ষণ আগে জানি না আমি তাহলে ছাড়ো পরে ফোন করতে না না বাহার জায়গা হয়েছে কি এই এলাকার পর রিজেকশন হয়েছে বেঞ্চ চেঞ্জ হচ্ছে বেঞ্চ চেঞ্জ হবে কি শুনতে যাবে না এলাও হয়েছে 3-4 মাস আগে জুলাই চলছে তারপর 2 মাস বলবে যে আমি এটার সঙ্গে সেম করতে নিয়ে আসবো তারপর সবাই করতে বললে করতে হবে না না তো তুমি যেটা বললে না রিজেকশনের একটা রিজেকশন হবে Election. Yes, dismiss.
এটা ওদের
আমার কাছে আছে আমি চার্জ একজন আছে যে কোনো একজন হবে দুজনই আমার কাছে এরা তো প্রপোজিশন আছে এটা ছিল না একটা কনস্পেক্ট ইয়ে হয়েছিল রিজলভ হয়েছিল বলছে Yes. আমরা কি অবস্থা হ্যাঁ বলুন এই কেসে দেখার জন্য কি আমার আইসিআইকে দেখাতে আজকে একটা পুরো ডিপেন্ড করে বলো তুমি সেটা করে ক্লায়েন্ট আর যদি গল্প না বলতে আপনার কাছে একে দুর্গাপুর স্টেশন থেকে অ্যারেস্ট করে হে করুন কেন একে অ্যারেস্ট করে তোমার চার্জ বলুন চার্জ করে চার্জ দিচ্ছি কারণ না বারো বাইশ লাস্ট রিজেকশন কপি দেখাবো আমি রিজেকশন করিনি আমার আগে নিয়ে চলে গেছে কমিটমেন্ট চার্জ পেমেন্ট I'm ever ready. Don't really ask me to Jana. তুমি কি একটা গল্প এটা অলরেডি গল্প একটা বলো গল্প জিজ্ঞেস পরে ওই দিলে বল হাতে করে পুরো একটা হাইকোর্ট এতটা আর্মস নিয়ে যাচ্ছিল
কথা কেটে যাচ্ছে কথা কেটে যাচ্ছে
তো ফাইল দিয়েছি তোমার একটা
হ্যাঁ বল
তারপরে
বল
লাইসেন্স কই
ঠিক আছে টাকা বলেছিল তিনের তোকে দেবে হ্যাঁ তোকে 3,000 তোকে দেবে হ্যাঁ নিয়ে নিস না না নিয়ে নিস বলে নিয়ে নিস তুই নিয়ে নিস আর বলো
জায়গাটার নাম করলে
টাকা নিয়ে
হাজবেন্ডই সব জায়গায় ভর্তি
ডকুমেন্টস আছে এখানে আছে এগুলো বেলা এগুলো বেলা এগুলো বেলা
আর কিছু কিছু ডকুমেন্টস কিন্তু
ये था रिजेक्शन कॉपी गलत नामा এমন বেলা
যেমন দুইজন চেক সব পাঠাতে পারি আর ওই যে সিম্বল হ্যাক বলেছেন আপনি মেল রিপটা নিয়ে আসছেন
ये की মানে ये सुनने की साइन लियोने हस्बैंड नहीं हां এটা ইয়ে সুন্দর করে
হ্যাঁ
এগুলো দেখছি
যেটা আমার
এখন কি দেখবো এক একটা পেজ বসতে
কালকে
জেরক্স কপি দাও আমি এটাকে এখন পড়া সম্ভব কাজ কপি সব সমস্ত শেয়ার স্পেশাল
ওর সাথে চালসে পুষে দেওয়া
হ্যাঁ সম্ভব আপনি একটা জেরক্স করে নাও না কেন যখন একটা জেরক্স করে নাও
আমাদের ব্যবসা ছেড়ে এটি
আগে নেই তো
আছে বলো পাঠিয়েছি তো হোয়াটসঅ্যাপ ছোটবেলা হবে হ্যাঁ এই শনি মন্ডলের একটা পয়েন্ট
শুনে হলে একটু পেলাম
তবে একটা জিনিস দিয়েছে
আরে ও 4-5 দিন জীবিত ছিল। হ্যাঁ, সাফল হয়েছে। kita পেছন ছিল পালিয়ে গেছে তার মানে মেরে পালিয়ে গেছে ভালো তখন তো ভালো ভালো পারে 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 বাড়ে আছি বাড়ে 5 নম্বর বাড়ে
হার্ট অ্যাটাক আমার
হ্যাঁ
এক্সপার্ট
বিল করবে তোমার লিখবে কি করে
এই তো मैं এই তো রাখতে পুরোটা কোন জন্য
না লিখছে কস অফ রেসপিরেশন আই ক্যান ইনজুরি আছে সাথে এখানে 2.5 এসে কাল লিখতে পারে ওটা একই
এই পুলিশের রিপোর্ট না ইঞ্জুরি হয়েছে আচ্ছা আপন প্রাণ বাঁচা পয়সা এখানে কোনো বাইরে
আচ্ছা এখানে না পজ দিতে পারো পজ আছে লাইভ পজ আছে
এটা
আরে দিয়ে দাও এক কথা তো প্রসেস
যদি তো
এটা যেন হয় খরচের খাতায়
তোমার ওই টাইম বলে দিয়ে ভাইকে খুঁজে বের
ওদের বেশি পার্লারে বেশি করে ভালো বক্তব্য হয় বক্তব্য দিয়ে করা যায় বক্তব্য থেকে যায় সে গরিব আচ্ছা ও দেখে আমি কি করবো
ওর পুরো খুশি আজকে যে আমার ভাই বেরোবে হ্যাঁ
আরেকটা ভাইকে মেরে দিল
কোনটা যাবো
रिपोर्ट आ रही है 5 मिनट
Okay, sir. Thank you very much for your
অর্ডার দিয়ে আমাকে 10-40 দিন করতে হবে এই নাম ছিল আমাকে বল না দেবে আসতে পারছি আমি কাউকে দেবে তাই তো নাম যারা একটা ফ্যাক্টর ফ্যাক্টর ফর ম্যাটারে ফ্যাক্টর না আমাকে আমাকে কেন মিসগাইড করছে আমাকে কেন মিসগাইড করছে আমাকে বলতে আমি আসতে পারছি কাউন্টার
আপনার যেটা বেরোলো সব সেম কপি এগুলো জেরক্স আপনি দেখা যে গভর্নমেন্ট নোটিফিকেশন চেক করলো অ্যাপয়েন্ট করলো নোটিফিকেশনটা ফার্স্ট গভর্নমেন্টের ফার্স্ট নোটিফিকেশনটা দেখা গেলাম আজকে আর বলতে পারি না যে একটু জয়ের জন্য দরকার
আমি সেটা দরখাস্ত করছি এরকম তো ওটা ওরকম আমি বলি আমাদের যেমন সাধারণত লোক নাই জায়গাটা খালি হচ্ছে ওটা আমি মানে হয়তো জানতে পারলাম বা আমি জানলাম সেটা একটা এইভাবে দরখাস্ত স্যার আমি আমার বাসিন্দা জায়গাটা কোনো স্থায়ী মেরিট রেজিস্টার নেই আর এই অস্থায়ীটা 1 বছর পরে এটা হচ্ছে প্রসেস ওই প্রসেসে
ম্যারেজ রেজিস্টার মুসলিম ম্যারেজ রেজিস্টার ক্লাস সভাপতি করলেন ক্লাস সভাপতিকে অ্যাপ্লিকেশন করলেন
হ্যাঁ জেলা সভাপতি
জেলা সভাপতি কি পাওয়ার আছে যে দেওয়া
না ওনাকে আমি দরখাস্ত কাজটা আমার আমি দরখাস্ত করেছি অথচ আমার টাকা সত্ত্বেও আমি দিলাম
কত অ্যাপ্লিকেশন করলেন লয়ার সেক্রেটারি প্রথম কাগজটা
প্রথম কাজ
21 সালে জেরক্স কপি নিয়ে এখানে ঠিক তারপর আপনার রিপ্লাই
আমি একবার নয় অনেকবার 2020 থেকে নিয়ে করে 2022 করেছি কাজটা এখন
হ্যালো, হ্যাঁ 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 পাঁচটার পর ছুটেই পাবে, তাহলে বলছি দুটোর পর থেকে ম্যাটার চলছে প্লাস তারপর মিটিং। আমি জানি ওখানে সবসময় সাজানো আছে। তুই বল রাজা চেম্বারটা যাবো, রাজা চেম্বারটা বল, রাজা চেম্বারের পাশে হচ্ছে তুই, ওরাই বানাচ্ছে, ওরাই বানাচ্ছে। আমি বলছি রাজা চেম্বার কোথায় যাই বলছে, আমাদের হচ্ছে না ওর পাশে স্টেট গেলে তারপর ডান দিকে মুখি, ডান দিক, হ্যাঁ ওইখানটা আমি বলছি। ওখানে একটা দোকান, তারপর আরো দু তিন দোকান পর হচ্ছে, এবং আরো একেবারে একেবারে রাজভবনের মুখেও একটা দোকান, কিন্তু ওরা বানিয়ে বিপদ পড়ে যায়। আমি ওখানে গেলে আর পারবো না, আমার 11 মিনিট। ধরে না তুই দেখে যান একবার, দেখে তো অসুবিধা কি আছে, তুই দেখে যা। 250 টাকার মধ্যে ভালো ভালো জিনিস
যেহেতু
কথা বলবে, আর আমি
ওটার জন্য আমাদের যেটা
আমি কত নম্বর রে
আপনার সার্টিফিকেট আসছে।
রেকর্ডিং ও 7 নম্বর, ঠিক আছে ঠিক আছে। নেক্সট ডেটে আয় আমি দেখছি, ঠিক আছে। দু তিন দিনের মধ্যে আবার আসতে হবে, তো সোমবার মঙ্গলবার আসতেই হবে তো, আজকে থেকে যেতে পারছি তাহলে 2-3 দিন থেকে যেতে পারছি। শুরু করে দিয়েছে, দেখছি আছে প্রচুর লোক আসবে, সব বিনা পয়সায় গাড়ি।
আর আপনার আধার কার্ডে
জুতো তো না চটি, হ্যাঁ ঠিক আছে বুঝতে পেরেছি, ঠিক আছে। আমি তোকে বলে কথা বলছি,
এখানে আধার কার্ড, হ্যাঁ আমার এবারে ধরুন আমাদের মসজিদের ব্যাপার এক জায়গাতে থাকাতে যায় না, সেখানে যেতে
আমি তো ওখানে চলে আর 10 মিনিট বাকি নেই, ওখানে কি একবার দেখে যাবো, আসতে এখন চেস করে কি নিল। মানে এখানে মানে ওই জায়গাটা ওই লাইন দিয়ে পুরোটাই এমন ওই আয়কর ডিপার্টমেন্ট আছে না, ওইখানেও একটা আছে যে একেবারে শেষ মধ্যে যে রাজভবনের মধ্যে ওই জুতো মানে তাহলে টেম্পোরাল পাশে, তারপর ওই রাজভবন, না না এটা না একদম কিনবো। এরপর থেকে কালকে বইটা ছিল করেছে,
না পুরো জিনিসটা সব আছে দেখেন এই পুরো জিনিসটা ভালো হ্যাঁ তো এটা ফার্স্ট টাইমে তো জেরক্স রয়েছে বাকি যেগুলো একটা জন্য যায় আসে না আপনি এই সেটা জেরক্স করে দেন বলেন না আপনার এখানে সামনে হচ্ছে বাইরে যেতে জেরক্স করে এই দুটো কাগজ পেলে দিতে হবে আর দুটো ওখানে এই দুটো কাগজ পেলে দিতে হবে হ্যাঁ তো ওটা কিছু বাস এগুলো দরকার নেই বাস এই দুটো পেলে এটা এটা অ্যাসেম্বলি এটা আমি পড়ে জজ করার এইটা পড়ে জজ যেমন এখানে এটা যেমন এটা আমার এটা 10 সেল মেমো নাম্বারে আমার পাঠিয়েছে এটা আমার মেমো নাম্বার 10 সেল আইজিআর কে দিয়েছে আইজিআর এই নাম্বার ধরে এখানে কি এই নাম্বারটা এটা কি ওটা লো সেল নাম্বার এটা এখানে যে একটা বলছে এখানে অথরাইজ করছে মানে যেহেতু এখানে কোনো জায়গায় জিনিসটা নাই সেই হিসাবে ওকে যে জায়গাটা খালি আছে তুমি কোন পেপার থাকে তাহলে ধরুন আমার কাছে এটা এটা আছে আপনাকে দিলাম এটাতে এর মধ্যেই আছে যদি এটা দিচ্ছে হ্যাঁ হ্যাঁ ওটা একটা সেট করব এবার আপনাকে আমাকে এই সেটটা রাখতে হবে আর আপনি চেষ্টা করব পড়াশোনাটা যদি এবার স্যার এখন টাকা সেটা তো আমি এটা আপনাকে আমার কাজে করতে পারি আপনি যে কাগজপত্রগুলো আমি দিলাম আপনাকে চিন্তা ভাবনা করে হ্যাঁ ওইটাই আমি চলছে ডিস্ট্রিক্ট বুঝছে তো এই সার্ভিসের আনি ঠিক আছে আর আপনার নাম্বারটা বলো দাঁড়া দাঁড়া বসে নেই গো কয়েকটা লালবাড়ি দেখতে পাচ্ছি লালবাড়ি সরল পয়সা লাগছে না
আর সিনেমা অন্য জায়গায় শিফট হয়ে যাচ্ছে জায়গাটা ভ্যাকুয়াম হয়ে গেলে কোর্ট যাবে যারা বেহালা স্বর্ণকার যারা সমস্ত আমি তো এই কারণ হ্যাঁ একদম সেই জায়গায় ছেলেকে ছেলে তোর ছেলে এখনো পলিটিক্স আর ইংল্যান্ড আগে বলতে মাথাটা এবার তো হাজারাতে সিট করলো এখনো 8 বছর 8 বছর 60 ডিগ্রি 60 দরকার কি আছে? হ্যাঁ আর ওই অবদানি করা না গাড়ি টাড়ি করে আর নবরাত্রি পালন করে ওই সময়টা ও তাই
আরে বন্ধা গাড়িওয়ালা
সবসময় ভালো মতো পড়া আমি কোর্ট পাস যাবে আমি যাবো আমার তো হয় সে তো যাবে না না জানেন আমি নাই আছি দাদা এমনি আছি
ভালো আছেন
আপনার অবাক হয়ে যাচ্ছে আমি না আমি একটু বসি আপনার আমি আমার আস্তে আস্তে পড়ে যাবে কি
ওয়ান এইটটি বার 180
180.
Last episode, my lord,
I have submitted my report, my lord. I think, my lord, after then the new cause of action arises.
Before going into that, may I refresh my memory? Now, the matter, the petitioner before lordship has come up before this honorable court, asking for a direction upon the respondent authorities to calculate the tax granted in terms of the Motor Vehicle Tax Act and the West Bengal Motor Additional Tax Act, as well as the notification issued by the government of West Bengal for granting exemption in respect to the vehicles which cannot be applied in the period. That application or the representation has not been considered. Accordingly, matter came up before this honorable court. This honorable court, Honorable Justice Vijay Gangapathy is pleased to direct them to consider this representation in a particular period and decide the issue. The first round, the Secretary of the State Transport Authority decide the issue and pass an order. Your Lordship kindly come to that order first. That is the order at page 70.
Yes.
Page 70. Number second paragraph. Gautam Kumar Sarathi, holder of a permit number certain which covered vehicle number issued by ST Odisha for the route Paradip contact, submitted statement during hearing. As per the statement, an election P6 appears that operate the vehicle for lockdown declared for COVID-19 pandemic and for exemption of the tax and additional tax without charging the penalty 1/10/2020 to 18/2021. And in respect of the period as and when restrictions after 30th June 2021. The counter signature of the same permit was valid up to 13/4/2023. CS number certain here and it has to pay additional tax and UP tax as per the authority letter number 693 dated 5/8/2019. Moreover, as per Transport Department's order number 613, exemption of tax will be applicable for vehicles registered in West Bengal having state carriage and contractors permit issued by the ST or RTA West Bengal. You will not see any market. This is the notification or this is the Transport Department's order indicated by the Secretary State Transport Authority rejecting my prayer for exemption. Challenging this, further petition has been filed. That petition, a judgment has been delivered by Honorable Justice Viranmoy Bhattacharya. It starts from your Lordship kindly come to page 84. That is the operating portion. It appears from the receipt issued by the Public Vehicles Department, Kolkata, West Bengal, that the additional fee that has been taxed 7th February 2020 to 6th February 2020 on 3rd February 2020. It is also not in dispute that the category of the vehicle of the falls otherwise within the category of the vehicles entitled to exemption as per notification in thus the condition for claiming exemption of tax and additional tax for a period from 1st April 2020 to 30th September 2020 satisfied in the instant case. Now the question arises as to whether the claim exemption on the basis of the notification dated August 10, 2020. The object behind issuance of such notification is that private operators of stage carriages who face financial stress due to increased financial price and limited number of ride leadership to ensure social distancing norms will allow exemption as one-time tax relief in crisis period. The right to claim benefit of such exemption accrued in favor of the petitioner with effect from the date of issuance of the said notification, that is on and from August 10, 2020. The said notification does not also stipulate any application to be made for claiming exemption. However,
The petitioner claimed adjustment of motor vehicles tax as well as additional road tax on twofold grounds by filing the representation dated 7th. Firstly, that the exemption has been provided under 1979 Act, 1989 and 1989 Act. And secondly, in terms of exemption notification dated 10th August 2020 issued by the government of West Bengal. The notification dated 23rd February 2021 for the purpose of one-time exemption of tax and additional tax for the period from 1st January 2021 to June 30, 2021, whereas the claim of the petitioner for exemption is up to September 2020. The notification dated February 2021 does not also refer to the earlier notification dated 10th August 2020. It is an independent exemption notification extending the benefit of exemption from 1st January 2021 to 30th June 2021 passenger transport vehicles having state carriages and contract carriages registered in the state of West Bengal. Thus, the state notification dated 23rd February 2021 is considered due of this court cannot be applied to. I will notification. This is the notification.
So, Mr. Chatterjee, this judgment says that the notification was not applicable to the petitioner.
Not applicable.
But in the present case, you are relying upon this notification.
No. 10th August is applicable for me. I am
The
relying on
earlier-
10th August.
The earlier notification.
Not February 2021. Here the department has exercised their power on the 10th February 2021 notification. Then your lordship can come. Now the question comes as to whether the right of the petitioner to claim exemption by virtue of the notification dated 10th August 2020 can be taken away by issuance of subsequent notification of March 2021. The state notification dated March 22, 2021 cannot operate retrospectively to take away the vested right of the petitioner. But this is the page 17 notification dated March 3, the 22nd March 2021, page 70. Cannot operate retrospectively to take away the vested right of the petitioner. Thus, the rights which stood vested upon the petitioner and was claimed by making representation in such regard to the respondent authority would not have been denied by taking aim of the subsequent notification dated March 22, 2021. This matter can also be looked from different angles. The petitioner claimed exemption in terms of the notification dated August 2020 by making representation which was received by the authority as far as back on December 2020. The respondent authorities had right over the matter, which compelled the writ petitioner to approach the court. This court, by an order dated 16 March 2021, directly responded to consider by the same representation, which claimed his right under the notification dated August 2021. No reasonable explanation is forthcoming from the respondent as to why no decision is taken on such representation for such long time. Even at the time of hearing of the petition WPA number on 16 March 2021, the respondent authority did not contest that the notification dated 10th August was not applicable. As on the date when the same petition was disposed of, the subsequent notification dated 22nd March 2021 did not see the light of the day. Thus, legally a vested right accrued in favor of the petitioner for consideration for exemption in terms of notification 10th August 2020. Thus, the consideration as per the direction passed by the Honorable High Court ought to have been. It is ought to have been on the basis of the notification dated 10th August 2020 that was prevailing on the date of passing the order on earlier petition, that is 16 March 2021. Thus, on the same ground, also the subsequent notification March 2021 would not have been applied to the case of the petitioner. This court is of the considered view that the reasons for which the prayer is rejected by the respondent authority cannot sustain the value of law and save that side. However, since the authorities have to take a decision as to the amount of tax and additional tax that to refund or claim adjustment thereof, this court feels that the concerned authority respondent authority should be directed to take a decision on the representation of the petitioner. While considering the prayer for adjustment, the same respondent shall also consider the claim of the petitioner adjustment in terms of the provision laid down under 1979 Act and 1989 Act. No appeal has been taken out. Then, your lordship kindly come to next annexure, page 94.
Yes.
This is the order passed by additional secretary as per the prayer of the Learned Council for the state respondents.
This is included in the present writ petition.
This is included in the present decree. Your lordship, at the first instance, on perusing this, on 15th March 2023, please to set aside this. And as per the prayer of Mr. Debray, the matter has been demanded back to the Principal Secretary Transport. My dear lordship, kindly see your lordship's order. 15th March 2023.
In this writ petition?
In this writ petition. It is in your lordship's file. Your lordship was mystified. Because your lordship can see the Secretary State Transport Authority passed the order, the view taken, the same view taken by the Additional Secretary while passing on the same notification, and now the Principal Secretary.
So this was disposed of.
No, your lordship kept the matter pending because this is the fourth round. Same order is being passed one after another. Same order, no change. But my first submission, when the Honorable Court is to set aside the thing, the finding, relying on a particular notification, can the authority take the same decision relying on the same notification again? Can it not be a contempt of this Honorable Court? My first submission to your lordship.
What does the report say?
Now your lordship can see the Principal Secretary. This is the affidavit filed by Mr. Debray on 12th July 2023. Page 8, reasoned order.
Page 8 is the 10th August notification. Page 8 is the 10th August notification.
No. Page 8 of this
report
or supplementary evidence, what is the same? The report of the report in the form of activity. Not 10th August notification. This is the order passed by the Secretary, Principal Secretary Transport Department. You not think I see this. Recent 12th July. Affidavit dated 12th July. On behalf of respondent number 1, affidavit dated 12th July. On the last day, Mr. Debray filed the same. Has also served a copy to me.
Yes.
You will also probably seen the earlier report.
Page 8 you're referring to. That's the order.
This is order page 8. Now you will also can see what the authority finds. It appears from the contents of the writ petition that most of the vehicles as mentioned in the writ petitions are covered by the interested party duly countersigned with the SUVRA. two letters number 18620 and letter number 492020. Transport Commissioner Odisha and Alisa are government to government communication regarding policy. No copy of the letter were taxing officer PBT submitted that if the applicant has prayed for exemption for non-flying of the vehicle to the COVID period. Nationwide lockdown was applicable from 1st June 2020, lockdown was started. Subsequently, September 2020, all mass operations allowed COVID protocol. During COVID period, government of West Bengal issued exemption tax for transportation vehicles from time to time, but exemption was restricted to the vehicles registered in West Bengal by number 998 dated 23/22/3/2021. This has been held by Honorable Justice Vinay Bhattacharya while deciding the matter earlier that this is not applicable in this case.
Is that in connection with the same petitioner and the same permit?
Yes. Same person. That's why my lord was other 5 matters, my lord was disposed of and sent matter before the principal secretary. The same order has been passed. I have to come up with fresh writ petition against that. As Mr. Debra has indicated, that is the fresh cause of action. The writ petition was not pending. Your lordship was pleased to dispose of the matter and send the matter back. And in this writ petition, I have prayed your lordship that this is the thing. Contempt rule should be issued against them. They are not permitted to take same stand in spite of the same has been set aside by the Honorable Court.
Let
They
Mr.
are
Debra
not
explain.
entitled.
Let Mr.
Number
Debra
one.
explain.
What I am praying subject to lordship kind of my prayer to the lordship at the present moment is this. The lordship can decide this. Whether as per the Motor Vehicles Tax Act, because my lord Justice Vinay Bhattacharya was pleased to take the matter back to them for deciding the exemption after holding that exemption is permissible as per the notification and as per the act. Whether I am entitled or not, my prayer is the lordship can decide it. And at the present moment, the lordship can allow my client to deposit the current tax so that he can fly the vehicle peacefully. I am not praying anything more. Current tax at the current rate, whatever the taxing officer PPT will calculate, I shall ready to pay from January 2023. Not from July, January 2023. Then your lordship can decide the issue after Mr. Debra filed the affidavit or whatever it may be. Said we are hearing, your lordship can hear. I want a proper decision whether as per the Motor Vehicles Tax Act, if operator is entitled for exemption or not.
Yes, Mr. Debra.
Well, I shall file one. In that case, my lord, I shall file a composite opposition. When my lord going to decide the issue, I have
to because your authorities are in contempt.
My lord, there is a difficulty. There is a serious difficulty faced by the authority, my lord, regarding interstate, not only Mr. Chatterjee's client, but also various vehicles are there. Various vehicles are there during the COVID period. COVID period only restricted to the state of West Bengal vehicle. Only that.
When the
But
court
on the
holds.
10th August, I am coming, my lord, I am coming. That has to be, my lord. I have to satisfy. But 10th August 2020, there is a mistake done by the authority. They are not indicated that any interstate rules. General notification.
For applicable for all vehicles.
All that is the main mistake done by the authority. But subsequently it was found at the subsequently 2021 notification was issued. So in that case, my lord, no outright interstate permit was not allowed. Interstate vehicle was not allowed to exempt the tax. In other state also, our vehicle also giving all entire tax. In other
No, it's not. Mr. Debra is not properly instructed, properly get the information. Odisha has granted exemption in respect of all kinds of vehicles, including West Bengal, Bihar,
And,
everybody.
well, I feel that is irrelevant.
Whatever it may be, the information is not correct.
The court has held that 2021 notification is not applicable in this case. Despite that.
In that case, lordship kindly thinks only this case is concerned, not for all. Particular this case is concerned only COVID
period.
This is a judgment in person and this is not a
Yes.
judgment in rem.
No. I am, and this judgment also only petitioner is concerned, not for all.
Obviously,
Only petitioner is concerned during COVID period.
because Mr. Devra, you must understand the matter has been decided by this court.
Mild.
Despite that, your authority is dealing with the 2021 notification.
That is why, Mala, I am also not satisfied with the order, because when the same matter was decided by this court, and already one of the learned judge also.
Two occasions. On two
One of the-
occasions.
One of the learned judge also, my lord, told that this is not a retrospective effect.
Yes, this is the
Then,
third
my lord,
audit after that.
Particular case, in a particular, not in general. On the, my lord, particular case, lordship kindly, I think, my lord, that is your 25th March to 2020 to 31st March 2020. From 1st June 2020, lifting of only that period.
Interstate vehicles is not allowed.
Yes, only that period, lordship kindly.
That's why
I shall take further instruction in this matter.
I
My.
have already enclosed the document.
Or when bolte da.
I have enclosed the document in this petition.
Assi tomar jaya assi.
I have enclosed the
Without
prejudice, but only intrastate, intra-district permit operation has been allowed, not the interstate. And the railway operation was also not allowed. Till it has been gone up to the minor, the period is, I am giving the period date, Mr. Devra is taking the instruction. First period was from March 2020 to 30th September 2020. First period.
First period, 25 March to 31st
Because 31st May, even if the lockdown lifted, but no interstate vehicle was allowed to operate. No train service was allowed to operate. And the
The
actually,
report says, my lord. After going to the entire record, they say.
these records are here. Let them go to that. If they do not see the record, what can I do? Everything has been placed before them. It is their document. It's not my document.
So shall I pass on an order or you want to come back with further instructions?
Further instruction required, my lord, because.
How will you improve your case, Mr. Devra? I don't understand.
Let him file an affidavit, comprehensive affidavit. You also kindly pass this interim order in favor of my client.
Only that.
Otherwise, my client cannot operate the vehicle.
No, only that period.
Stop the vehicle.
Only that period, let them pay, let them exempt only that period without prejudice to their right and contest.
No. It has gone to long period up to 2021 October.
Yes.
Up to 2021
But
October.
without paying tax, additional tax, vehicle is
I
fine.
cannot operate.
Operating.
You
You can try operating. That is why Caesar was made.
You have not been paying right from that period
Yes,
till date?
till date.
They are not
How
paid.
can I pay?
They are
Because
operating.
no, I am not
They are not
operating.
operating.
I am not operating.
Seize the vehicle, only two vehicles.
That is separate vehicle. That is not.
No,
this vehicle.
separate nothing.
That is separate vehicle. That is not this vehicle. That is one vehicle. As per the court's order, it has been released. Another, your lordship did not pass any order. Send the matter back. It has been in the custody of the authority. But the funny thing is this. Now I believe the state government, if they arrest any person, they will charge the hotel fee from the person for putting them in lockup. Because they have arrested my vehicle for non-payment of tax. That vehicle has been put it in the parking stand and they have charged the parking fee from me. Because why definitely? Then tomorrow they will charge person from the lockup. Because the vehicle has been arrested by them.
Lordship can fix the matter on next, on Wednesday. I shall take short instruction to that effect and they are.
So be it, let him come back. Let him come back, I'll pass a final order. It will not be kept pending like this.
Your lordship can indicate that let them take instruction in respect of the entire thing.
Lockdown, period of lockdown.
No.
Period of lockdown.
After the 2021 election in West Bengal, the period, the notification is there. Your lordship can seek notification. Mr. Devra is not accepting. What can I do?
Amar accepted.
Notification is there.
I am bound by the instruction.
Your officer, yes. Your lordship can seek notification.
The 10th August notification says 1st April 2020 to 30th September 2020.
Thereafter, the 30 March, May 2020. You also can do.
তারপরে জুন মাস থেকে আরম্ভ হয় জুন 21
Your Lordship, can come to
after election is over.
page 65. Yes, page 65. This is the first restriction imposed after the general election of West Bengal in May 2021. Your Lordship, can you see? Movement of public transport, including intrastate, inter-district, not interstate. And this restriction continued up to 30th October.
That I have to check it.
And Odisha, Mr. Devray also kindly take information that Odisha has imposed restrictions from April 2021 itself, immediately outbreak of second wave of COVID.
This is from 15 July 2021
Yes,
to
30th July. 30th July, third paragraph. Prior to that, it was there, it was extended up to 30th July. Then your Lordship kindly come to, because it was, your Lordship, in the first paragraph, it was effective till 15th of July, earlier. Page 65. Then by this notification 14/7, it was extended to 30th July. Earlier notification is not with me, I cannot collect it. Because it appears that it was up to 15th of July.
that is from 28th of June. The first paragraph. Earlier notification 28th June.
28th June, yes.
28th June.
28th, after the election, that I cannot exactly remember the date. In May 2021, election was held. Subsequently, after 10 days, the all results are published, new government has been taken place. Then the restriction have been imposed.
So the,
Then
this is the second phase till 30th July.
No, not 30th July, till 30th October. Your Lordship, can page 66. Page 66. Same restriction up to 15th of August.
30th October.
No, 30th October.
This is 15th August.
15th August, then page 67. 31st August 2021. Then page 68. 15th September 2021.
Here no public transport.
আরে ভাই যেটা ছিল সেটা কন্টিনিউ করছে
কোথায় আউট
এই তো
they are relaxation
রিল্যাক্সেশন কি দিয়েছে
2021 there is a relaxation.
What is the relaxation?
Outdoor government program.
Read it properly.
This is in continuation with earlier orders, Mr. Devray.
Yes, yes.
What is the relaxation?
So that includes
Are you think myself so full that what is not there? I
Relaxation.
this continues till
30th September. That last notification is not with me.
30th September. At that time, we had to rush back on a day's notice because it was closing down from 24th.
24. So I was in the residence. I have to visit the doctor on this day, 24th. In television news, I have heard it. Then I have to inform the doctor that 24th I cannot go because of the national lockdown starts and all vehicles are stopped. So please allow me on 23rd. Doctor said 23rd, it's a Sunday, I cannot see. Where will you come to my residence? His residence is far away from my residence, but I have to travel.
So it's 24th March to 30th
September, because
the first phase.
First phase, because national lockdown, even if it's lifted from 1st June, but the restriction was continued till 30th September. Mr. Devra can
And-
check it from record.
And then from 28th June 2021 to 30th September 2021.
No doubt, but the Odisha, because I am from originally from Odisha, Odisha starts from April 2021, immediately after out. Because April 2021, West Bengal cannot stop it because of the ongoing election. The May election was there, that's why West Bengal cannot stop it. It was continued, but I cannot cover the Odisha border. In Odisha border, it was stopped. So I cannot operate in Odisha also. In West Bengal, vehicle was stopped from that date and thereafter it has been lifted.
So this is the period that he is seeking exemption.
Yes.
Please take instructions and come.
I said instruction fully and
I
Along with
intend to
the-
pass a final order.
along with the notification, my lord, I shall produce report. And I requested them to
Heard learned counsels for the parties. It is a paragraph. It is surprising to note that in compliance with the order of this court passed on March 2023, an almost identical order as the earlier ones has again been passed by the concerned authority, relying upon the notification dated February 23, 2021. They have relied upon February 23, 2021. Paragraph. The petitioner seeks exemption of tax and additional tax.
February and March, both. March 22, 2021.
The notification.
notification date. February.
March is also there, 9/19 March.
Uh,
22nd March.
February 2023, February 23 যেটা বললাম and March 22, 2021. Yes. কি বললাম? The petitioner seeks exemption of tax and additional tax for the period 24th March 2020 to 30th September 2020 and from April 2021 to 30th September 2021. Paragraph. Learned counsel for the state respondents seeks to take further instructions in this regard. Paragraph. Let the matter appear under the same heading on 2nd August.
That's why I am praying. 2nd August, your lordship will be here. I have heard your lordship.
I have not got a confirmation as yet.
Oh,
The
this is
dates are
now-
being changed.
Now in the corridor, that your lordship will.
May. There's a proposal.
1st of July.
The chief has not given any approval as
Your
yet.
lordship is not there. Matter will not be taken up.
So come back next week in that case.
Yes, up to 16th of.
Next week. Next Wednesday, you were saying, isn't it? Where 26th. 26th July.
Very good. What?
You're for the petitioner? Yes.
The petitioner has purchased the pass.
Please switch on the microphone.
Well, the petitioner has purchased a bus from one Birendra Pratap Singh. The bus was initially taken on hire purchase.
Several respondents who are appearing.
I'm for the bank, my lord, Canara Bank.
Yes, my lord. Mr. Devra, you're appearing in this matter. State, you're appearing. And what about the private respondent?
Lordship, I'm for the respondent number 4.
Private
Lordship.
dispute first solved, then.
You are for 4.
Respondent number 4, Lordship.
What about 6?
Now 6 is not appearing, my lord. Because he will, because yes, I've submitted, I gather on the earlier occasions, I have given the affidavit of service also. Well, only
Yes.
the crux of the matter is that the petitioner has purchased one bus from Birendra Pratap Singh, that is respondent number 6. This bus was initially taken on hypothecation by Joy Shah, that is respondent number 4. Joy Shah has failed to pay the EMIs. After to fail the EMIs, this bus was taken as per the hire purchase agreement rule. It is on the bank. So bank has taken it. Bank has performed an e-auction and a bidding was conducted. Birendra Pratap was the successful bidder. Birendra Pratap purchased the bus, and from Birendra Pratap, the present petitioner, that is SUVRA Maitif, has purchased it. Thereafter, after purchase of the bus, he have gone for the RTO. The RTO has done something, my lord, will come from P1.
Page?
Page 15. Just after affidavit.
Yes.
But I'll read it for your lordship for the convincing. Where this office could not verify the submitted documents properly, being informed from a source, it is detected that the vehicle was handed over to bidder Sri Birendra Pratap Gupta by Canara Bank in a public auction, and the bank also certified the same in a prescribed forms. Whereas it would be transferred in the name of the bidder could sell it to any person. Therefore, it is rectified that the procedural latches now, the vehicle is being returned to the name of Sri Joy Shah, the previous owner. This office feels sorry for this unintentional mistake. So they have admitted it is a mistake on their part that they have transferred to Joy Shah. Now, presently, Joy Shah is running this vehicle. And because of this unintentional mistake, I am suffering this because I have purchased it with a tune of rupees almost 10 lakhs. Now it is flying by Joy Shah. The bus is almost 6 years, some months old. So this is the entire scenario. In fact, my lord, we have also filed an application under section 457 CRPC before the court bill for return of the vehicle. The court categorically stated that you bring an order. We have also stated we have filed a writ petition also. So stated that, okay, you filed an given direction from the writ court that whose latches is this, we will be returning this vehicle.
What is your prayer in the writ petition?
Please return the vehicle to me. Delivery of the said vehicle initially.
Very blanket prayers, no specific prayer.
That was what happened, my lord.
Taking illegal action against the law of the land. What prayer? What kind of a prayer?
No, my lord. That is what happened when this writ petition was filed. My lord has only directed, have you filed any application before the court below? So we filed an application thereafter. They were very candid.
No, that's all right. But
so
what is your prayer in the writ petition?
No,
To
that
give
is
protection to the vehicle. What kind of protection to the vehicle?
My only prayer is very limited to extent to delivery of this vehicle. Nothing more, nothing less.
Yes, Mr. Debroy.
What can I do? On the basis of the court's order, he has taken
There is no court's order, my lord.
There is
on the basis of the court's order.
There is a court's order.
Well, initially, my lord, Mr. Joy Shah, original owner of the vehicle, my lord, moved a writ petition before this honorable court. Lordship, can you turn to page koto eta? Writ petition, my lord. Page.
My lord, writ petition was filed on a police in action.
P4 of the writ petition, Lordship, whereupon it appears. P4, second page, Lordship, kindly see. P4, last, advocate letter, my lord.
Advocate's letter, yes.
Reply. Reply to the bank. Right? No, reply to the petitioner regard notice. Well, next, paragraph 3. Second page, paragraph 3, Lordship, kindly see.
Yes.
On the basis of the said order, my lord, 156(3), initially 226, thereafter 156(3). And next page, paragraph 8.
This is the seized vehicle. Now vehicle. Paragraph 8.
So an FIR was registered.
Lordship,
Yes.
Lordship. FIR was registered against.
Vehicle, my lord. Now, what's the vehicle under the Joy Shah? He is the original owner of the vehicle.
My lord, if your lordship permits me, lordship, I shall serve a copy of the order passed by the coordinate bench of your lordship. Justice Rajshekar Manta, while the respondent number 4 preferred an application under section 226 of the Constitution.
আমি জজকে বলিনি একদম
হ্যাঁ, বলুন।
Lord,
বাংলা সুবিধা হবে।
Lord, section 51 subsection 5, bank has to be incorporate his name as the owner.
No.
Thereafter, he has to sell the.
No.
No. 51(5), kindly go to the 51(5).
Yes, kindly, sir.
My lord, bank has performed whatever the bank was required to do. He was
Only
original
they
owner,
say.
Joy Shah was a defaulter. So we forcefully seized the vehicle. He's perhaps referring to this order, my lord, the order of
My lord, there was a direction only to file a
17th February.
17th February.
17th February.
Lordship.
Yes, my lord. So we recovered the possession. Now we had held an e-auction. Birendra Pratap was the highest bidder. Accordingly, he had deposited the money. We have transferred the no objection and whatever we had to do to Birendra Pratap. Now, how the vehicle had passed over to Joy Shah, that is something I myself am.
Court's order.
Maybe
That is the.
the bank has nothing to do with that.
Where is the court's order?
Where is the court's
directly
order?
handing over the vehicle to Joy Shah?
That-
Where is that court's order?
Court order আছে?
Now, Birendra Pratap has sold it to Shiburam Maiti. Then
Yes.
again, it has
Yes.
passed over to Joy Shah. This is a entirely confusing state of affairs.
My lord, kindly
Here
proceed.
there was a direction, a liberty to file an application.
156 clause 3.
Lordship,
That also for a limited purpose.
Lordship,
Recovery agents have seized the vehicle midway without
Lordship.
notice.
Lordship,
So only on that, only that.
Lordship, Lordship,
Remaining part was not entertained.
Lordship,
So where is the order under 156(3)
Lordship.
taking return of the vehicle to you?
Lordship, during the course of the investigation, Lordship, the vehicle was seized. I was the registered owner. I am the registered owner of the vehicle, Lordship. I prayed before on my behest, the application under section 156 clause 3 has been preferred. Under the strength of the observation of the Honorable Court, Lordship, I have preferred an application for releasing the vehicle as the owners ordinarily appear before the learned magistrates and seeks for return of the seized vehicle or seized article, which he have the ownership. Lordship, I have produced the relevant documents to the London magistrate in concerning prima facie to prove that I am the owner of the vehicle. The London magistrate has been pleased.
Are
and
you
passed.
actually the owner of the vehicle?
I am actually the owner of the vehicle, Lordship.
Forget about the registration part.
Lordship,
Your name has not been changed,
Lordship,
right?
Lordship, to the
Have you
clarity,
cleared the dues of the bank?
Lordship, the clarity, with the clarity I shall submit before your Lordship. Lordship, while the pendency of when the vehicle was with me, I was going with the payment of the EMIs, Lordship. There was a dispute between bank and me regarding some payment issues, Lordship. I have made the payment, the bulk of the amount which was required to be paid as per the instruction of the bank. Thereafter, the bank authority, without giving me any notice, without giving me any appropriate, showing me any appropriate order, Lordship, midway, they have taken the possession of the vehicle illegally, Lordship. Thereafter, Lordship, I prefer the writ petition. Lordship, it was the observation of the coordinate bench of the my lord that I may prefer an application under section 126 clause 3, Lordship. At the time of application, it was allowed, and thereafter investigation started, Lordship, and thereafter the vehicle was recovered and it was handed over to me with the lawful order, Lordship. Now, in the meantime, the auction notice was issued, Lordship. I was not made a party. Bank have never intimated me that I need to participate or there is an auction going to be taken place. I was never informed, Lordship. The bidder, who is the bidder, we don't know. Lordship, the bidder took the name of the bidder came from where, we don't know.
All this has happened on paper.
Without any intimation to your the actual registered owner, Lordship. Now, Lordship, what is the settled law?
when we are the learned counsels of from the bar, we have to abide by the statutory provisions, Lordship. The settled principle of law as per section 51 of the Motor Vehicles Act, Lordship. One is, Lordship, section 51, subsection 4, Lordship. If I go through, it will be as crystal clear, Lordship. Thereafter, I shall bow down with any order which will pass by your Lordship. Section 51, special provisions regarding motor vehicles subject to hire purchase agreements. Where an application for registration of motor vehicle which is held under a hire purchase, lease or hypothecation agreement, hereafter in this section referred to as the said agreement, is made, the registering authority shall make an entry in the certificate of registration regarding the existence of the said agreement. Where the ownership of any motor vehicle registered under this chapter is transferred and the transferee enters into the said agreement with any person, the last registering authority shall, on receipt of an application in such form as the central government may prescribe from the parties to the said agreement.
Not applicable.
This is not applicable. Lordship, if I come to clause 4, which is directly applicable to us, no entry regarding the transfer of ownership of any motor vehicle which is held under the said agreement shall be made in the certificate of registration except with the written consent of the person whose name has been specified in the certificate of registration as the person with whom the registered owner has entered into the said agreement, Lordship. Now, Lordship, there is any consent which has been taken from the bank authority by the registering authority not? This is the question, Lordship. Now, clause 5 is most relevant to our case, Lordship, where the person whose name has been specified in the certificate of registration as the person with whom the registered owner has entered into the said agreement satisfies the registering authority that he has taken possession of the vehicle from the registered owner owing to the default of the registered owner under the provisions of the said agreement, and that the registered owner refuses to deliver the certificate of registration or has absconded. Such authority may, after giving the registered owner an opportunity to make such representation as he may wish to make, by sending to him a notice by registered post acknowledgement due at his address entered in the certificate of registration, and notwithstanding that the certificate of registration is not produced before it, cancel the certificate and issue a fresh certificate of registration in the name of the person with whom the registered owner has entered into the said agreement. Now, Lordship, this has not been complied. If it has been complied, Lordship, this dispute never would have arose. If the registered owner given an opportunity of hearing before the registering authority, Lordship, we could have placed every other documents to the authority and it could have been resolved, and the petitioner would not be in a position to prefer this writ application because from whom he has purchased, he is not a lawful owner. His ownership has never been a lawful as per the statutory provisions of law. If any malpractice has been occurred before any authority, and for few days my name is showing as a owner, I do not become an owner, Lordship, if that ownership is not in accordance with law.
But only one thing. The registered owner becomes the bank after the time of hypothecation because it's in the name of the bank. The bank remains the owner until and unless the dues
Lordship,
are paid.
the statute does not say so, Lordship. I am very sorry to say, Lordship.
With GHOSH, we have that clause that if he's a defaulter, if he's not paying that amount, we can forcefully enter. Clause D, it says the borrower failing or neglecting to comply with the said demand and pay the amounts due to the bank is entitled to enter upon the premises in which the hypothecated vehicle is kept or believed to be kept, seize, take possession thereof, or otherwise cause to be sold in public auction or by private treaty for recovery of the amounts
without further notice to the
Lordship.
registered owner.
That I will have to find out, but must have been a notice because the entire procedure, the removal of hypothecation, the handing
His
over.
primary grievance is that
Lordship.
it was done without notice.
Lordship.
So if you can show me that a notice was issued,
Lordship.
that solves the issue.
Lordship. Lordship.
Will you come back with the instructions?
I will, my lord. That only that part, whether that notice has been given to
Yes,
him or
yes,
not.
yes. Prior to confiscation of the vehicle, you've issued a notice,
Lordship.
given him an opportunity.
Lordship.
That is required under the law.
Lordship.
Yes, my lord,
You cannot
because,
stop his vehicle and take it away
Lordship,
without
forcefully.
notice.
but he had initially filed a writ for that. And there was the order of the court also that it was a private agreement between the two of us. So,
The court also did not appreciate the
Lordship.
taking away of the vehicle without
Lordship.
notice
Lordship.
and granted liberty to the petitioner,
Lordship.
to the owner to take necessary steps, which he has done. And in that proceeding, by court's order, he has got the vehicle
Lordship.
back. Right?
very well, my lord, I shall take
So,
instruction to that
yes,
effect that
yes.
whether notice was given to him or not. That I shall do.
Otherwise, we need to go back to square one again.
Lordship.
That's all. Right. I shall take instructions.
Yes,
of
to
that.
make a application before the CGA that you better for recovery of the vehicle.
Let her come back with the,
Lordship.
Lots.
because if notice has been served,
No notice,
Then-
then the entire sale has to be paid.
Lordship.
if there is no notice, the subsequent acts cannot be supported.
Lordship. My lord,
So will
only
it,
will
last
it be
part, my lord,
possible, Lordship,
if
to indicate in the order sheet that what they have submitted, the notice has been served?
No, I
No,
did not
Lordship.
say that. She'll find out.
I
Anything,
shall
anything,
take
Lordship.
instructions
Anything
on
what
that.
falls from your Lordship.
Yes, do you want to add to this?
my lord, no, my lord, let it fix, my
Let
lord.
come back.
Let it come
Yes.
back, my lord.
The primary grievance of the no, take it again. The petitioner claims to have purchased the vehicle in question from the sixth respondent, who in turn purchased the vehicle through an e-auction floated by the bank, comma, being the third respondent herein, comma, due to non-payment, চলছে, same sentence কিন্তু, due to non-payment of dues by the fourth respondent in terms of the hypothecation agreement entered into by and between the bank and the fourth respondent in respect of the said vehicle. Paragraph. The primary grievance of the fourth respondent is that the vehicle was snatched away from him without service of notice upon him. It appears, paragraph, it appears that the fourth respondent filed a writ petition being WPA 20823 of 2021 in this regard, and by an order passed on 17th February 2022, comma, a coordinate bench of this court observed that since the recovery agents had seized the vehicle midway without notice upon the petitioner therein, comma, the petitioner within bracket, respondent number 4 in the present writ petition, bracket closed, was granted liberty to initiate appropriate proceedings after ascertaining facts under section 156 within bracket 3 of the Code of Criminal Procedure. Paragraph, learned counsel for the fourth respondent submits, paragraph, that such proceeding was initiated by him in compliance of the order of the court, and the vehicle in question was returned to him by an order of the learned Chief Judicial Magistrate,
Additional Chief Judicial Magistrate Alipur.
by an order of the learned Additional Chief Judicial Magistrate Alipur in the proceeding pending before him.
Well, only one thing.
Paragraph, learned counsel for the bank seeks to take instructions as to whether notice was served upon the fourth respondent before his vehicle was confiscated.
But it was, I found it out. It
Yes.
was, it was, It was a thumb impression of Joy Shah where it has been clearly stated that it has been cancelled.
Why don't you come back with an affidavit, the bank?
Definitely, my lord. Definitely.
We shall file an affidavit.
Annexing this document.
Yes, ma'am.
Great. Paragraph, let the matter appear under the same heading on 14th August.
14th August.
Next.
Lord. Deeply. Deeply. Deeply obliged.
My lord, I am for the petition. In this matter, your lordship, on the 20th June, your lordship directed if the petitioner applied for the renewal of permit.
Applied for?
This is the interstate route. Well, the pursuant to your lordship direction dated 20th June. Well, the petitioner applied for renewal before the STA Jharkhand, and well, it is under process. Probably, well, it will be issued within a week. Adjourned for
signature?
no new renewal of permit. Your lordship will adjourn for 15 days. Well, I have instruction. Well, the renewal of my application for renewal is under process. Already they have taken a decision to renew my permit. But the renewal has not yet been made. Your lordship will adjourn for 15 days. Well, in the
yes,
the Jharkhand melody will issue a new renew permit.
Learned counsel for the petitioner seeks accommodation. For the reason that the State Transport Authority, Jharkhand, has taken a decision to renew the permit of the petitioner in a short time. Paragraph, let the matter appear under the same heading on 14th August.
14 August.
Within a short time. Ashok, within a short time.
I am behalf of petition, my lord. On the last occasion, the lordship was pleased to direct the state respondents to file a report.
And respondent number 7?
Respondent number 7, I am appearing on behalf of respondent number 7.
State, Mr. Dey is appearing in this matter.
State was supposed to file a report for why they have allowed the respondent 7 to interfere in the issuing of class B timetable and all that matters.
Here is Mr. Dev. Let there be a date. Just intimate him and come back.
Last talk, yesterday only, day before yesterday, on Monday, the petitioner went to the RTO again for approval of the class B timetable. But they have again sent the letter to respondent number 7. While refusing that, my client, the petitioner, was constant to send it by registered post on yesterday only. They have not stopped doing this, my lord. Without the approval of the private respondent 7, they are not accepting the letters only.
I'll just make it not today. Please inform Mr. Dey.
Yes, sure.
Not today.
For the, can it be fixed on Monday, my lord?
Next week will be difficult. There are a lot of matters.
21st rally also. But 21st is rally, my lord. That's why. Tomorrow is original site. Difficult for any of us to go.
Order করুন আগেরটাতে একটা order করুন 183 তো আগেরটা none appears for the state respondents. Paragraph, let the matter appear under the same heading, then it has to be 14th August. 14th August. Please intimate Mr. Dey so that we can take up the matter.
I am for the writ petitioner, my lord. Lordship has passed an order on July 3rd, 2023, He was staying the
Appearing
tent.
For the respondents, you're
Yes, my lord, he sought time, he sought.
I have
for-
instruction, my lord, but that report not produced, my lord, prepare, my lord, in
The
time.
report has to be there, my lord, because I have challenged the illegality
I have
of issuing the
instruction.
tender. Because tender has been issued, my lord, illegally curtailing my right, because as per I have already an agreement has been executed. Now, when the agreement has been executed, they cannot cancel it without intimating me and without giving me an opportunity of hearing. I could have understood, my lord, that upon emerging as the highest bidder, they have done so. They have every right to cancel it before the execution of the agreement. But when the agreement has been executed, under the relevant provisions of the exit clause, they have to adhere to that. And that they have not done so, and they have.
You are not ready with your report today.
Yes, my lord.
You are not ready with your report today. You are
I'm ready, my lord, with my instruction, my lord.
A report in the.
Report, my lord, because of some officer, my lord, transport, my lord, that is the problem.
Can even interim order be extended?
You will take it up next week, my lord, short date.
Next week, not possible. Learned counsel for the respondents seeks extension of time to submit the report in the form of affidavit as intended. Paragraph, let the matter appear under the same heading on 16th August,
Plus, interim order may be
31st August,
interim.
31st
Oh,
August. Paragraph, the interim order granted earlier is extended till 31st August or until further orders, comma, whichever is earlier. Please serve an advance copy, Mr. Chakravarti.
Yes. Definitely.
But I appear for the petitioner.
Yes.
My lord. There was an order passed, my lord, when my learned friend was directed to take instruction, my lord. The brief facts, my lord, is the case is, my lord. I have challenged, my lord, an order of termination on dated, my lord, 14/6/2023, my lord. I have entered into a contract with, my lord, the railway for leasing of a parcel van. Immediately upon entering of the agreement, my lord, I faced two problem, different kind. One, my lord, the train was originating from Howrah station, whereas my lord, the parcel loading facility was provided in Shalimar. Now, my lord, the circular provides that I should be given 3 hours free time before, my lord, that it was scheduled to be. What happened, my lord? The scheduled time for departure was 10:20 p.m. in the evening, my lord, whereas, my lord, I was given, my lord, to load at 2 a.m., 1 or 2 a.m. in the morning. And the second part was that, my lord, even if I load the consignment, they were not attaching it with the original train. So therefore, what is happening, my lord, it was kept remaining in the parcel shed. I missed that train. Next day, it gets attached to the next day train. So I don't get a parcel van on for that day. These are the two problems, my lord, I communicated to the railways and says this has to be, my lord, redressed. I have given, my lord, a few, my lord, representation to the railway, my lord, starting from, my lord, page 59. 59.
My lord, subject to lordship's kind sanction, my lord. I find, my lord, Mr. Kollan Kumar Chakravarti is appearing on behalf of the Union of India. My lord,
In this matter?
Yes, yes, my lord. Initially, my lord, the order shows he had appeared. For such reason, Lord, leaving the court. I'm grateful.
But subsequently, he
So, my lord, on these two issues, my lord, I have given representation which would appear from page 59 and onwards. Page 59 on 25th of May, my lord, I write to them, my lord. My lord will kindly forget this is the language of the letter, my lord. But what they have, my lord, tried to say, my lord, that they are not getting the parcel van and this. This is forwarded by, my lord, another on 29th of May. My lord, in 29th of
Is Mr. Chakravarti ready today? You have instructions?
no, my lord, actually, what happened, my lord, initially I was happy, my lord, but subsequently, my lord, that person engaged, my lord, with my telephonic call.
Now who is engaged?
Now he is engaged, but he is not, he is refusing to appear because I was engaged.
So you will continue, isn't it?
That may be, but I have no instruction till date, my lord. That is a problem.
That's why I stopped you.
Lord, there was an order on 3rd July, my lord. There was
There's an interim order that has to
Interim
be extended in that
Yes.
case.
kindly give some direction for instruction. He said the instruction may be taken into.
You wanted to take instructions. The earlier occasion, it's recorded.
That is true, but
Learned counsel for the respondents seeks extension of time to take instructions in this matter. Will you submit file an
yes,
report
the report. Ma'am.
to instructions in this matter and file and submit a report in the form of affidavit? And submit a report in the form of affidavit. Paragraph, let the matter appear under the same heading on
16th of August. Ma'am.
16th.
Same date. Ma'am.
16th August. Paragraph, the interim order granted earlier is extended till paragraph 31st August or until further orders, whichever is earlier. Further orders, comma, whichever is earlier. Yes, next.
Will I be appearing on behalf of the petitioner?
Yes.
My lord, day before yesterday, your lordship has been pleased to fix all the e-rickshaw matters. 4 matters were on board on 2nd of August, my lord. To
These are different issues, no?
my lord, all are same, canvassed on same, my lord. My lord, some
By
facts
mail?
are required to be dealt with by way of a
my lord?
report.
Respondents.
I am preparing.
My lord, some facts were suppressed
Why?
that I want to
Submitting
bring on
on
record.
mail.
That's why I prayed for time before your lordship.
Mr. Sinha has come up with a new issue of suppression
No,
of
no,
facts.
this is not the
No,
issue.
my lord, I will,
After hearing both,
my lord.
kindly recall the matter.
Sinha has come up with a new issue.
In one matter was heard in the thrice or fourth time. In presence of his, this order was applicable in all cases. We have same matter, ideally, no different, there is no different issue. in
Now
this
he's
matter.
not liking this order. He wants another order.
No, my lord,
Can we
I'm not making submission to that effect, my lord. My lord, I'm just, I just intend to place some facts before your lordship, nothing else. Whatever your lordship desire, your lordship may pass that order. My
That's
lord.
why
My lord, that was a,
there's
my
no
lord.
agreement with my client. Other cases, there is
Only I want to place those facts, sir. Nothing else, my lord. I never.
Come back, let him come.
Yeah.
He wants an adjournment today, let him come back.
Only for a week, kindly, because why?
No, week not, all the other matters are on?
My lord, item number 188, Ravi Kumar Dubey is that
Date.
on 2nd August, my lord.
Let all these matters appear on. the
Second
same-
August, yes, I have no.
Affidavit of
It is a
service
sir.
on prayer of the 6th respondent, the matter is adjourned. Let the matter appear under the same heading on 2nd August.
There is no suppression.
Let all the matters, he says, let him come back.
I can record my
I have not done any.
So submission.
Let me file my affidavit.
That is his submission. Let him come back.
Wait.
Yes.
But this is the Second August.
The petitioner had purchased 5 trucks.
Let's give you a minute, please. I'll just take the file. Who is appearing for the respondents, Mr. Debra?
But he had purchased 5 trucks from a bank to ply, my lord, and then he applied for a registration with the RTA Kamlu. The disclaimer was issued, but somebody made some complaint and the RTA is not willing to register. He says, bring an order from the court. But kindly come to page 66. The disclaimer certificates in respect of the said trucks. And we have already paid the fees also. 43,000, that will be from page 70. Disclaimer has been issued. That certificate shows that there is no other claimant, and we have paid the fees on the same date also, my lord. 12th of June 2023, 43,982 for each of the trucks. 5 trucks.
Where is the amount stated?
My lord, the page 70 kindly comes the below grand total
Right, yes.
in respect to all the 5 trucks, my lord. I don't know why there was
Yes, Mr. Debra.
Some complaint was received. That is why, Mala, with only now, Mala, I had a talk with the secretary, Mala. They have now allowed.
they wanted an order from the court. He is afraid.
So now no court order
No,
is
they are
necessary.
now agreed to.
So let this be adjourned for some time, please.
My lord, let there be a
Pass
direction.
an order. Lordship pass an order directing the registering authority to register. After complaints, all the nations.
No, we have after
Absolutely,
the
Lords, after the payment of the prescribed fees, my lord, nothing remains. এটা কিছু লিখতে হবে। হ্যাঁ, ঠিক আছে।
It is contended on behalf of the petitioner that the petitioner purchased five trucks.
5 trucks, my lord.
5 trucks
Page 15, my lord, the sale letters are there.
from the authorized dealer. And the trucks, they are still hypothecated.
Yes, my lord, we are paying the installments to the bank
are
also.
hypothecated to the HDFC Bank Limited. Stop. The petitioners approached the respondent authority for registration of the trucks.
After the fragmentation of the,
Upon payment of requisite fees,
my lord,
which was turned down by the authority without assigning any valid reasons.
my lord,
No reason was assigned. The petitioner prays for a direction upon the authority to cause registration of the vehicles in his favor.
Some
in
complaint has been
accordance-
received, my lord.
Yes.
Some complaint has been received, but thereafter we have,
I'll record your
we
submission.
we have
I'll record
inquired
your
into that. There are-
I'll
now
record
you
your
are-
submission. In accordance with law. Paragraph, it is submitted on behalf of the respondents that registration of the vehicles of the petitioner was halted due to some complaint received by the authority. Stop, the complaint has been inquired into and the authority has agreed to cause registration of the vehicles in favor of the petitioner. Paragraph, in view of the above, nothing further remains to be adjudicated in the writ petition. The paragraph, the writ petition is accordingly disposed of, directing the
Registering authority Purva Medipur.
respondent number
my lord, 2.
2.
Registering Transport Authority, Purva
না, না,
Medipur.
registering authority আছে?
RTO, 4.
RTO,
4.
4.
The fourth respondent to cause registration of the vehicles of the petitioner and issue certificate of registration in the name of the petitioner within 2 weeks.
My lord.
Within 2 weeks from the date of communication of this order, subject to the petitioner complying with all necessary formalities.
But the parties will act on server copies of the,
Get it by tomorrow.
my lord.
Disposed of? Disposed of বলেছি কোথায় আমরা আগে দেখে নেবো তো? দুবার বলবেন না। No order is to cause আর ওই চারটে লাইন থাকবে। Since no affidavit, registered by the
Development.
Grateful, my lord.
Next.
এটা আবার কি?
My lord, I have filed one CAN application for intervention.
Now, all these matters, application are filed long back. No copy is served upon a still date.
My lord, I am unable to contact with my learned friend. On the 2nd August, previous matter was,
Court every day. Why are you unable to contact?
my lord,
Please serve here and now.
my lord, I will serve in a course of a day. I am undertaking, my lord. আপনাকে আমি এক্ষুনি দিয়ে দিচ্ছি।
Received a copy?
No, I have not received.
আজকে কপি এক্ষুনি সার্ভ করে দিচ্ছি।
আরে এরকম করে অপোজিট মানে কি হয়? সব পুরো আজকে
না কপি আমি সার্ভ করে দিচ্ছি।
new policy. Yeah, that after a now new policy.
My lord, never. I always want.
New orders. He's not happy with the earlier orders.
No, my lord. I am not paying for any change in the terms of the order, my lord. I'm just tracing the facts, my lord. That's
Dragging unnecessary.
my lord. When
You're not asking for a change.
my lord, I'm not pressing for change, my lord. When the division bench order came, I placed before your lordship. The order term remains the same, my lord. Just the facts needed to be informed to the honorable court. That's the main thing, my lord.
Division bench is different way.
No, that thing has to
The
be informed before the honorable court.
Undertakes to serve copy of the intervention application upon both the parties to the writ petition in course of this day. Paragraph, let the matter appear under the same heading on 18th August.
Lordship, yes, similar matter was taken up yesterday, your lordship fixed the matter on 14th.
14th?
Yes,
You
your
want to
lordship.
come back on 14th? What the 14th? code?
14th तारीख को yes.
My lord, four matters, my lord, 189, 190, 191, and 192.
You are appearing all the matters in all the
These five
matters?
matters I'm happening, your lordship.
188 to 192.
Mr. Debra in all these matters?
189, 188,
I'll call one by one. Act as a-
190 and 90. Censor attempt.
189,
My lord, I'm for
Same
the
order.
petition, I'm for the petition.
intervention applications in all the matters?
No.
None of them copy as.
Mr. Sinha, in all these matters, you filed
My lord, my lord.
applications?
Sir, आपने कौन सा मामला है? 189?
189 or 192?
Same order.
188, 189, 192.
कब रखा? कब रखा?
14 तारीख.
I'm for the petitioner.
Same order.
I'm for the petitioner.
Same order.
Daga.
Wait for me.
Well, I'm appearing on behalf of the petitioner.
Well, I am for the private respondent number 14.
Mr. Debra Junior ঘুমিয়ে পড়েছে বলে।
Well, every service man.
নেই কোথাও? Sure. আমি মনে হচ্ছে দেখেছি।
Respondents?
Served to all the respondents. I have served to all the respondents.
You are
I am for the respondent of 14. Against whom the all allegations are there.
Well, accept my lord, respond number 15, but the service returned back. Not found.
Please serve and come back.
Matter is, everything is same, everything is same.
15, serve and come back.
15.
Serve 15 and come back.
Well, this matter can easily be subject to kind sanction of my
same
learned
issue.
senior.
But I kindly I shall satisfy, same issue. Well, I'm placing this matter.
It can be sent it back to the
Well,
authority.
kindly see
decide
that
the
page number 21. Well, we are holding a permanent, my lord, stage case permit.
Who is appearing for the state?
Yeah, my lord.
Page number 21.
21.
Yes.
We are holding a permanent stage case permit on the route, my lord, Malda, Gourkonda bus terminus to Ses road.
Yes.
Well, this my lord, intra-regional route. Well, this route, my lord, within the territorial jurisdiction of the same district. Same district. And my next page, page number 25. The second petitioner,
Yes.
that route, my lord, Malda to Bamuntola. This route is covered by two regions, but countersign said is here. Man, we are the valid permit holder. Man, our allegation against the my lord, private respondent number 8 to 16. Their permit was issued by the regional transport authority Murshidabad. But according to 69, application was made to the region where the major portion falls. And major portion falls within the territorial jurisdiction of RT Murshidabad. Accordingly, the application was made before the RT Murshidabad, and the decision was taken for grant of permit. But according to Rule 103, if any route is covered more than two regions, before grant of permit, both the region will sit together and will take decisions. Here in this case, without compliance 103 and also section 88, my permit will not be valid to the other region unless the permit is countersigned. Decision has been taken for grant of permit. Accordingly, permit was granted. After grant of permit, the permit holder, that is respondent number 8 to 16, started to ply the vehicle up to the Malda because the permit up to Malda. So, my lord, then my lord, some existing operator of the operator who got obtained the permit in the district of Malda, they raised the objection. Therefrom, my lord, district magistrate, can you see the page number 45. 45. 45. Page number 45, relevant portion. Relevant portion, my lord, page number 68. 45, my lord, that the board meeting held on 20
Page number
March.
68.
For 68. Agenda number 8, capital B, capital B. Prayer for NOC. A letter has been received, fight memo such and such dated 30th August 2022 of the chairman RTA and district magistrate Murshidabad for obtaining NOC in regard of stage carriage permit register. But district magistrate, being the chairman of the RT board, Murshidabad, well, issued a notice letter to the chairman of the Malda to issue NOC. That money letter was placed before the RT board meeting held on 22nd March 2023. Now, kindly left side decision. The decision to be taken in the next RT board meeting, whether NOC will be issued or not. And all the owners, all the permit holder names has been recorded 1 to 10. Their permit was issued by the RT Murshidabad and route has also been mentioned. That means in this board meeting held on page 45, 22nd March 2023, that decision will be taken in the next board meeting, whether decision will be taken or not. Now, kindly say page number 70.
Yes.
The secretary at Malda issued a notice to appear all the secretary of the association, Malda as well as Murshidabad, on the issue of connection of class of free timetable. And also other 9 operators who obtained the permit from the Malda, from Murshidabad. They have been called in the meeting. The meeting will be held on 26th May 2023.
Yes.
Kindly see the next page, page number 71. In terms of this notice, hearing was taken on 26th May, page number 71, Annex P5. The decision was taken, and next resolution, that is column number 1, serial number 1 and 5. Murshidabad district bus owners will return back their buses from Malda with immediate effect. Because, my lord, the permit cannot be valid to the other unless the permit is countersigned. Unless the permit is countersigned, that permit holder is not entitled to fly the vehicle within the territorial jurisdiction of RT Malda. For this reason, my lord, Murshidabad district has RTA Malda has decided all this vehicle which was issued by the RT Murshidabad will take return back with immediate effect. Serial number 5, regarding the new permit issued by RT Murshidabad, not obtaining 13 numbers of NOC from Malda, memo dated 1013 MB dated 30th August 2022 of the chairman Murshidabad will be granted subject to approval at the board Malda. Well, meeting has not been yet held. Well, in next board meeting, whether the NOC will be issued or not, that decision will be taken in the next meeting. Then kindly see next page number 74. An objection was submitted before the district magistrate Malda by the petitioner that not to allow any vehicle to ply in the district of Malda unless the permit is countersigned, and requested to stop the flying of the vehicle. But that representative will be considered. At the same time, followed the respondent number 8 to 16, unless the permit is countersigned. Whether, my lord, how this rectification will be clarified, I don't know. Because law says if any route is covered by to reject before grant of permit, that means no amount of passage of time can cure this illegality, but unless the, my lord, this decision is taken in time. So for this reason, my lord, already, my lord, request of the district chairman of the RT Murshidabad will be decided in the next board meeting. Till date, my lord, after 30th of March, 22nd March 2020, no board meeting has been held. In the meantime, my lord, the permit holder who has been obtained the permit from the RT Murshidabad, they will not be allowed to fly in the district of Malda. And at the same time, my objection, which has been annexed in the representative page number 74, that will consider in accordance with the law. Because my LHR requested not to fly in the district of Murshidabad, the Malda. Page number 75 at the last paragraph. In this, I request you not to take steps to stop flying the above mentioned vehicles.
In Malda.
In the Majinta. But they can fly in their own regions. Murshidabad and Omar. Unless the malord that it is rectified on 100, as per rule 103, they cannot fly in the Murshidabad district, in the Malda.
And my lord, section rule 103, it is also stated that where I am pray for the permission that I can run my bus or vehicle from one place to another, it is the duty of that particular authority to send it to the another region where the next RTO is. Well, this is a totally ego problem, my lord.
When after 2 years,
Boli dada,
permit is issued in that.
Before
gone to 100.
Well, there is a ego problem between the Malda RTO and the Murshidabad RTO. Same thing is happening. Those who are starting from Malda and ended up to the Murshidabad, there also permission is not granting. Because I have one document, my lord, of the record, I can show your lordship by saying just a note and why they are.
But this board meeting says that we will grant, you also grant.
Yes.
There is.
And my lord, most of the buses, most of the vehicles are not at all running. The 8 to 16 and 9 to 16, the private respondents are concerned. So far, 14 is my client is concerned, my lord. He is not at all running the bus.
71, page 71 says the same.
Yes, sir, lordship. I have seen, ma'am. I have seen. But board meeting with subject to kind sanction will not fulfill the purpose because of this ego problem. This is the
There has
best.
to be a joint conference, sir.
Well, we are ready because they are suffering. My learned senior friends, clients are suffering due to some clashing of two vehicles. But for that very reason, we have stopped because they are all our brothers. But the problem or ego is between the authorities. It is not within us. Let the direction may be given to them to say, we are ready to face. We don't have any problem.
Murshid has created a problem.
That I don't know. Who has created?
I received the application. We have the duty as per rule. That joint sitting is required.
103.
Yes.
We sit in a joint conference and then decide. And they'll take into consideration your representation also.
Yes, but unless that, my lord, they will not fly in the
No, that cannot, my lord. For due to the fault on the part of the authority.
Without countersignal permit, section 80. The permit will not valid to the other.
My lord, why I am saying,
Without countersignature.
my lord, why I am saying, my lord, I may not run up to Malda. I may not run up to Malda. Before Malda, I can run, my lord.
To run within your district.
Yes, that liberty, my lord. My lord, no, what my learned senior is submitting, I cannot run my.
Malda.
That subject to kind. I may be wrongly understood.
Yes.
I may be wrongly understood, my lord.
The petitioner has no concern with your
Time limit, yes, your lordship.
Yes.
Because we are also facing losses, my lord.
Thank you.
Affidavit of service. Third learned counsels for the parties. The petitioners are holders of permanent stage carriage permits. In the intra-regional route, Malda Kourkonna bus terminus to Shesh Road, SHESH ROAD. One is intra-regional, the second.
Yeah, we have counted. Yes, we have verified inter-region.
And inter-regional route.
One intra and then second permit
Second is
inter-regional.
Second intra, yes.
Inter-region.
Route from Malda to Bamangola.
Yes.
Route from Malda to Bamangola. Stop. The Regional Transport Authority Murshidabad granted stage carriage permits in favor of the private respondents in inter-regional routes. comma, major portion of which falls in the district of Murshidabad and the remaining portion in the district of Malda. In granting such Malda, without compliance of Rule 103 of the West Bengal Motor Vehicles Rules 1989. No joint conference was held by the authorities of Murshidabad and Malda prior to issuance of permits in favor of the private respondents. The chairman, RTA and district magistrate, Murshidabad issued a letter to the chairman, Regional Transport Authority, Malda, for issuance of no objection certificate in respect of the permits issued in favor of the private respondents. And in a board meeting, and in a resolution, taken. This is a corrigendum of proceeding of the board meeting.
Yes, your lordship. Corrigendum of board.
Resolution na kore, and in the corrigendum of proceeding of the board meeting held on 26th May 2023,
This is not the board meeting. Secretary,
corrigendum of proceeding of the meeting.
26 it's a meeting proceeding held by secretary.
Page 71.
Page
71.
71.
It is not the board meeting. This has been taken by the secretary.
It's a corrigendum of proceeding of the meeting.
Corrigendum of proceeding. Proceeding. But it is not the RT board meeting. It's RT board meeting.
And you know,
Both parties are directed to appear.
Decided the next board meeting. Decided the next board meeting. Board meeting.
Paragraph 5, my lord, is clear, my lord. That is to be decided on the next board meeting.
I approval of that.
Without corrigendum, how the decision can be taken? Is it definitely corrigendum?
No, corrigendum.
Corrigendum to must. Now like you decision.
and in a corrigendum of proceeding of the meeting held on 26th May 2023, the secretary RTA Malda, RTA Malda recorded that NOC shall be granted subject to the approval of the RTA board Malda and the RTA Murshidabad shall also grant the same number of NOC for counter signature in the event any applicant of Malda district applied for new inter-district stage carriage permit between Malda and Murshidabad in future, without imposing any condition. the petitioners submitted a representation before the concerned authority
Hearing
requesting necessary steps to stop plying of the vehicles of the private respondents in the region of Malda.
আছে তো সবার এই দুটো আছে কিনা দেখতো
হোসেন আর উল্লেহার বিধি
ও নিচুই
8 থেকে 11 বল
8 থেকে 11 বলেছে
In violation of Rule 103 of the 1989 rules.
And also section 88. Permit not valid to the other region unless the permit is outside.
881
80
In,
subsection 1.
as well as Section 88 of the Motor Vehicles Act.
Subsection 1.
16
Section 88 within bracket 1 of the Motor Vehicles Rules,
তোর 11
Motor Vehicles Act 1988.
14 পরে 11 তাহলে 12 আছে
Paragraph upon consideration of the
12
no, it is submitted on behalf of the private respondents, paragraph that the private respondents are also suffering loss due to
12 13 আমি 8 থেকে 11
non-issuance of
15 16 আছে
no objection certificate by the concerned authority in their favor. Paragraph, it is submitted on behalf of the state respondents that who should be directed?
my lord
Both the authorities should be directed actually.
yes both of them my lord to sit together and decide the issue yes both the RTOs RTA
Respondent numbers?
my lord
respondent number 2
This one 2
5
Rest number 2 and
2 and 5.
yes,
2 and 5
This one 2 and 5. This one 2 and 5.
That respondent numbers 2 and 5 be directed to settle the issue in accordance with law. Paragraph, in view of the above, the writ petition is disposed of, directing respondent numbers 2 and 5 to comply with the provision laid down under Rule 103 of the West Bengal Motor Vehicles Rules 1989.
একটা মুর্শিদাবাদ আছে 8টা মুর্শিদাবাদ আছে আর 9-10 বহরমপুর আছে
really
Unless the permit legalized.
no
they
no
can find the-
এই মামলাগুলো করা বেশ সুবিধা ভালো কথা এবং
For regularization of the permits issued in favor of the private respondents and also take into consideration the representation submitted by the petitioners in this regard on
কাকে দিয়েছে
what is the date of your representation?
Page number 74.
my representation address to the Malda
Malda, yes.
the loss of selling pass
Authorities are considering.
Yes.
Both the authorities.
Yes, yes.
12 June 20. Bash, is it considering?
As well as all interested persons.
All interested. Add করুন, upon affording reasonable.
Within 1 year.
ওই representation বললাম যেখানে। Upon affording reasonable opportunity of hearing to all the interested persons, including the petitioners and the private respondents. From an accordance with law.
Decision communicated within 1 week thereafter. Decision of
Bash,
সব অ্যাকশন হলে হবে নাকি?
ওই ওটা করে দেবেন তারপরে that decision taken by the authority
না,
shall
ও
be
গন্ডগোল হয়ে যাবে।
communicated to the
হয়ে যাবে না দেখা যাবে।
interested persons within a week thereafter. To the interested persons, within a week thereafter.
The problem may be resolved because the passengers are also suffering, owners are also suffering, my lord. I'm grateful, your lordship.
Hearing matter.
Chief Justice.
Other matter. Well, other matter.
Yes, Session Gupta, you'll continue. You'll continue. Release for the day. Other matters release for.
হ্যাঁ আজকে দেবো আজ তোমাকে তুমি কালকে করে রেডি হয়ে বলবো
Mr. Sengupta has assured me that I don't need to open my mouth today.
With Mr. Sengupta in court, I don't think anyone needs to open their mouth. Yes,
I think well, this is an innuendo.
this is an
Innuendo. I think that is not.
yes.
জানে না
But I am very proud to be associated with him. His son is the youngest FRCS.
MRCS.
MRCS.
Oh, congratulations. That's great.
Very brilliant.
একটা প্রশ্ন আছে, ওর ছেলে এরকম কি করে হলো?
My family, well, we actually, I have come from doctor's family. My 4 uncles are doctors. My elder brothers are doctors.
It's good that you have not chosen that profession. I would have pitied your patience.
He has got one similarity with the Paja family. Except Mr. Ajit Paja, everybody of their family are doctors.
Yes.
So তোমার ওর সাথে বিয়ে আছে।
God knows whom to put in which profession.
Everything allotted.
Everything.
Allotted, yes. Due to grace of.
I should not have come this professor. None is there, first generation.
No, but patients are saved.
Oh. Had.
Yes, continue.
Well, the 4 points I am making. First point, my lord, I have already asked that if there is a palpable errors committed by the honorable court, my lord can exercise my lord's inherent power and rectify the same. Because at that point of time, it is totally the recording of the observation of the honorable court, honorable judge at that point of time was totally contrary to the record. Number 1. Even number 2, my lord, that for reviewing if this power inheres in my lord, for that order 47 rule 1 is not at all applicable. If my lord, whether my lord can exercise my lord's inherent power or not, that is my lord's discretion. But my humble submission would be, my lord, this is to correct the grave or patent error committed by the honorable court. My lord, correct the injustice which was done to the state, my lord. My lord, first, my lord, that third, my lord, that so far the facts are concerned, my lord, my submission would be 9(3)(b), because admitted fact that 4(1)(a) of Act 2 was issued at that point of time. I say that this vesting has been saved by dint of amendment which was carried out in the Act 1 by introducing 9(3)(b). I should say, because 4(1)(a), 9(3)(b), if 4(1)(a) was not issued, 9(3)(a). My lord, at this juncture, my lord, I should point out, my lord, there is a larger than judgment presided over by the Honorable Then Justice Bhaskar Bhattacharya. The larger bench held that taking into account of 7(a) of Act 2, when admittedly that act was not subsisting and amendment has been taken place by that point of time when my lords were taking up these or going into consideration of those nitty-gritty of the laws. My lord, there the Honorable larger bench held there was a diversion of opinion of two Honorable Division Bench, and that's why larger bench was constituted. And my lord, the Honorable Division Bench, the larger bench held that 9(3)(b) is not applicable. So far, Section 4(1)(a), if it was issued at that point of time when that Penpore Act was there or subsisting. Why? Because the larger bench had taken into account of 7(a) of Act 2, but not taken into consideration of the 9(3)(b). There I join issue, my lord, that so far 9(3)(b) is concerned, larger bench held no, you can convert it to 9(3)(a) of the Act 1. But 9(3)(b) is not at all applicable. Taking into consideration again at the cost of repetition, 7(a) or capital A of Act 2. Now, my kindly consider first, my lord, let us আমার বইটা তো চুরি করে দিচ্ছে তোমাকে বই চুরি করে চুরি হয় বই চুরি অমিত দা তো রেগে যাচ্ছে কেন বলে তুমি এত রেগে যাচ্ছ কেন আমার বই চুরিটা কবে চুরি হবে আবার হ্যাঁ রেগে যাচ্ছ My lord, admittedly, my lord, that I have been reviewed by my senior. My lord, admitted fact, the temporary act which expired on 31st March 1997. So far, Act 2 is concerned. My lord, now kindly, I will go back into the larger bench judgment. Before that, my lord, kindly apply my lord's mind. So far, 7(a) is concerned of the statute. 7(a). My lord has already, I have pointed out Section 4(1)(a) that state government may acquire any land requisition under Section 3 by publishing notice in the soft land is required by law. Where a notice as aforesaid is published in the official gazette, the requisition land shall, on from the beginning of the day on which the notice is so published, vest absolutely in the state government free from all incumbents, and the period of requisition of such land shall end. Now, my lord, kindly come to 7(a), capital A, because larger bench had taken into consideration of 7(a) and held that 9(3)(b) is not applicable because the award, if you do not pass an award within a time frame as fixed in that award goes, that vesting goes. My submission would be this is totally I should say, my lord, is the par uncuriam. It is held to par uncuriam. This is contrary to statute. That I will demonstrate. Well, 7A first.
Of the 1894 Act.
Larger bench judgment. Well, I will show, my lord, that judgment. Before that, my lord, I am placing the relevant law at that point of time. Act 2. Act 2. Yes. Award by collector. My lord, got it. 7 capital A. 1948. Act 2, my lord. It expired on 31st March 1997.
Yes.
Well, 7 capital A. Well, kindly see. Collector shall make an award under subsection 2 of section 7 within a period of 3 years. That is important. That was taken into account by the Honorable Larger. 3 years from the date of publication of the notice in the official gazette under subsection 1A of section 4, as in referred said notice, and if such award is not made within the period of service, said notice shall lapse. That means notice under section 4(1)(a), which was invoked at that point, if the award be not passed within the period mentioned in the 7A statute, then vesting goes. Notice goes. Then means notice goes means they are saying that vesting goes. Impliedly, they are saying. My lord, provided that in a case where said notice has been published more than 2 years before the commencement of the West Bengal Land Acquisition Amendment 1994, the award shall be made within a period of 1 year from the date of commencement of the attack. So, my lord, explanation I don't think it is required, because this is the computation period within which period if the award be not passed, whether acquisition lapse or not, or vesting will go or not, my lord, that is prescribed in the statute as per the larger bench judgment. My lord, my submission would be, at that point of time, when the larger bench had taken into account of 7A, holding that the award in that, so for that factor concerns, awards were not passed within the period. That's why everything goes. So you can invoke 9(3)(a), but not 9(3)(b). My submission would be, my lord, how the honorable judges had that how the honorable could look into a provisions which if I may permit to use that word, that to ride on a dead horse. My lord, there is no existence of that law. How, suppose, my lord, it admittedly, it expired on 31st March 1997. So after any proceeding be considered by the honorable judges, whether, my submission would be, whether the honorable judges can look into a section which was not at all there. So, and, my lord, considering the saving clause in 9(3)(b), which is very important. Now let us, my lord, kindly come to 9(3)(b) of the Amendment Act. That is the Act 1, my lord.
Yes.
It is there, my lord, in this. It's there. West Bengal Amendment, my lord, got it? My lord, I am only concerned with 9(3)(b), because admittedly 4(1)(a) was in admitted fact. Collector, my lord, I am saying, I am reading, my lord. My lord, every word in the statute should be looked into. What is the intention? What is the logic behind such framing or introduction of some amendment? This should be taken into account before, my lord, coming to any conclusion over that the sections which was not at all there. whether any intention will be forthcoming on reading of section 9(3)(b) to say that this was saved. 7A was saved. But if my lord reads 9(3)(b), my lord will find the saving is because, my lord, kindly consider, if vesting is done, there is no question of acquisition. So if the 9(3)(b) says in order to acquire, then question would be otherwise. Let us read, my lord, the 9(3)(b). Collector shall also serve a notice to the same effect. My lord, got it?
Yes.
On all such persons known or believed to be interested in any land or to be entitled to act for persons so interested, the possession whereof which has already been taken on requisition under section 3 of the said act, and the notice for acquisition of such land, notice for acquisition of such land has also been published under section 1A of section 4 of the said act. In every case, kindly see, not only that, provisions of section 4, section 5, section 5A, section 6, section 7, section 8, and section 16 of the act shall be deemed to have been complied. Why? First, I am giving explanation why this has been incorporated. Because legislative intention to complete that vesting process. Or if it was not vested, to complete that process. Otherwise, this section 4, 5, my lord, kindly see, there are two modes of acquisition as it will be reflected from the Act 1. One is through section 16 and another is through section 17. There 11 was there. That the period was mentioned. The Honorable 3 judges bench, my lord, at that point of time held that once vesting has been taken place and there is no law in that in the provisions of Act 1, even if no compensation was paid, even if no award was passed, my lord, the vesting has been done and it cannot be divested. And 11A is not applicable relating to such proceedings. So obviously, when the legislature thought it fit to incorporate this section 9(3) and 9(3)(b), it was in the mind of the legislatures that section 16 has to be deemed to be complied with, has to be written, 4, 5, because there is no meaning. If it is not because that means impliedly, or that means that vesting has been given effect to. Now, third, this is important. Provided that the date of publication of the notice under subsection 1A of section 4 shall be the date of reference for the purpose of determining the value of such under this act. Then it is very important. Provided further, my lord, kindly see, each word has got some meaning. In every such case, collector shall make an award under section 11 in respect of such land only for the purpose of payment of due compensation. To the persons, because, my lord, kindly consider, take a point, my lord, kindly consider this is a fine line of difference. Section 16 shall be deemed to have been complied with. That means, even without compensation, award, you have no award can be position compensation, no award can be passed. Section 16 has been done away with. So 17, they have taken into account of 17(1) of Act 1 because it was where the vesting has already been taken. Same analogy had been taken into account by the legislature in framing this law. Why? Because of that, collectors shall make an award under section 11 in respect of such land only for the purpose of payment of due compensation to the person interested in such land has, comma, upon the collector taking possession thereof, comma, already vested absolutely in the government free from all encumbrances. That means the honorable judge's larger bench finding is held to be per incuriam in that regard only to the respect, to the extent, I should say, that the honorable judges had taken into consideration of 7A, which the honorable judge cannot because there is no whisper in the Amendment Act in 93B, 93A, 93B that you have to take further acquisition. 4, 5, 6, 7.
It's the special bench judgment.
Is a special bench judgment. I will show because
But
they will.
the special bench judgment also.
Yes. Special bench judgment, I say, in that regard, to that respect, only in that regard, because special bench judgment held 93B is not applicable, taking into consideration of 7A, but held.
You place the authority.
My lord, I will place because unless I show the relevant statute, my lord, that is better because for learning, for my learning, I am placing. My lord knows that. My lord, only thing, my lord, kindly consider that special bench judgment is held to be per incuriam to the extent in holding that 93B is not applicable, but on the converse, they held that 93A is applicable. I say to that extent 93B is not applicable because of taking into consideration of 7A, which was no longer there. The honorable judges, that part of the judgment are held to be per incuriam. That observation. Why? Because first, it was a dead horse. Nobody can ride upon a dead horse. Amendment, when the matter was taken up, amendment has been taken place, that temporary act goes. So the honorable judges should have taken into consideration of the amendment instead of going into a provision which was no longer there. So my respectful submission would be that vesting, because in the legislative words says that vesting has already been done. You just give compensation and make an award. Now, my lord, this special bench judgment, my lord, I am already preparing that spiral binding because at the end, my lord, I will hand over this judgment. But my lord, this is a voluminous. That's why, my lord, I am handing over. I am handing over, my lord, kindly. I have read, my lord, kindly see, I am reading, then, my lord, I am handing over this judgment.
If you're referring to judgments, please place them.
Yes, judgment, my lord, he knows.
I do not know. Please place it.
My lord, it is reported in, my lord, 2012 AIR Calcutta 47, 2011 3 CHN same 555.
2012 Calcutta.
2012 AIR Calcutta 47. Same, my lord, the judgment has also has been reported in 2011 3 CHN 555 CLJ. My lord, this is the judgment of the larger bench. Presided over by the Honorable Justice Bhaskar Bhattacharya. My lord, here, my lord, I am showing that the relevant part why the honorable judges held.
Judgment দিবি তো জজ স্যার
না জজকে ওই পার্টটা না দেখিয়ে আচ্ছা লাইভে না আমি ওটা জজের জন্য ভাইরালটা করছি মানে দিস ইজ দ্য এই দিকে because unless spiral binding is impossible to, my lord, read.
The relevant paragraphs?
Really? Paragraph, my lord, 23, 20, right now I cannot, because that's, I have handed over, my lord, I have marked.
You have only one copy?
Yes, yes, no, I have no. My lord, I'm sorry. My lord, I am already preparing. দিদি একটু প্যারাগ্রাফটা বলে দিই, তাই জন্যই বলছিলাম যে প্যারাগ্রাফটা বলে দিতে।
Keep it with the decision. How will he refer?
Yes, my lord. With great respect to the, my lord, just paragraph এটা প্যারাগ্রাফ এখানে হচ্ছে 16.
This is the AIR version? Or the CHN?
My lord, this is SCC online. All of NCC online.
So it will not tell you.
My lord, no. My lord, I am handing over this. That's why, my lord. Hey, just like, my lord, may I mark it, my lord? And my lord, can 20, the last two paragraphs, 9(3)(b) is not applicable, 9(3)(a) is applicable. Last.
Yes, yes. Fresh notice to be issued under 3A.
9(3).
Yes.
So, my lord, my humble submission would be, my lord, that once vested cannot be divested unless there is a retrospective operation specific, incorporating the statute itself. Conversely, my lord, on the contrary, statute, the amendment saves that vesting. Only make an award, pay compensation. So, my lord, vesting, and the section says that 16(4)(5). 4 is, my lord, initiation. My lord knows that at the time, my lord, Act 1 was there. Initiation of proceeding under section 4, invoking 4. So, my lord, everything shall be deemed to have been complied. So, legislative wording has to be taken into account. Because why they frame this, they bring this amendment? Because of to complete the vesting process, or if it is not vested, to complete the acquisition process. My lord, now, my lord, kindly. My lord, now kindly, the fact, so far facts are concerned, my lord, I have narrated in my affidavit in opposition. My lord, I have used 2 affidavits in connection with application and in connection with main writ petition. My lord, here, whatever records I have enclosed or annexed, my lord, first, and it was admitted by the respondent, that is the writ petitioner herein, that section 3(1) was issued, section 4(1)(a) was issued, my lord, and their case is, my lord, sad, my lord, the learned senior, my lord, sir, made a submissions based on 2 things. One, he is, my lord, emphasizing on a judgment which was delivered by the then Honorable Single Judge. Number one. Number two, my lord, that on the other matters, so far Rungta's matter, that was not, because Rungta's matter in their supplementary affidavit, they have brought in there also that I have pointed out on the last occasion that the Honorable Single Judge, which who passed this order, solemn order, my lord, only in respect of the DUG number which was mentioned in that order itself, judgment itself. And so far this case is concerned, those DUG numbers are not there. And it went up to appeal, Supreme Court dismissed. However, my lord, there was, my lord, an observation that you can proceed in accordance with law. There my learned senior, my lord, made a submission that you should have proceeded with issuing a section 4, not straightway 9(3) and 9(3)(a) of the Act 1. Number one. Number two, since the Honorable Single Judge at that point of time set aside everything, so entire acquisition proceeding, you have to start with de novo by issuing a notice under section 4(1). And your passing or making an award in the year 2004 is liable to be struck off or held to be illegal. Thereby a joint issue. First of all, if my lord exercise first, my lord, it depends upon if whether my lord will exercise my lord's inherent power to rectify the patent or grave error, which is totally contrary to the records. If my lord exercise my lord's power, then come whether vesting has been taken place or not. If my lord says that yes, vesting has been taken place, then award, they cannot say that award is to be treated as a final. And my lord, so far the Rungta's case, even for argument's sake, my lord, Rungta's case they have brought in their supplementary affidavit and enclosing all those judgments. There, I have pointed out on the last occasion that the DUG numbers are not matching with the DUG numbers. So for this petition circus. Now, my lord, kindly consider one thing. Here, Rungta's case, my lord, that is the supplementary affidavit of the writ petitioner. There also, my lord, the Rungta agency, my lord, got it. Supplementary affidavit, which was issued by which was affirmed on 14th March 2023. My lord, here, my lord, they have এই যে ওরা ওই রুংটার কেসটা ঢুকিয়ে দিয়ে ওইটা দেখাচ্ছে, ওই যে জাজমেন্টটা যেটা দিয়েছে জাতীয় সুপ্রিম কোর্টের। My lord, here, my lord, kindly state at page 19. I have also, I think is a repetition. I should not repeat that. My lord, I think my lord has taken note of it. Page 19. My lord, kindly see the DUG number is there. And others is not there. Kindly DUG number 88, 1308, 1308, 1309, 1308, 3912, 3906, 3907, 39, 3909. And etc. It is not there. So the honorable judge allowed this writ petition, went up to a division bench, lost, appeal, Supreme Court, lost. But that judgment of the Honorable Appellate Court was only specially dismissed. However, the leave was granted to act in accordance with law. And my lord, at that background, because why? 9(3)(b) was not, so far Roongta's case is concerned, I am making a submission. 9(3)(b) was not properly issued. That's why the authority was asked to issue again 9(3)(b). And 9(3)(b) notice was issued subsequently. And this is a challenge before this 9(3)(b) notice was challenged by the writ petitioners herein, also therein, that the Roongta agency is not the writ petitioner here. Writ petitioner, that advocate, honorable, the learned advocate. Learned advocate appearing in this case, also appearing in that case. In Roongta's case, they have challenged the notice under section 3B. And the hearing is going on, and on coming Wednesday, it is scheduled to be, I think, it heard on coming Wednesday at 2 p.m. So
he is talking about the vesting. In that matter, most of the land has been returned to me. He is talking about the vesting.
my lord, why he is so appearance? I just put that question to myself.
Carry on.
If he has got a better case, then my lord, I think everybody, my lord, kindly consider so far Roongta's case, Roongta agency is concerned, it is neither here nor there. 9(3)(b) was issued, that was challenged by the petitioner therein, and the hearing is going on. Whether 9(3)(b) was issued in terms of law or not, that is to be decided there. So this is no way connected with my lord, the plots in question, which is the subject matter on the present writ petition. আরে আমি জানি তোমার ওটা নয়, আমি অন্য জায়গায় বলছি।
That's all.
No, my lord. My lord, I have something to argue because there in the writ petition, here only that number is 845, 846 and 847. My lord will find in my affidavit in opposition, that is page 25 as page 26. That is 9(3) and 4 of Act 1. They are making a contention to that effect because you did not issue a fresh proceeding de novo by issuing section 4 notice. So everything is to be held to be illegal. And based on that judgment, that there was no vesting. And they will rely of the larger bench. That's why I am relying that the larger bench judgment is held to be, some portion of the judgment is held to be parid kuri. This is totally contrary to the law. My lord, kindly come page 25, 84 for my lord, got it? 845, 846
Of your
of my affidavit in opposition. My lord, I have used 2 affidavit, my lord.
yes.
This is in every application for appropriate orders, my lord. In that application, I have already also I have used that affidavit in my lord, affidavit in opposition, that was affirmed on 24th day of March 2023. My lord, got it? Page, my lord, এখানে দুখানা আছে,
Both are reformed on 24th March 2023.
25, page 25 of my affidavit in opposition. Kindly see, my lord, that 9(3) and subsection 3, subsection 4 of 9 of Act 1. Kindly plot in question 845. There are other plots. 845, 846. My lord got it full.
Yes.
My lord got it. And next page, my lord, page 26. 847 part. My lord got it. So these are the plots in question. These are the plots in questions. My lord got it. 847 part. And this 845, 846 full. F full. My lord, they have challenged, they saying this is to be held to be an illegal order because you did not proceed with the section 4 notice, de novo. You have liberty was given to you and you did not proceed with that. So entire thing goes. My lord, now they have already in their writ petition, they have annexed, because that's why one thing, my lord. My lord, kindly come to their writ petition, page 75.
Yes.
My lord got it. Their writ petition, 75. Kindly see Srimati Renu Devi Chaudhuri.
Yes.
845 to 847, Sholop. Sholop is not the, my lord, the Mauja. But I have stated in my opposition, no such records is available so far this record is concerned. I have stated in my opinion opposition. And now, my lord, kindly come the very vital question. What is the writ petition? I just put that question to myself. Whether what they cannot do directly, whether they can do in an indirect way or not. Who can challenge? And though there is a judgment which has been followed by my lord, allowing my dismissing the writ petition, so many writ petition, and I was addressing before my lord, that relates to section issuance of section 4.1 of Act 1. But the analogy is to be applied that subsequent purchaser cannot have any right to challenge the acquisition process. They make a statement, my lord. They made a contention. My sir made a contention that in a way they are the subsequent purchaser. 2020 or something like that. They have purchased. My lord, I will that when it was purchased, my lord, in the year 2022. 2022, these petitioners, they have purchased these lands. My lord, they will make a contention to the effect after in their reply that I am not challenging the acquisition proceeding. Why? Because, yes, answer, because I am making their submission that they will come forward in their reply to say, I am not challenging, subsequent purchasers are not challenging the acquisition proceeding because there is no acquisition proceeding at all. But whether it is an acquisition, the vesting was done, or the 9 section 9.3 subsection 9.4 3 and 4 of section 9 of Act 1 is valid, whether award is valid, that will look into by my lord. Has to be looked into by my lord. Even if I, for argument's sake, assuming but not admitting that the subsequent purchaser, they have filed this instant writ petition saying because there is no acquisition. But whether there is an acquisition or award is rightly made or not, my lord will go into that. So what they cannot directly, they are doing it indirectly. So section 4 my lord knows that even if section 4(1) of Act 1 was issued at that point of time, subsequent purchase is to be deemed to be a void one, as has been held by the, my lord, the in the development, that is the constitutional bench judge. And my lord, that subsequent purchaser 2012, my lord, judgment says, Supreme Court, my lord knows that, my lord has held to it, and my lord against that they preferred an appeal, they lost it. My lord, subsequent purchaser, they have no course, they have got no locus to challenge the acquisition proceeding. So I am drawing the analogy, because if the vesting, my lord, if I say that is vesting has been taken place in terms of law, award was passed long back. If my lord, then my lord will decide whether vesting was correctly done, whether vesting was at all done, whether requisition was at all made, rightfully made, whether award was the subsection 3 and subsection 4 of 9 was correctly done, or the award was correctly passed. This has to be examined by my lord. So in a way, they are challenging the acquisition process, which they cannot do. I am drawing the analogy. There is no such judgment so far this act is concerned, that subsequent purchaser, so far this act is concerned. But my submission will be that subsequent, after in the year 2022, 2004, the award was passed and delayed. 2022, not that they are because 2022 they have purchased, and the award was passed in the year, I think 2004 or something like that, my lord. Just a minute, man. Yes, 30th September 2004. 30/9/2004. And who are the awardee original owners? My lord, is written. Well, why the owners should not come? They should have come. The subsequent, what I mean to submit, subject to my lord's kind approval, what I mean to submit, that they cannot file this application in saying that there is no acquisition proceeding, no vesting, no award. So there is no prohibition, there is no bar. So for challenging this thing, my humble submission would be, you are doing it in indirect way, which you cannot do. Drawing the analogy of section 4 and the judgment being delivered by the Honorable Apex Court, my lord has gone through that several times. That subsequent purchase has got no locus to challenge the acquisition process. I say this is a valid acquisition process, valid vesting, valid award. Only they can say, yes, they are entitled to get compensation with an interest. And my lord, even in a case there, the indoor development and indoor development authority, that is the 5-man bench judgment, after that 3-man bench judgment has taken into consideration by of interpreting of section 24(1). Even the 3-man bench judgment held recently that section 4, the authority issued section 4 of Act 1, that will be continued. Because of section 114 of the 2013 Act, because General Cause Act would be applicable. So award was not passed, no compensation, no possession, only section 4. There the issue was, because by interpreting section 24(1), next day, my lord, I will read that section 24, because indoor development only 24(1), not in an elaborate way, my lord, has been interpreted, but 24(2), yes, has been interpreted. So, my lord, I will show that the repealing of 20, that is Act 1, my lord, doesn't mean that I will not be permitted to continue with the acquisition proceeding which was invoked under the repealed act at that point of time. Their submission was that you have to proceed with the section 11 of Act 2013. It was turned out.
Please continue on
Yes.
the next question.
Next day মানে কি? Next বুধবার।
Next Budhvar.
After 12, I have a circuit bench at Jalpaiguri.
Well, whatever my lord will think. My lord, I will take just 15 minutes time. I will show that judgment and I will leave it to my senior.
Next day the three.
3, my lord. So that, my lord, I can
Lord, I have to what sufferer in.
watch sufferer. 2022 watch
They
sufferer.
are actually constructing the.
3:30, next day.
Next day, but 3:30.
August.
16th August,
16th August, 3:30.
it's a Wednesday, 3:30. Her learned counsel for the state respondents. Paragraph, let the matter appear under the same heading for further consideration on 16th August, marked at 3:30 PM.
Obliged.
এগুলো সব না।
Great.
Yes. বইটা এটা ফেরত দিন। দুটো। এই যে বলছি নাম দুটো
এই
delete না
দিদি,
করেন, miss
আমার
করে
একটা
আছে
যে
জানেন।